I seek permission.
Yes. After come, after next. Yes, sir.
Well,
With your lordship's kind permission.
Next, yes, sir, just yes.
Next bench. This is a different bench. So yes. Lordship, government was supposed
Government,
to.
yes, have you got some?
Yes, well, in fact, on 19th, my lord, he has been sent to that mental hospital, my lord. He is undergoing treatment.
So you have made provisions for keeping him, no,
Yes,
in a
he
mental.
can fill that document.
Okay, very well.
With the coffee.
From 19/1/2023, my lord, he is undergoing treatment.
So keep him there till so long as required.
Exactly, my lord.
Huh?
My lord will close it with an observation that, my lord, as and when it is required, my lord, necessary arrangement will be made. In future also, my lord, there may be some requirement.
See, in 23(1), with reference, I would like to inform that if the LGB fixes a date for accommodation in district jail, inform the according will provide necessary escort to convict as per procedure up to hospital.
In fact, before that, my lord, on 19th, my lord, this is the second document, my lord, common certificate. He was sent by the district jail authority, my lord. And my lord, the other document from the SP, sorry, my lord, district jail authority, it is today, my lord, dated 25/1. Just now I have received.
Yes, I have known since I have been undergoing treatment.
So they have arranged from the jail authorities, my lord, not from the superintendent police.
Okay.
That is escort party, Lordship. But
See, one jail warden deputed so attendant and a team of police escort parties also there. The escort party security, but it doesn't say anything.
yes,
We want a specific that why escort
He
party?
is undergoing treatment since 19/1, and this escort party has been deputed, my lord.
Why escort party? Why you spend so much of time and money in that?
only one person will be required.
Why one
Lordship.
person? Why you the entire
No, my
team?
lord, though the word used is escort party, my lord, kindly see the common certificate. Only one person has been
You
sent.
know, we please, draft your letter in such a manner that we can dispose it of. You advise them that we'll keep in the hospital as long as it is required, for which necessary security
Yes,
will provide. That's all.
yes. Escort, it means Lordship.
Escort me again will be escorted and again come back. That we want to avoid, not only because the inconvenience, you are rich state government, so we don't mind, do whatever you want. But then this person, he has to be constantly back for, from that is, that may again may not be helpful to the treatment.
Exactly.
So he would like a continuous treatment to
Exactly.
be undertaken.
Exactly.
Once you say that, yes, now he maybe you can come after 2 months, then it's okay. We have given a proper treatment now. He will be under observation and he can be brought after 1 month, 2 months, then okay, fine.
Yes.
My lord,
So-
may I indicate one thing, my lord? Instead of what uses escort party, my lord, we'll see the common certificate. Only one person.
No,
will
no,
have
please,
deputed.
please,
Yes, escort party.
make
police
it
escort
you,
party.
you have understood what we have
Yes.
indicated to you. You please call your official, this is the one we want. If they can give that very well, otherwise, see, this is not very clear. We don't want to see Mr. C. Goswami. We don't want to pass an order as if we are dictating to you.
In fact, my
We
lord,
can do that. If you
will be
leave
more
that,
helpful for us, my lord.
we want to avoid that. If you compel us, we'll do that. But we are asking that this is from your side, because then you will understand. Otherwise, you'll say, oh, court has directed. No, we can do that if you want. If you have any express difficulty, we'll pass the
My
order.
lord may record my under
Oh,
my lord, that
Mr.
we'll
Mr.
feed him as far as his treatment is required, my lord. That is my undertaking, that let be an order to that effect, my lord.
Okay, then in that
You
case.
can cut it short, my lord.
Because escort won't do. Escort
Okay.
means what, Lordship? Taking and
Correct,
bringing.
correct.
We need a person there.
Ms. Smita Majumdar counsel for the applicant. Sorry, I'm amicus, I think amicus.
Yes,
Amicus.
Here I said the as petitioner,
Yes,
Lordship.
correct.
I
No,
was
correct, we are
independent.
amicus and also Mr. Prangan Goswami Lana, additional from state. We had, on the last occasion, we had desired from the state government as to the provision for making necessary arrangement to be provided for keeping the convict in the LGB Regional Institute of Mental Health Tezpur for undergoing treatment, for which the hospital, the institute has also recommended that he requires to be kept, has been request to be treated as an inpatient, inpatient, which obviously which necessarily will require his stay in the institute. Considering the fact that frequent transfer of the convict from the jail to the institute located in another district may not be advisable, we had requested the learned additional advocate general to take instruction in this regard, and on today he has produced before us certain letters written by the superintendent of district jail, North Lakhimpur, as well as the superintendent of police Lakhimpur, for providing necessary and adequate police escort party for escort / security point of view.
One jail warder has already
As per the letter dated 25 January 2023 from the superintendent of district jail, North Lakhimpur, it has been mentioned that one jail warder has been deputed at LGB Regional Institute of Mental Health Tezpur as an attendant of the convict, and a team of police escort party from the superintendent police Lakhimpur also is there at an institute for escort / security point of view. Full stop. Though it appears that the said letter also mentions that the convict had been undergoing treatment since 19/1/2023. Full stop. Though it appears that the state government has taken necessary steps in this regard for proper treatment of the convict, we would expect that the convict may be allowed to remain in the LGB Regional Institute of Mental Health so long as his presence is required by the hospital authorities, and the district as well as jail authorities will provide necessary security for the purpose as may be required by the institute in this regard. Mr. P.N. Goswami, additional advocate, also submits that the convict patient will not be made to undergo frequent travel, and he will be allowed to remain in the institute so long as the institute requires full stop, as inpatient, inpatient, full stop. In view of the above submission made, and in view of the submission and the letters which have been produced before us, we close this application with permission. First of all, Ms. First of we express our appreciation of the service rendered by Ms. R.D. Mozumdar in assisting us for the welfare of the convict, who is apparently suffering from certain mental illness, and would will expect Ms. Goswami to continue to render the assistance to us as and when she may bring to us, and she would be liberty to bring before us to the notice of this court as and when. Mozumdar, sorry. And we will, sorry. Sometimes Shakespeare says, no, what is there in the name? So I see you, okay, sometimes name keeps changing, you know.
The party
Sorry. And we'll appreciate Ms. Mozumdar to that they would continue to assist this court, and also and bring to the notice of this court about the condition of the said convict as and when it is necessary.
But I won't know, Lordship.
For which.
Okay.
4 weeks. the district and district legal service authorities of Tezpur,
Not looking.
Lakhimpur. No, it is the in Tezpur. Tezpur is
Hospital, the institute.
Tezpur will be which district?
Sonitpur.
Sonitpur. So both, that the district legal service authority of Sonitpur as well as district legal service of Lakhimpur,
Not looking.
not Lakhimpur, will apprise Ms. R.D. Majumdar of any requirement full stop. The secretaries of the aforesaid two district legal service will remain in touch with the aforesaid convict and the jail authorities to ascertain if the said convict requires any legal assistance, and if so, they will immediately inform Ms. R.D. Majumdar for doing the needful.
I'm highly obliged.
R.D. Majumdar may be given the honorarium
No,
as per rules.
no,
We direct that the
No,
registry shall provide, though Ms. Aruna has expressed expressed that she would render her service pro bono, we insist on making some payment of honorarium for the service rendered by her.
no, Lordship, this is, he has mental, Lordship, no, not in this case, Lordship. Lordship may give in any other case,
Okay.
no problem. Not here, Lordship.
Okay.
Highest stands closed, man.
I speak. We also put on record the assistance rendered by Mr. P.N. Goswami, Learned Advocate General, in assisting us in this application, in this case.
I'm all right.
Highly
Your
obliged.
records beyond always document that's on record. Will form part of the record. Will come.
Your
We'll take
Lordships,
it.
here I am an outstation counsel and I. have
91,
flights back.
don't worry about 91. It will come up.
I am also appearing.
Flights back at 4.
We expect that it will come up within 90 minutes. So you can wait. 90 minutes, 91, na? We expect it will come up within 90 minutes.
I'm great.
Yes.
Wait, please, Lord.
Yes.
But it is a surfacing matter. My house is, residential house is put on action day after tomorrow, my lord. Urgent application, my lord.
Put an auction. So let him auction. They will not implement it. What to do? Day after tomorrow. Tomorrow is a 26 January. We can't hold court for you.
My lord.
So
Okay, my lord,
let
my
him be put on. Let them auction. They are not going to do anything.
I'll be on street, my lord.
What street?
God, my lord, they want money and I'm
Okay.
ready to pay, my lord. I need some time only, my lord. There's no other thing, my lord.
Okay, 27, na?
But today, my lord.
Today.
Today, my lord. There's no other option, my lord.
Once it auction, immediately you are out.
My lord.
Huh? Is it like that?
Third party will come in, my lord.
They are already coming.
My lord.
Third party. When the moment this hammer goes down, you are out. I don't know. What is the practice here?
By, my lord, the
Why the third party will come take his own time. He said, oh, now I got where in Kharguli, top hilltop, where? Some palace, some.
Well, today may be taken, my lord. I don't have.
Have to be effective.
Huh? The
Sale will
sale,
have to be effective
sale has
after
to be
that.
effective. He just can't come.
Certificate will have to be
Just
issued.
because the hammer has gone down, he will come rushing unless it's a very valuable.
Third party individual generate, my
Third
lord.
party doesn't matter. Third party, whatever we can.
When was it notified for auction?
My lord.
When was it put up for auction?
No, auction notices come in the last part of December, my lord. I was negotiating with the bank. My lord, I am ready to pay, my lord. I'm not
Correct.
challenging it any manner, my lord. 1 month's time I want, my lord, I'll pay. my
Doesn't
lord.
matter in any event. Once auction is done and auction is done, we can't put on. But
It's not done, my lord. But kindly consider today, my lord.
how can we put on hold? The bank has spent so much of money, time for auctioning. We are not saying that we'll allow that. Let them do whatever they want. We'll see.
My lord, on 27, my lord, then.
27.
Okay.
Yes.
Wait, please, Lordship. I seek on behalf of Senior Counsel, Mr. Partheep Kumar Goswami, I seek permission to move 2 matters through virtual mode, fixed matters on 27. There is a procedure of seeking permission, Lordship.
Virtual mode. Okay.
These matters are fixed on 27.
27, motion matters. On earlier occasions.
It's fixed.
Fixed matter. On earlier occasions, it was moved through physical mode only for today, the 27th, Lord. Due to personal difficulty, he could not come.
We'll see if the internet works properly or not. You take your chance. If we can't hear properly, then you go. And we have to see not only here, but both audio and video must be there. We will not accept any, we will not entertain any plea without the video. Please make it sure. Your audio and video must be clear to entertain any such plea. Okay, you take that. If for some reason the video goes, we will not hear. We are not going to ascertain whose voice is this. We are not going to send to forensic laboratory to ascertain. But if the video is there, will be satisfied. Prime Minister, he is the okay.
Deeply.
Yes.
May I please, Lordship?
Yes, yes.
With the function of the respondent side, Lordship, item number 35.
Please wait. Yes,
And,
please wait.
sorry.
Yes.
The consent of the other side.
Please wait.
My lord,
All consents among your party, but
I have a difficulty. My lord.
by no problem. There's so many friends. You don't have any friend in this
No,
bar.
not that, my
You
lord.
ask somebody. There's so many
No,
people are waiting. You can ask.
Not that, my lord. My lord, item number 3, I received the records today. my
Whatever
lord.
it is, no problem. We'll pass the order. We have to pass some orders. Some orders has to be passed. Yes.
May please, your lordship. Yesterday I mentioned 2 writ appeal, my lord, for listing today. One has come, my lord, one has not, one
What
is
is
not,
missing?
one is, my lord, that may become today, my lord. Must have not.
Lordship, I beg to mention item number 32, Lordship.
Please wait.
Lordship, not Lordship, the matter has been in fact, says Lordship, I am praying on behalf of C. Goswami, Lordship.
Okay, Mr. Lana Council. What is your name, Mr.?
Yes, Sharma, Lordship.
From Lana Council, the matter has become infection. According to the place is closed on has been on being infected. Yes. Next.
May I please, Lordship, I beg to mention with consent on the other side, item number 19, only for adjournment for 1 day. Lordship.
Mr. Please wait.
Right.
Very good. Yes, next.
I beg to mention a writ appeal for urgent listing. The writ appeal was filed on 23rd of this month. There is a implement order or a writ petition number 5919 of 2022 in the favor of the highest bidder for 8 months, Lordship. It will cross the financial year of which is indeed on 23rd, 21st.
What is the stage of the writ appeal?
It is for mention.
No, what is the stage? Is it already moved? No, not yet moved.
No. So kindly listed on Friday, Lordship.
Right.
May please, your lordship. Lordship, I'd like to mention item number 15 of the daily list. Lordship, in that matter, will be filing a rejoinder affidavit.
Please wait. We'll pass the order.
Lordship, I would like to mention an item number 36 of today's list. May I pay this matter may be taken up after 2 weeks, Lord.
We'll pass the order. We have to pass some order, no? So we'll pass the order when the matter comes up. Yes, next.
Daily list for motion, item number 1.
Yes, Abdul Razak. What is
This
this?
is regarding the dissolution of the board of directors for not holding a annual general meeting.
In fact, the violation
I have already
challenge,
given,
violation of the act is under challenge. Your lordship wanted to know, my lord, whether similar orders has been passed. My lord, there are.
I have already given the copies, Lordship.
So then we can close on that
Yes,
basis. Okay.
The
Mr.
disqualification for participating in. next
Whatever,
election
if
should not be
already
there.
pass them, we follow that. Nah.
My lord, there are orders in respect of the same impugn order. I place this one, my lord. Same impugn order.
This one, this thick one.
No, I don't know what is that. Lordship may take up this one, my lord.
When you exchange it, you should have been.
I'm sorry, my lord.
You.
5 cases, my lord, 5 cases has been disposed of by the honorable single judge in respect.
And
of-
what is this? What is this thick one?
This is regarding the disqualification for contesting the next election.
My lord,
This honorable court has held that disqualification will not operate.
Okay.
my lord, that is a
this is
proposition
what
of
was-
law. That order, my lord, judgment by my learned friend is a proposition of law, and applying this law, my lord, this
This-
orders has been passed.
2022. And this one, Horikolita.
Yes, in respect of the same impugn order, my lord, passed by.
You
the
don't have a
honorable
copy of this, mister. Have a look. What is there? After some time, have a
On the
look.
last occasion,
Doesn't
my
matter.
council friend was
We'll
insisting.
take it after some time, have a look. If you are satisfied, we'll close.
Lots on Wednesday.
On Wednesday, why, it's only four pages.
Yes.
Only 3 orders, 5 pages. You go there and have a cup of tea and look at it till after some time. Yes, next. Next, Sri Sai.
Item number 2.
What is this item number 2?
May I please your lordship?
Yes,
We have received a copy of the affidavit filed by the respondent authorities yesterday.
yes.
So we request some time for filing our affidavit in reply. In this matter.
Yes,
Yesterday we had filed our affidavit
okay.
and
Have you filed?
File the affidavit.
yes,
You have received a copy.
Yes, yesterday we have received, so we
Okay.
request time for filing our reply. And lordship, we have a small prayer here. Lordship.
There's some status quo. What is this
yes,
about?
status
What?
quo is there.
Ah.
Status quo in respect of the auction sale.
Ah.
So status quo may be continued till the
Till what time? Tell us.
lordship, will you please to fix after 2 weeks, a fixed date may be given.
Till then status quo. And how much you owe him?
5 crores.
5 crore.
5 crores, but as per our claim, your lordship, as per the second OTS, we have paid 81% of the amount.
Ah.
So in regard of that, we would like to bring in relevant documents on record.
Oh, you want to say that since you have paid 81%, therefore surfacing would not apply?
Just to operate.
Huh?
The crux of the matter is that what is the percentage?
Hmm.
According to their claim, lordship.
Why 2 weeks? You take 1 week, we have to
Yes,
work
yes,
out, huh?
yes, sir.
One, huh?
And
No.
lordship, a small prayer, lordship.
Yes, yes.
Lordship may be pleased to give a direction in order to furnish us the copy of the term loan agreement as well as the account statements. Because
It
in
is
the-
with you, you are supposed to be
Yes,
with you.
yes.
Term loan agreement, you are the one.
No, but
You took the loan, you have a copy of the agreement with you.
lordship.
If you have lost it, you apply. We can't direct. You apply. Okay. Please after a week to enable Mr.
He does.
He has to file a rejoinder to the affidavit filed by the respondent. Yes, list again, direct 1 week till then the status order will continue.
Lordship may fix a date.
Did. Bring some money also. Not to us, for them.
3rd February.
Yes.
Item number 3 for admission.
Item number 3. Yes, state.
I was praying for
What?
Monday, my lord. I have received the records today, my lord.
You have received the record today
Just today, my lord.
from the
Yesterday was-
government.
My lord, for the
Who
government.
filed this?
My lord, it was filed by the government, by the earlier set of councils, my lord.
Oh,
And yesterday being a holiday, my lord, I could only arrange for the records today.
and tomorrow also holiday.
Friday, I
Then,
will not be in station, let it be on Monday, my lord.
On Monday.
April of 18, my lord.
Yes.
Monday.
Monday on the Prime Muzumdar. Yes, next.
Approach.
Next.
Item number 4.
June money. Yes, what is this June money?
My lord,
Huh?
it's a dispute between two wives, my lord. with
Two
regard to
wives.
Pension.
Two wives are fighting.
I am the
But I
first,
already.
You are the first wife, second wife.
I'm the first wife.
You are
First
first.
wife,
You are
because-
the problem creator.
Now no. I will make everyone happy, my lord.
Yes,
today.
tell us.
My lord, in terms of the order dated 29/11, 2019, passed in my lord, IA number 3951 of 2018. IA,
In IA.
my lord, IA number 3951 of 2018.
Tell us what is
Yes.
what is
My
that?
lord, in terms of that order, there was a objection raised by the state government that pension has to be can be deposited only in the name of one person.
Correct.
So this court ordered that yes, the pension and all the amount which are due will be deposited in my account. I have to make 4 shares because the first wife, second wife, and there are 2 daughters. So 4 shares I have to make. Then in terms of that order, my lord, on last 19, the money has been deposited in my account, my lord. So
Yes.
So in terms of the direction of this code, an amount of 5,65,703 plus 26,61,580. It's almost around 32 lakhs. have
Okay.
been, deposited.
Yes.
But my lord, there was a loan of my husband, my lord, amounting to around 5,34,865 plus interest. I think that amount has been kept hold or it has been deducted because in the mini statement which I took out, my lord, after this deposit, although it should have been shown 32 lakhs, it now shows that 25 lakhs 23,000 and 062.88 is there. So I think that they have taken out the loan which my husband has taken us.
Here.
Now what I will do, I will make this into 4 share. Plus in here I have to add more 5,000 in the statement, your mini statement, your lordship will see. I took out 5,000 to come to Guwahati and give the instruction to the lawyers about this, all these things, my lord. So that 5,000 I will not share it or whatever it. Now we'll make it into 4 shares, and my learned friend will give the account number of the wife and the daughter, and my 4 shares I'll immediately RTGS or whatever it's immediately I will do, because in terms of the court order it has to be done within 2 days. But since the account number was not given to us, we could not do it. So it will be done. That is number 1. Now, so far the other dues are concerned, my lord. Now only GIS, GPF, and leave salary. These 3 has to be paid, because since the direction of this court was only in case of pension and provident fund, so the department did not process it. They told that if a direction is given from this honorable court to calculate all this and disperse it, then also we'll make it at 4 shares and give it to them. And I think with this observation, my lord, this matter can be closed, because I don't know, we don't determine who is now and all, because everyone should go back home happy. And they all belong to the lower economic society of standards.
In principle, I agree with my learned friend, but with some reservations, my lord. First of all, my lord, as per the pension rules, lordships are aware that it cannot be divided, but still I have taken consent of my client, who is the first wife, and she has agreed to it. Now, the second point which arises, my lord, my learned senior friend is referring to a order passed in the miss case, my lord, where the pension was apportioned and only one portion was given to me. That order was passed, my lord, on the statement made by the other side that my minor child is also living with the respondent number 6, who's the second wife.
My lord, I will only request my friend to pause for a moment. What has happened? Earlier, the 2 daughters were staying with because she has deserted her children and gone. There was also a son. Now, since the son is now a major, he will not be entitled to pension. The other daughter, my lord, when she became a major, she went to her first mother. But earlier, she deserted both the children, and I brought up them when she deserted them. Now, since the first child wanted to go to the mother, so instead of making it 3 shares, because the daughter will be entitled to get the pension till she gets married in terms of the new rule of the state government. So that's why 4 shares. Otherwise, to 3 shares, if you make it, I will get more. But that statement is corrected. Because
what do you want to say?
Yes, ma'am. So that order was passed that only one portion out of 4 portions should be paid to the petitioner. Now, my lords, when I objected to that order, my lord, the honorable division bench requested the other side to give photographic evidence of the statement as to whether the minor is still living or whether she ever lived with the second wife. Now, that was never produced, my lord. Instead,
we had filed an affidavit.
We filed an affidavit, my lord.
We had filed an affidavit.
By the major son and daughter, who claimed that they never lived with the second wife.
Those are
my only prayer, my lord. What I'm
I have
trying to say,
photographic evidence.
my only prayer, and if your lordship goes through the rules, my lord, the 143 rules, my lord, the pension would devolve upon the sons and daughters only if the widow or the widow is not there. Now that question does not even arise now, sons and daughters. So what I humbly pray, my lord, otherwise, my lord, on merit, I have a very good case. I am entitled to the entire pension, my lord, because that divorce per se is null and void, non-est in the eyes of law. But however, my lord, since, my lord, it's a beneficial legislation, my lord, pension, and admittedly, my husband married another woman, my lord, so I'm agreeable, provided it is shared 50-50, my lord. So, and another point, my lord, since I am the first wife, it should have been deposited in my account, and there should have been a direction by this court to the bank to apportion it 50-50. Now that pension has already been deposited few days back, what I have been told, my lord, in the account of the second wife, when matter was still pending, my lord. What I say now, my lord,
instead of using
all due respect, my lord,
You are aggrieved by this order passed in the miss case.
yes, my lord, because it says lordship would kindly
Then
come.
you should have got an appeal.
My lord, thereafter it was, yes, my lord, but my lord, was perused the later orders, my lord, order dated.
Later order is all right, but this order remains. This order, so long this order remains.
My lord, it's a continuation of the proceedings, my lord.
Maybe, but if you are aggrieved by this order, you should have taken.
My lord,
recourse
that's
to-
why, my lord, I raised that contention, lordship would come to.
And this matter has come before the division bench by
Order,
virtue of the fact that this is a matter pertaining to customary law.
customary.
The question really whether your wedding or the divorce survives or not
Yes.
is a matter
I'm
of evidence.
agree to argue on that point, my lord.
No, it's a matter of evidence.
My
How can the division bench without evidence come to a finding?
My lord,
whether it is valid or not. So
I
the only issue is what is to be done with the pension.
yes.
I believe recently a full bench of this court had deliberated on similar issues and has rendered a judgment. I think you should have a look.
We are
Amicably settle it. We close it.
Yes, my lord, I'm
At this
agreeable.
stage.
I'm agreeable.
Now
but it
he
has
is
to be
saying
divided
now
50-50, my lord.
whose child lives with whom is a
Exactly,
matter
that
of
is not
evidence.
even material. That is the point I'm trying to make, my lord.
No, no,
Now,
how
what-
do we
My lord-
come to a finding that what he says or you say is correct or incorrect on the basis of a photograph?
My lord,
No, not
to
only
one
basis of a
extent,
photograph, Lord, you would
all are
take
agreeable
up my
that
additional
there are four
affidavit, my lord.
members.
It's a affidavit sworn by the children who are majors, my lord. They say that
My lord,
I've never lived
Sir,
with
my
them.
lord will kindly
However,
take into
like-
consideration, there are four persons who are entitled to pension. He wants that it should have. My lord, I'm saying that these four persons who are entitled, so 4%
So
share
we
should
go by
go
this
to four.
order.
Yes.
If you are agreed by this order, you should,
My lord, this is.
we can't
this-
advise you what you
My
should
my lord,
do.
in that case, lordship would kindly produce the order dated 6/10/2021. That's a later order passed by the honorable division bench, my lord. I'm sorry,
6.
my lord, it's yes, 9/6/2022, my lord,
In the repetition,
in the writ petition, my lord,
9/3.
9/6/2022. Can you file for affidavit?
Nine Han Monto, also Khanikar, Dima
Second
Asaf,
paragraph, my lord.
Brahmo will submit by affidavit photo proof that a second will looking after our own daughter, Avirna Bathari, and also Miss Ringsodi Bathari.
Now,
The
lordship.
daughter.
Now, your lordship
Lordship
will
would
see, in
produce
terms
their
of this
affidavit now.
order, we had
Lordship would
filed an
produce-
affidavit on 1/8/2022.
Lordship would produce paragraph 4.
But photograph.
Yes. Photograph is there. And we have given my 1/8/2022, the affidavit, your lordship will see.
So you are staying there.
Yes.
You
My
Lordship
lord,
would
1/8/2022.
kindly produce paragraph. I'll read it out, my lord, paragraph 4. And with all due respect, my lord, the pension.
Why? You see, what we propose to do is that
My lord, sir.
since both of you are showing some inclination towards agreement, why can't you sit down?
Hmm.
No,
Well, I have already.
sit down somewhere and come up, we can assist you, or then you see, then we'll, because see,
But this
there's no
can be-
point, doing this.
My lord, I have no.
See, normal cases are okay, but see, family disputes, sometimes you don't want to say things in public, whatever is there, so many things. So you sit down together.
My lord.
It's
I'm-
not kind of
I'm
mediation
obliged,
also, but sit down together, have a cup of tea, we'll depute one officer.
What my
And if you
proposal-
say so, then it can be disposed of. What
My
is
lord, you
there?
can- my lord,
My proposal, my
what
lord,
I-
all due respect, my lord.
Whatever you propose,
It's
you
the
come.
same thing, my lord.
Both are very reasonable counsel, so I think,
Just one
this
second,
is-
my lord.
ah,
One
this-
second, one second.
yes.
What my learned friend is proposing is that the daughter who is major and now she is around 23 years of age, her share should
How
also
will
be
it devolve
clubbed
upon
together
the
with
daughter,
her.
my lord, when the
I
wives
have
are
no
there?
problem. I can
I'm
also go
proposing
with
Very
the
well.
minor.
Therefore,
If you want
since-
two
Devolve
shares.
upon the sons and daughters, the wives have to.
see, have a
My
discussion.
lord.
If you come to an agreement, fine, we welcome. We are not forcing you. If you some genuine reasons you are not able to agree, no problem. We'll pass some
My lord, the
orders.
only point of
Otherwise,
dispute.
on merits, my lord, like my honorable justice.
Or council will sit or the party will sit, tell us. which
Parties,
one.
my lord, she has to spend 5,000 rupees.
Then
doesn't
let
want
the
to
council
speak.
sit then.
That's why I'm telling, my lord, if he wants that. we
No,
should-
not just now, not just now.
No,
You sit somewhere, any convenient time, the matter will come up on Monday. Monday?
I briefed him about the development before
Yes,
coming to
yes,
this.
please
court
that.
also.
You have good bar rooms, you can just sit, order cup of tea, sit down there, take your time, informant manner,
My
in a
lord,
very friendly manner. Everything can be sorted out.
otherwise-
Because we
otherwise-
see, why I am saying that both parties are showing some inclination to resolve, which we appreciate.
My lord,
So kindly do that, let the matter be listed on Monday. In the meantime, parties will try to work out an amicable settlement
My
to the
lord,
issue.
on the last
And
occasion.
you also kindly help them.
My lord, on the last occasion, some instructions are recorded to
So
be given.
please also take part also, no problem, please, because your instruction will be also necessary for both the parties to.
Instructions, what is it?
What instruction? That,
Regarding pension, my lord.
okay,
the
we'll
last
see that,
occasion.
you are more on official line, so we'll see that, of course, huh? Kindly give that instruction available to them. Mr. Learned Counsel, please give it to both the parties so that you will know the official stand.
What my learned friend is saying, that this pension should be apportioned into two portions.
You,
I agree to it.
whatever,
just
that is
now,
a very good,
but
that's.
He's agreeing to it, my lord.
So you just have a.
What problem will be there, my lord, what I'm telling as a counsel, as an officer of the court, that if I make it into two shares, definitely my share will be, but the daughter's life will not be secure. Because the daughter's life has to be, because if you give it to one wife, if she doesn't give
List
it to
on
the
Monday. In the meantime, parties will may try to work out as amicable settlement.
Just one prayer, my lord. The money, the DCIG has already been deposited. That
Till
should not-
Monday, till Monday, till Monday.
that should not be utilized.
No, he's not going to.
Spends it, that is duty bound to refund it back.
Yeah, he may send it, then of course, but whatever he spends, he will give it to you.
I have
He's
instructed my
already
client.
5,000 for the expenses. Like.
Why not, ladies?
Otherwise,
Coming
Mr.
out to
Kowar
raise
himself,
fancy.
he'll pay from his pocket,
Oh.
don't worry. Yes, Mr. Yes, next one.
Grateful, my lord.
You have a very rich opponent, so the client, lawyer as well, so don't worry. You are assured.
Take full care.
Yes, sir.
You don't have to worry.
Very grateful, my lord.
Monday.
Item number 5.
Yes. Secretary, government, what is this? Please tell us.
This is regarding rental compensation, Lordship.
What consultation?
Rental compensation. For
You give.
No, Lordship, we have already given.
Okay, yes, who's for the other side?
Now.
What is, why is it listed today? Nobody's the other side?
Mr. KL Chaudhary appears for the private respondents, Lordship.
So what to do? Tell us.
Now.
Devi appellant prayer down the middle again. Please tell us what will be done today. Please tell us. What do you want?
In fact, the state of Mizoram was directed to file an affidavit as to who would calculate and what rate the calculation has been made. That affidavit is to come.
See, the next is state of Mizoram. Yes, madam, we are from Mizoram.
Your Lordship, I am appearing on behalf of the additional lady. He is keeping unwell. Your Lordship will file the affidavit. 3 weeks time will be given.
Okay. 3 weeks time, further 3 weeks time granted to the state of Mizoram to file the affidavit as directed earlier. Next.
Item number 6 to 12.
What is this? Mr. KL.
These are the appeal filed by the revenue under section 35G. After receipt of the notice, the opposite party appeared and they challenge the maintainability of the.
Okay, we'll hear.
No.
We can hear summarily. We'll hear.
Yes, Lord. That is.
Well, this issue of maintainability was there, and on the decision on order on 26th July 2022, order was passed. What instructions they have about the maintainability, because in the central excise appeals, certain appeals cannot be filed before my lord. These are to be filed before the Honorable Supreme Court only. These
In respect
cannot
of the rates.
Yes, my lord. Rates and classification.
And your appeal is relating to what?
Lordship, in this case, what happened, the respondents, they are supplying oil to different refineries. And we tried to.
Anyway, we'll hear you.
Yes, Lord.
Properly, we'll hear what is there. Which will
Yes,
include the. So we'll hear. Anyway, you are prejudiced by this appeal right now?
Yes, my lord.
In what way?
Our submission is
Oh, we'll hear your submission.
that this should be not entertained and this should not be admitted. Reason, because
We have not yet entertained, we have not yet admitted.
yes,
So till so far, no prejudice goes to you.
yes,
We will fix a hearing for you, yes. This is the matter.
my lord, in this for admission only this was fixed today.
Okay. Then unfortunately today we may not be able to spare much time because of some other reasons. Not that we are not inclined to hear you,
Oh.
but we may not be able to hear you extensively on this issue. That is the reason.
Sorry, my lord. I have
There is no issue. Because we are in a hurry for some other
sorry,
reason.
my lord. I was not.
No, not because of anything. It's not that. Because we have to cover many, so we want to give time to everybody who is present here. A little bit of rationing we are doing because of paucity of time. Yes. So we'll hear it
Yes.
properly on the matter will be listed again.
You are outside.
You are outside,
Yes,
Master.
yes.
When?
Issue date.
My lord, we give the date, we will like.
Okay. List again, give a day after 2 weeks. On as to whether these appeals will be admitted or not.
9th of February.
To consider as to whether these appeals will be admitted or not. Yes. On that day we'll see. Huh?
Not highly
Yes,
likely.
next.
Item 13.
Satish. What is this, Satish?
My lord, the person there was a criminal case against him. My lord, the charge sheet was filed, but the charge sheets were not issued to him. Charge sheets were issued to him only in 2016. In the meantime, in 2012 and 2017, it was issued to him. 2012 and 2016, 2 rounds of promotions were held, but it was kept under seal cover. The charge against him is that he abetted his wife's suicide. The charge sheet, although filed in 2012, till date charges have not been framed. Case was taken cognizance only in 2017. Thereafter, the copies were issued to me. I'm relying on my lord KV Janagiraman para 16, which says seal cover procedure can be resorted to if my lord there is a suspension, person is under suspension, or a charge sheet has been issued to him. I was under suspension in 2012. Although I was never arrested in a criminal case, they had placed me under suspension. Be that as. But 2016, 2012 to 2016, number of promotions took place. 2016, the next higher grade promotion took place. My case considered, but kept under seal cover. And from 2012 onwards, till date, 10 years, I am forced to work under my juniors. This is my case.
And what is the stage of the charge sheet?
My lord, the charge framing is fixed on 31st of March, 30th or 31st of March. Till date, nothing.
31st of
Very much. And the order, my lord, would find at page 128, the criminal proceedings. I had even prayed that you give me an ad hoc promotion. That also, my lord, they are not.
Your case is that on the day the DPC was held, there was no charge sheet filed
My lord, the
against him.
first DPC, I was under suspension. So that is a ground for keeping me under my
And
seal
the
cover.
second,
Second DPC, there was no charge sheet.
there is no charge sheet.
No charge sheet. And from 2012 to
Second DPC was when?
But second DPC was held on January 2016. My lord.
January 2016.
16.
And the charge sheet was filed on?
My lord, charge sheet was filed in 2012. My lord, it was filed on 36 2012.
36?
2012.
And the
Cognizance taken on 6/3 2017.
6/3?
2017.
And now charge is fixed on what?
30th of March 2023. Madam.
Yes. What do you say? Mr.
Lordship,
Chief?
we have followed the OM, Lordship.
What is the OM?
Lordship, we take up our affidavit, Lordship.
What is the OM, please?
In the page 17, running page, if I'm not wrong, it is 147. Lordship.
147. Yes.
Lordship, may I read?
146 is the charge sheet. Final form, report, charge. This is a
No,
charge.
office memorandum dated
Yes.
14 September 92. Annexure A of my affidavit, Lordship.
145. This is 92. There is a further office memorandum of 2012 at
145.
145.
Yes.
You're referring to 14 September 92.
Lordship,
92.
Para number?
Lordship, para number 2, Lordship.
Yes.
At the time of consideration of the case of government servant for promotion, details of government servants in the consideration zone for promotion falling under the following categories should be specifically brought to the notice of the DPC. Government servant under suspension. Then 2 is no relevant. 3.
And the D is still continuing or what?
There is no DE. Madam.
Okay. Government servant charge has been issued.
Lordship,
Shall
government
be
servant,
issued.
and number 3, Lordship, government 2 subclause 3. Government servant in respect of whom prosecution for a criminal charge is pending, Lordship. So the criminal case is still pending, Lordship. And
For a
Lordship,
criminal charge is pending.
pending. Lordship, then Lordship 2.1. The Departmental Promotion Committee shall assess the suitability of the government servants coming within the purview of the circumstances mentioned above, along with their eligible candidate, without taking into consideration the disciplinary case, criminal prosecution pending, the assessment of the DPC, including unfit for promotion and the grading awarded by it will be kept in a sealed cover. The cover will be subscribed finding regarding suitability of the promotion to the grade post of in respect of so and so, not to be open till the termination of the disciplinary case or criminal prosecution against so and so. So till the case is terminated, lordship, the criminal case is to be kept in sealed cover, lordship.
My lord, that has been clarified. Internal page 29 of that affidavit. My lord. It will be the last but one page, my lord.
Yes,
Para 8, my lord.
there are 8 of their affidavit.
No. That last but one page of their affidavit, my lord. It's a part of an office memorandum of 2012. Its internal page is 29, my lord. Running page, my lord, unfortunately. It's last but one, my lord, of the
Whose affidavit?
their affidavit, my lord. The affidavit which my lord is reading, my lord. That is Annexure A, my lord is reading. My lord will have to come to Annexure C.
Para 9.
Lordship.
Which para?
Para 8, my lord. Page 29, internal page, my lord. That,
Yes,
my lord has got it.
yes.
As regards the stage when prosecution for criminal charge can be stated to be pending, the said OM dated 14/9/92 does not specify the same, and hence the definition of pendency of judicial proceeding in criminal cases given in so and so is adopted for the purpose. The rule 961B here 1972 provides as under. Judicial proceeding shall be deemed to be instituted in the case of criminal proceeding on the date on which the complaint or report of a police officer of which the magistrate take cognizance is made. My lord,
And cognizance was made on?
my lord, my lord will come to 128 of the, my lord.
And when was the cognizance made?
Cognizance was made, my lord, on 35 2017.
Where is the record?
My lord would come to page 128 of the writ petition.
24/7/2019.
Lordship.
Cognizance.
Second paragraph, the GR case number was committed by the learned judicial magistrate Jalpaiguri wide order dated 6/3/2017 and learned section judge after commitment to cognizance.
Yes,
Why
Mr.
this
Chakraborty,
order-
what do you say? 2nd November 2012, your office OM, it has clarified. The vagueness has been clarified saying that the cognizance and when the date the magistrate takes the cognizance is the date from which it will be deemed that the criminal pending. What do you say? Yes,
Lordship, can you peruse this decision, Lord?
quick decision.
Okay. One is 1993, 3 SCC, page 196, Delhi Development Authority, Lordship. Relevant paragraph is paragraph 8, Lordship.
This OM has been discussed?
Lordship.
This OM has been discussed?
2012.
This OM has been discussed?
Lordship.
Or just a general law you are talking?
Lordship, I discussed paragraph 5, it has been.
Paragraph?
Paragraph 5, the OM has been referred. That
Paragraph
4992 OM has been.
92 OM would be there, my lord. 2012 would not.
The 92, you are talking of 92.
That 2012 OM is continuation of the 92 OM.
But then it's clarification that this 92, what is the relevant provision? 92? The government service charge has been issued and pending. Now, correct. Now, it has been clarified further in 2012. That clarification, therefore, is not there, so it's not applicable. Then next. Harsh Kumar.
Harsh Kumar, Lord.
Yes, so
Paragraph 16, Lord.
paragraph?
16.
Paragraph 16. Paragraph 16. Employee.
In respect of whom charges have been
Correct.
issued and the disciplinary proceeding are pending.
Correct,
In respect
no
of
problem,
whom
pending.
Prosecution of criminal charges pending.
Correct,
this
but we are
assessment is
concerned with the OM.
Lordship.
Then there was 92 OM, you are referring to 92 OM. Next, any
No,
other case?
Lordship, paragraph 20, this 2002 OM has been discussed, Lordship. Paragraph 20,
Paragraph 20.
Lordship.
Okay, therefore, the move on the part between resources of justified.
We may
In
record at this stage
92,
now. First,
Silk cover has been repeated by the Ministry of issues regarding view dicta and so the assumptions.
Lordship.
Correct. There is no doubt about it. Silk cover has to be, but then when is
Charges are-
one thing.
When the charges are serious in nature, Lordship.
Doesn't matter. whether serious or non-serious, we have laid down certain rules.
Lordship, let us wait till March. If we have a good case, he will get.
What do good case, bad case, we don't, sir. Please don't bother us with good case, bad case. We are just dialing with this law.
Get discharged in the.
Doesn't matter. That,
Charges,
oh, mister, why are you burdening us on good case, bad case? There is nothing good or nothing bad for us. We have to interpret what the provisions of law is.
Lordship.
So we'll see that.
Lordship, I'll be relying on paragraph 20.
Very well, we have heard you. We are disposing of, we are allowing that. But we are distinguishing this, but we don't have time to dictate, so we can't now. Next,
My lord, that AR 1991 4 SCC.
you are relying after we have passed over. What is that?
No, only that earlier judgment, my lord, KV Janakiraman, which is holding the bill. 1991 4 SCC, my lord, its page is
What is it?
109, my lord. 1991 4 SCC 109.
Those judgment has been referred. To
Then, my lord, para 16 and para 17 will thereof.
Okay.
Much obliged, your lordship.
Next.
Item 14.
Deposit Gogo, yes, what do you want?
Lordship, this matter pertains to compassion appointment. My father died. After that, Lordship, we applied for compassionate appointment. District level committee recommended my case. State level committee rejected my case on the ground that it was a voluntary retirement on medical ground. I filed this case, Lordship, saying that medical ground is one of the grounds
Yes.
for compassion appointment. Only there are two circumstances which needs to be followed. I argued before the single judge that I followed substantially, but since my father died, it could not be followed, so it was impossible to follow.
What follow? What follow? What
So
substantive what?
there are two conditions that I should receive invalid pension.
Yeah.
Secondly, there has to be a certificate of the medical board. Since after 6 months of my retirement, I died. These conditions could not be fulfilled. I argued before the single judge
What
that
do you say? After 6 months I died. What is this? I don't know. Your father died. Father died. You say that after 6 months I died.
father of the petitioner died. Therefore, I argued for a purposive construction of the policy. At page 23, Lordship would see the judgment. Learned single judge has said that the conditions are mandatory in nature. Therefore,
So what does the learned single judge say?
the conditions are mandatory in nature and it has to be strictly followed. I had argued that it is a beneficial policy, therefore, Lordship, purposive construction should have been given page 23, Lordship, which is the operative part. Now, Lordship, only thing for the first time in these appeals, affidavits have been filed virtually admitting that it was a medical ground for which my father had taken voluntary retirement. Therefore, just a raise consideration. That is all I require, Lordship. I am not seeking appointment.
Yes, but
Just because
Why consider your case?
Lordship, many aspects.
You are seeking appointment for compassion on compassionate ground.
Yeah.
You just said you're not seeking appointment.
No, Lordship. From this court, I just need a fresh consideration on this issue because my initial application was not considered by the state level committee. My medical certificates was not considered. Therefore, Lordship, these documents, Lordship, the state level committee may consider it again, Lordship, and take a decision on this.
but if the medical board, whether if a person dies, obviously they can't have a medical board of the spirit.
Yes.
It has to be the physical person,
Yes.
not the spiritual person. So what to do then, madam?
Lordship, actually, he has taken the deceased, he actually taken retirement on his own request, Lordship. This is on voluntary ground. And this is in page 36 of the.
Voluntary,
Yes, Lord.
Yes.
Voluntary retirement
I voluntary retirement on medical
on
ground.
medical ground, on medical ground.
But there was no board because if it was on medical ground, Lordship. the
But
board-
question is,
Lordship.
when the voluntary retirement was accepted by the authority.
Lordship.
On what ground it was accepted?
Yes, Lordship may kindly peruse the page 36 of the memo of appeal, Lordship.
With due respect, I am a constable, so and so I come to 20 years, I like to submit retirement case. I am suffering from very ailments, so and so, difficult, so and so. And this was accepted?
Yes,
Yes.
this has been accepted.
Well,
Lordship.
I have been suffering from very ailments in
Yes,
last
Lordship.
invalid to invalid for it become difficult. Then what was the ground for accepting?
Accident because
Where is it?
My medical certificate,
Then why the ground? Why the ground?
Lordship, this has been
page 69.
Cannot go on so and so on under FRC and circular for duties pending. Constable is allowed to go on voluntary
yes,
retirement.
page 39.
Only thing that this government also not will go on voluntary retirement on medical ground or something like that, nothing like that, no?
This is exactly Lordship.
Now, Lordship,
See, you are entitled to go on voluntary retirement since you have completed 29 years.
yes,
That is also there.
12 years of leftover services
Huh.
also there.
So I have been suffering, understand, not to accept voluntary
He has
retirement
not
notice.
taken any,
See, you also were not very clear, I said, I am suffering, so I don't want. You didn't say that difficult on a medical service effect. So we'll presume that why you are taking such a strict kind of. He said, I cannot function, I can't run after this chore, I can't run after these thieves, I cannot function valid, I am invalid. I want to retire. You allowed, okay, go and retire.
yes, Lordship.
So
this
you
is
see
exactly
what immediately preceded his application, no? That has to be looked into.
Lordship. And
So
it
if
has
it
been
is
given-
voluntary retirement on medical
There
ground, why you are-
there was no medical board,
Oh,
Lordship.
again, how can the medical, when he has died?
No,
You
no,
say,
that time he, because this application was on, no date is mentioned here.
he retired
Yes,
on
August 2014 and.
2nd January 2015.
Yes.
See, this is the precise question asked by the single judge. Who has to send me to the medical board? That time I also could not answer. They also could not answer. But at page 124, now I have annexed a document of 93, which says that is the department who sends me to the medical board. I cannot go on my own.
No. See, the person that he died, he retired, he was given voluntary retirement on medical ground,
Yeah.
isn't it?
On his own request.
Doesn't matter, you
Yes.
only request, you accepted it. Now, if he's allowed to go on voluntary retirement medical ground, his son is entitled to apply for compulsory appointment, isn't it?
Yes.
Now, his medical examination is not of the applicant.
No.
You are required to be, no,
No,
you are fit,
not
medically fit.
applicant.
Then medical examination the person.
Son,
Ah,
who actually
now who
prayed
has
for-
died?
yes,
Now
yes.
you arrange, send a team to hell or heaven. What to do? We'll allow you. Arey Baba, you have to work out a solution to this.
Lordship.
Therefore, we see the immediate circumstances which led to his retirement.
Yes,
That
but
amounts to, if from the record it appears that he was not well.
he was
I'm
not
totally
well and
invalid.
He said that his wife expired and there is no one to look
No, no.
after his daughter. That's why he
No, no,
was
please,
seeking
please.
retirement.
Page 36, please read, voluntary retirement. I have been suffering from various ailments in
Yes,
last
Lordship.
6 months, especially my left hand become totally invalid, for
Yes,
which it will be
Lordship.
difficult for me to perform duty sincerely. A copy of
A
medical certificate.
certificate
What is
would
this medical
attest.
certificate?
And
Next
after
page,
6 months, he
Phonindo
died.
Sonowal. You can ask Dr. Phonindo Sonowal, this gentleman had come. Is it correct? I say, yes, it's correct. Then matter ends there. Unless Phonindo Sonowal, he's a superintendent also. He's a big, he's not a normal person. He's a superintendent of Dibrugarh University, Dibrugarh Hospital. You ask him, this gentleman, man, Dimbeswar had Gogoi had obtained his survey. Do you think, was you examined by you? I said, yes. No, it was not examined by me. I don't know how he maintained. Then fine. Because see, he said loss of, what is the stiffness, because the weakness in loose motion, liver. What is this? What kind of medical problem you are having? Suffering from?
Lordship, his left hand was totally invalid, Lordship.
No, he has been suffering from, what is this?
Deformity of left wrist.
No, no,
Mental,
this is to
Sir,
certify that see,
sir,
Dimbeswar Gogoi has been suffering from
page 37. Lordship, you
hepatitis,
see the medical
astromophia, deformity of left wrist, mental illness, considering the nature of the case, he is being referred to Assam Medical College for hospital and proper treatment. This was on 2000. Did you undertake any treatment in Assam Medical College?
Yes, Lordship.
Loss of appetite and giddiness, so and so. less risk join, deformity, stiffness, deformity, weakness.
I was almost on regular hospital.
Mr. Madam, forget this medical board. You just ascertain whether these documents, these medical, if it is considered to be correct,
Lordship.
can it be a case of invalid? See that can he discharge a function? If he cannot, then he shall be deemed to be valid.
Lordship, that's why the medical board was necessary and
You constitute a medical board only to ascertain as to whether on the basis of this this document,
Lordship.
a document, whether a person can be considered to be invalid. If that is so, it will be considered invalid
Lordship,
pension.
then lordship may say,
Yes.
that affect lord.
You were recommended by the DLC.
Yes, yes.
And what happened to the SLC?
No, SLC pays 69.
What did the SLC say?
Retired on voluntary ground, therefore it is not covered under that.
Then we have to interfere with the SLC also.
Lordship.
We have to direct afresh.
Yes, set aside and.
Okay, we'll direct afresh. We'll ask you to constitute a medical board and see this document.
Lordship.
As if he's a dead person's, under Evidence Act,
Yes, lordship.
is admissible.
Yes.
The document evidence is a statement of him admissible in law.
Lordship.
So you see this, if the
Lord-
medical board consider that, yes,
Yes.
this is a case of invalidity, he cannot function, then we'll treat that, we'll clarify that this voluntary retirement was on medical ground and accordingly proceed. Is okay?
Lordship.
Madam, you could have done this also, the government, why the government
Lordship.
doesn't do all these things?
Because the
Because what? Only little
Lordship,
bit of
because-
application of mind, a little bit of sympathy, little of
Lordship,
empathy.
because they were always.
You are not
referring
bothered,
to
no,
medical
you are
board,
everything.
Lordship.
Everything is like a mechanical process. That's why we are overburdened with this kind of cases. Yes, allowed. We have given the reason also, no? But we don't have time to dictate now. Yes. Next.
Item number 15.
Headmaster. Yes, madam, please tell us.
Doctor would like to file an additional affidavit.
Additional affidavit.
Yes, sir.
Yes. He wants to find an additional affidavit,
So I have applied for the resolution of 4. I have filed affidavit in opposition.
but they want to file.
Yes, sir.
Miss, when she how long? 2 weeks? To file additional affidavit. Yes, next.
Timing item 1.
What is that one? Why time being? Okay.
That order.
Similar order, Lordship.
They
Thereby
agree to
allow us
that.
to participate in the election, Lordship.
Huh?
They have agreed to that.
We are agreed,
order.
Lordship. Lordship,
Okay, I understand, and a counsel from the hall, have been submitted by the, the applicants are agreeable to, the similar order, be passed as in this 1, 2, 3, 4. You get the submission to be allowed.
Appellant will be considered
Yes, sir.
in terms of the directions in.
4868/22.
You say, understood? Nice. See, tell us, not
You are
understood.
considering them to be ineligible in terms of Rate Appeal 31.
Well, in fact, these are orders of the learned single just says that in terms of the division bench judgment, though it has not been recorded, they are eligible to participate.
That's what.
That's all.
Yes.
Yes.
Lots of kindly, my lord, mention the number of the writ petition, my lord, 4868/22. In terms of 4868/22.
Order, you give us the order.
Lordship will dictate to you in the chamber. Please go. Next,
Item number 16.
16. Jayanti Das. Yes, yes.
This matter relates to removal of a Panchayat president by way of no confidence, your lordship. And admittedly, in this case, your lordship, the section 15 of the Assam Panchayat Act has been violated in the sense that under the section 18(5), there is a requirement that if no confidence meeting is discussed, their voting should be done by way of secret ballot, which is also a mandatory requirement under section 18(5). That has not been adhered to, and by way of raising hands, a no confidence motion against the present appellant.
Is it correct by raising hands?
Lordship will see the.
Is it correct? Yes, Mr. Is it correct by raising hands? Raising hands is not secret ballot.
Actually, what happened here, Lordship?
No. Is it correct or see? We'll hear your story later on. Huh?
Secret ballot should be.
Secret ballot. Then. How do you say it was by raising hand, not by secret ballot? On what basis you are saying?
Page 33 is the
Yes.
minutes.
Page 33. Page 33.
In the minutes, I have given the translated copy, Your Lordship.
Today, experience against and so presided by so and so, take over. Meeting so and so. Then,
Resolution number 1, Your Lordship.
ah,
One Rangalal, the ward member of so and so proposed no confirm motion. The rest 9 other ward members supported. So the process of casting of vote was not necessary in the meeting.
number one, propose a no confirm that the race 9 other wards members supported the motion. So the process for casting vote was not. How can you do this? This is against democratic norm. You cannot do this. It's a secret, but secret is absolutely sacred. Secrecy is sacred in democracy. Otherwise, you say in this ballot box, whom you have casted, lotus or hand?
Yes, yes. That is.
Can you do that openly or sickle? No, you can't do that.
Section 18(5) is.
Secret. Secret is sacred. So we allow this petition. No further argument.
I would just like to bring
What?
you-
Why you are wasting our time?
There's a judgment.
Statutory provision is not followed, the ends there. You may be correct in all other aspects. He may be one of the most corrupt person. We don't know. Doesn't-
Part in the proceedings, madam. There's a judgment of the apex court to that effect. Padmini, I would just like to. bring
What is that? Tell us.
Padmini Singha versus.
Yes, what is that? What is that? What is the ratio of that?
The
Tell us.
ratio is that if the petitioner wholeheartedly takes part in the proceeding,
No, sorry.
which was supposed.
His acquiescence is no acquiescence. His acquiescence contrary to statute is no acquiescence. Or allowed.
No
This-
public.
Obliged,
interest is affected.
Sorry, no more. We have heard you.
You furnish a copy of the judgment.
Gentlemen,
If you want.
you can furnish a copy of that. Yes, next.
Diploma.
Item 17.
Yes.
Lordship, this appeals referred against common judgmental error. Order Lordship connected case item number 92. We have filed 2 appeal. Connected appeal Lordship item 92 of the supplement.
So what do you want? What do you want? What do you want?
Lordship, in this.
What is to be done today?
Lordship, at this stage, learned friend appear on for the record number 1, Lordship. Lordship, impending judgment may be stayed and notice may go.
Lordship, is not the correct lordship already referred to the government lordship. The Honorable Single Judge referred the matter to the government lordship.
That's why I'm
Connected
praying for interim order.
Or voting
Lordship,
fresh,
to be stayed.
fresh selection.
For fresh inquiry lordship, because entire proceeding was done.
Your,
Lordship, by learned friend.
whose appointment was set aside?
Lordship, my appointment.
Your appointment.
Lordship.
On the ground that you do not belong to that
Lordship.
area.
But that representation, Lordship, even in the writ petition, I was not made a party. Then I filed a writ appeal before the Honorable Division Bench, Lordship. Then the Honorable Division Bench referred the matter to the. So see,
Anganwadi members are to be local people.
yes, yes,
Are you a
Lordship.
local
Yes,
person?
yes. There is
No,
a
no, no,
appeal.
Lordship, no.
Lordship.
Lordship, kindly have a look at page
Mr.
78.
Mr. How do we sitting here decide he is local, non-local? Is a question of fact. Who will decide?
Honorable
Lordship,
Single.
You will decide?
Lordship.
Let them decide.
Lordship, kindly come to page 78. There is a finding that she is outside.
Already finding.
Lordship,
We
that
cannot
report
have
was not
repeated inquiry.
That report was not challenged before
With all
the,
respect,
any of the
Space,
state. Lordship,
Space.
page 78.
No, no, that. finding-
Lordship, page 78.
Yes. 78, yes.
Lordship, para 4, Lordship.
Para 4.
Lordship, peruse the report submitted by the CDPO. Kaline ICDS project, wherein it is reveals that Srimati Hanifa Khatun, wife of Hafiz Ahmed, belongs to the survey area of Onkonwadi Center number 13.
Has this order been challenged by anybody?
No,
Lordship,
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 that was
Lordship,
not
Lordship, I
not
challenge
the
Lordship.
report was
Honorable
not challenged
Single Judge has-
before the any of the.
31st March 2018 order has been challenged by whom?
Lordship by me, Lordship.
Only some part
Let
he
me, let him
challenged,
submit.
but
then I-
this.
Not this
report was
part.
challenged. Not
No,
challenged.
no, no.
These report, all of Lordship, kindly have a look at the prayer of the writ petition filed by my learned friend. Lordship, kindly have a look.
Yes.
Lordship.
Lordship, kindly
my- I
come
will
to
place my
prayer
case.
for.
You here, you don't worry.
Page-
Why
page
you are
46.
afraid? Yes.
Page 46.
Yes.
Page 46.
Page 14. Yes. Tell us.
Lordship. The order, Lordship, appropriate direction shall not be issued to setting aside quashing the such and such dated 31/3/2018, passed by the Director of Social Welfare. Lordship, only this part was challenged. The order passed by the Director of Social Welfare.
What is that order passed by the Director of Social Welfare?
That is an actual
31(3).
Lordship.
So he's challenging the entire thing.
Lordship, but report of the CDPO was not challenged.
Oh.
No.
CDPO report was not
The
challenged.
report is part of that order.
Lordship, but report, Lordship,
Okay, we'll hear then. We'll see that. Okay, we'll hear. We'll hear. This
Lordship,
again.
impugned order may be stayed.
Let the matter, Lordship, maybe come up another day, Lordship, because Honorable Single Judge Lordship held that Lordship, since the entire that inquiry report was an ex parte Lordship. By my landed friend has
we'll-
filed a representation Lordship on that, Lordship, and that was
We'll
not
hear
heard.
this matter. So and so. And why you want interim? What? kind of
Lordship,
assessment?
otherwise, fresh inquiry would be called. That
Oh.
is stated at this stage.
What is wrong with that? Why you are afraid of fresh inquiry?
Lordship, fresh
We
inquiry.
may accept, we may not accept.
Lordship,
Let the inquiry be held.
Lordship, may I submit? May I submit?
Yes.
Fresh inquiry was directed to be conducted by the circle officer and the deputy commissioner. They are not the authority to certify that person is belongs to a particular area as per advertisement. Advertisement stated that resident proof certificate is to be issued by the headman.
We'll see.
That
We'll see.
may be
What's the
authenticated by
inquiry
the
is for?
concerned
Sir,
body.
when the inquiry is held, it's not going to say that you are not a
You have the papers.
Lordship,
The enquiry is only vis-a-vis this gentleman, whether he is a resident or she is a resident of that
Yes,
person. No, they are not inquiring about you. So what then?
Yes.
We'll list a matter of sanctions.
Lordship, impugned order may be stayed, otherwise I would be affected, Lordship.
How it will be affected?
Process.
Lordship, my writ petition was dismissed.
Oh,
Two writ petition filed by
so we
one.
are hearing you. You may allow your appeal. We are hearing. Yes, Nish.
After 9th, Lordship.
Latai di do beta.
Lordship, in item number 92, there is a delay of 17 days in preferring appeal that may be conducted.
You have filed 17
Lordship,
days,
item number 92,
2,000
there is a
rupees.
delay of 17.
2,000 rupees. Welfare fund. Delay in filing, how many days?
17 days.
7 days allowed, subject to payment of 2,000.
Lordship, very poor petitioner.
1,000?
1,000.
1,092.
In the
Lawyers
delay
fund, lawyers
In the
welfare
delay
fund.
petition, you appeared.
Lordship, I already filed my caveat, Lordship.
Oh,
and the delay.
doesn't, we have heard so and so.
That's fine.
17 days,
17. And Lordship, appeal may be numbered.
number, will be listed for, yes, Nick.
After 9th, Lordship. 9th,
Okay.
13 February.
Okay, yes.
Obliged.
Yes.
Item 18.
Adam Ali, yes, Adam Ali. Yes, what do you want? Tell us.
My lord, Lord, we want that the, my lord,
Today for what do you want today? Tell us.
my lord may admit and fix for hearing.
Yes, Mr. R. MR. Who is for the R. Majumdar?
My lord.
Bhattacharya. Yes. Bhattacharya for the state. Majumdar for standing. Okay, hard. What is the hard so and so? The request of Bhuya. Yes. Huh? Okay.
My lord, private respondents of their notices.
Okay.
Formal.
Not appeal is
No. We will- No.
okay, issue notice.
My lord.
Appellant takes example so and so mark, huh? Government appears. The appellant takes a service upon the private respondent number.
Lord, 9 to my lord 14.
How will you take steps?
My lord, my lord, it should be from respondent number 5 to 14, my lord, by registered AD as well as Dasti, my lord. Dasti may also be.
Yes. Next.
Obliged.
Item number 19.
Protima.
Lordship, in the morning, I to sought for time in this matter.
For what?
Arguing counsel is not available. Lordship will fix on Monday, Lord. Monday.
There is nothing called Monday.
Monday
Today is
or
your
any
ticket,
day.
and if you don't fly today, it's some other day. We can't say Monday.
Okay.
What is the urgency?
Lordship, our results have been withheld.
My lord, it's the rule doesn't permit, so that's why I filed an affidavit, my lord.
Readings are complete.
Readings are complete, my lord.
For which examination?
It's BA.
BA, first year, second year, third year.
No, we have completed all the 6 semesters. Only back exam 1 is there. We have already given the exam.
They
They
have
are not
exhausted their
giving
chances, my
the
lord.
results.
They have exhausted their chances, my lord.
Why you want to cut off the number of, you want to cut down the number of, unemployed graduates by not giving that he is not a graduate. What is there?
Not rule.
Otherwise,
Have you filed your affidavit? You have filed?
yes,
Come on Monday.
meetings are complete, Lord.
Monday for what?
Lordship, we have paid our fees, we have given our examination, they have allowed it, we have passed all the
You have
subjects.
passed also.
Now only for one subject, they are not giving the result.
What is the problem? You have passed also.
So it may come out at 2 o'clock, my lord. At 2 o'clock, my senior will, my lord.
Who is your senior?
The KK, my lord.
Your senior also there, your senior also not there. Okay. Both the seniors are not there. And both the juniors are not in a position to argue. Okay, some other date, did you? Some other date. Yes,
First of
yes.
February, 1, 2.
Yes, next.
Item 20.
Moinul Haq. What is this?
This case, madam, notice already issued, madam, no affidavit has been filed by that.
Yes, yes.
On that matter.
We need to file an affidavit.
Otherwise,
this is a very.
So who is preventing you filing?
For the instructions, a week's time, madam.
Huh?
A week's time, madam.
At least after a week on the prayer line council to the state. Yes, next.
Item 21.
McLeod. Yes, what is this?
I'm appearing for the respondent number 3.
Yes, what do you want?
If I require 4 weeks time, in this case, they have challenged section 16 of the GST Act. So we require to file our.
Okay, 4 weeks time. For the 4 weeks time granted to the union for filing the affidavit. Yes, next.
Item 22.
May I please, Lord?
Yes, yes.
Senior counsel out of station, Lord.
Huh?
Senior counsel out of station.
Senior, what is the matter about?
Regarding stenographer, Lord.
Senior, what happened?
Selection and appointment, lordship.
Huh?
Regarding selection and appointment.
Manashwi Hazarika, what did the largest single just say? Do you have any idea?
No, sir.
You have the file, mister.
No, sir.
You don't have the file.
No, sir.
Your senior has not given you the file also. Under lock and key. Eh?
And my lord, the
In view of
private
the dismissal of
respondent,
board member appointing authority may proceed with the selection process available. Yes, what do you want to say? Yes.
the private respondents is already filed on writ appeal, lordship. This is by writ appeal number 326/22.
Why the private respondent has filed?
Respondent number 6 and 7, lordship, they already have filed on writ appeal.
What is that appeal?
326/22, lordship.
This along with next week,
Monday, Lordship.
Monday. Okay. This along with huh? Yes.
Deployed.
Next,
Item number 23.
union. What do you want? Yes, union. What is this?
Regarding Sainik school case.
Oh, Sainik school.
Yes.
Yes. What to do? Yes. Any?
Notice can be issued. I will
What
not.
notice? What notice? We are disposed of what notice? If we issue notice, nothing. What will you gain by issuing notice?
Because this interpretation of clause 3.32, that is also a factor. Because their entire stand. If a lordship kindly takes, my lord, page number 75 for a moment. Page number 75, my lord.
See, mister, you are want to argue, we'll fix for hearing. Let it come on after 1 month.
But only difficulty is, my lord.
It's up to you. We have given our opinion earlier, tentative opinion. If you are not agreeable, we'll fix the hearing.
If you're
Tell us, what do you want?
I don't want anything. It is their appeal. My only point is.
Agree with that opinion of the court.
Earlier opinion.
If it is agreeable, it is possible.
Because only thing is, because looking at the.
So what about you? She said the earlier opinion, yes. What about you? Tell us. We don't want to force you anything.
My stand is there is no infirmity in the order, judgment and order of the learned single judge. And no stay should be granted. That is my simple stand before your lordship today.
We are not granting any stay. We are upholding the order of the learned single
That's all,
judge.
my lord. And-
But since there was no challenge to the DP, that they will be allowed to
No,
proceed.
We can't bind their hands.
The final product, the final result of the DP was challenged. The
No, there is no final. They have not even
And
final.
the learned single judge
They
had said-
stopped halfway. They did not conclude. Did you
Single
conclude?
judge allowed it on the
No,
ground of
they have not concluded. Let them conclude.
If your lordship kindly turns to one page.
Oh, that even that finding, then we'll set aside that finding because that is contrary to records. Record does not indicate
No.
that this inquiry has been concluded.
If for one moment, your lordship,
Again,
one page, just one page, my lord, just one page, page number 76.
yes,
In which matter?
In this matter only, my lord, this writ appeal. Item number 23.
you're also appearing this.
Page number, yes, page number
Gitabali,
76. Page
yes.
number 76, the second paragraph.
76, yes, yes, yes.
They say in the page number 76, second paragraph,
76, yes.
it is their own affidavit before the learned single judge. That is what
Yes.
their stand is. It
Yes.
says, in the said rule, there is no provision of show cause notice to the cadets. On disciplinary ground, the principal can order for withdrawal of the interest of the school. And therefore, they have
Doesn't
issued.
matter.
That is
Obviously,
the-
show
that is
cause
the
is not
interpretation
required
of
for
the rule.
suspension.
That is what, no, not suspension, my lord.
See, in service law, is show cause notice required to be issued before suspending
Not
a
required.
person?
Not required.
Is it?
But before inflicting a penalty, show cause
No,
is
this is
required.
not a penalty. This is their case that you had applied for TC.
But then that was under compelling circumstances.
Whatever.
There's
So
a finding
therefore we are,
to that effect.
therefore we are allowing it.
Therefore, we are allowing the learned single judge order.
If you want to, if it is your argument that no, not only TC, that TC has been given as a consequence of the DP, then the
Yes.
DP has to be challenged, which is not a part of the written petition.
I have challenged the final outcome of that DP, which is
No,
the
no, no,
issuance,
no, mister, again you are.
which is the issuance of the.
Oh,
But
there was no
anyways,
final, there was no
only thing is,
finality.
There
They have
are
not.
two things. How will they respond?
No, but their stand is on disciplinary ground, they can issue transfer certificate,
See, there was no
That is what the
finality.
rule says.
taking recourse of clause 3.32.
That is what the rule says. You have
But
not
then
put the rule to
that rule
challenge.
has been interpreted by the
Your,
learned
your
single judge.
challenge before the learned single judge is that the issuance of TC on the
Yes.
alleged ground by the parents was under coercion.
Yes.
That is your short case.
No, my case is twofold, my lord. Number one, that TC was issued forcibly under compelling circumstances. To
Very
that
well.
effect, learned single judge has already given their findings.
And number
And
two,
number two, that clause 3.32 has to be read. Principles of natural justice has to be read into
We
it.
have to
Correct.
hear it.
And that is how the learned single judge interpreted clause 3.32. And
Correct.
therefore, the learned single judge
Correct.
said that
correct,
the
correct.
issuance of
It has
the
to be. Yes,
that
principal
imposition
lessons.
of penalty is wrong.
Oh, they have not issued penalty. They had, see, two things. Initially, they place you under suspension.
They placed me
In the
under
meantime, according to the school, you said, Baba, please issue transfer certificate.
suspension. According
And
to
okay, they said. Now they, after the transfer certificate, what inquiry they are going to pursue?
no, that is the
If
point.
they pursue the inquiry, obviously they have to give notice to you. They will have to hear you. They will hear you.
They-
They cannot
They
conclude the
say
proceeding.
They did not hear me.
No, they will have to
Clause
hear.
3.32 gives them the
Before-
The learned single judge, sorry.
So we'll say that they may conclude, but then after following the due process of law and principle of natural justice. That goes without saying, but we'll reiterate it. Therefore, they will not take
No,
any
that-
adverse action against you without hearing you.
No, that since that goes without hearing,
Ah.
the moment your lordship puts that in the order,
Yes,
it will give them an automatic handle. Like what the officer of
but they have
said
not
the other day.
concluded.
We'll clarify that they'll have to give you opportunities of being heard.
And they
You
should-
want to say that there should not be any inquiry now because it has been set aside.
They are free to do whatever they want.
And then let him.
They are free to take de novo, they are free. But then your lordship will not give them any kind of handle. That is all I'm trying to say, man. Because one word, one sentence, they will interpret in a very wrongful manner. That is all I'm
See,
saying.
mister, you are, see,
This
you,
is up to your lordship, my lord.
no, we will hear you.
Can't dictate.
No, no,
He
I'm not
orders-
dictating.
We'll hear
I'm
you,
not dictating.
Mr. Counsel will hear you in the next month. We'll hear you. In the meantime, you will proceed. In the meantime, if you are not, we
No,
can
no.
hear you.
Up to you, up to your lordship.
Again, up
But
to you,
only
up to you,
thing,
what
only
you have
thing is
to
no stay should be granted. That is all my humble prayer.
Oh, what we are, when we are allowing the appeals, we are dismissing
Yes.
their appeals.
Yes. In that case, I'll have nothing to say. man.
We are dismissing the
Then I have nothing
appeal.
to say.
Only thing is that they will also have a right, to proceed. We'll say that nothing there will nothing prevents him to take appropriate action in accordance with law. Is it okay?
That line is not.
We'll give you some more time to make up your mind.
You
But
have
that
make up
line
mind.
is
You
not-
see.
But anyways, if your lordship is dismissing, I have nothing to say, my lord. I have nothing to say. If your lordship dismisses, I have nothing to say.
You are dismissing it.
No, my lord,
But-
that observation may be stated,
Oh,
my lord.
it goes without saying, whatever, because since the since the issuance of the transfer certificate was not a final consequence of a departmental inquiry which has not been concluded,
Yes, my lord.
the authorities will take as appropriate as per law.
Yes, my lord.
That's all.
Yeah.
It's okay. But you don't ask more than that.
No, I'm not asking.
We are going to
My
refuse.
only concern.
Any other further, we will going to refuse.
I'm candidly submitting before this honorable court. madam.
Next.
My only
Madam,
concern is they
item
might
number
take in the
88 is-
vindictive manner.
Yes, appeal
88.
also heard, sir. Appeal allowed.
Mas-
Sorry, appeal dismissed.
That may be, the.
Okay, we
Okay,
dispose.
yeah, maybe.
We are not interfering with the direction of the learned single judge. Since the transfer certificate was not issued on culmination of the inquiry which was initiated by the authorities. We leave it to the school authorities to do the needful in accordance with law.
And the
Must apply, sir.
transfer certificates will.
However, transfer certificate will stand,
Will not be.
no, since cancelled. Send cancelled.
He should be allowed to resume the classes, man.
Yes, they shall be allowed to resume the
Please,
class.
before your lordship, man.
Yes,
Why do you
yes.
have to bring him to the
Oh,
court?
I didn't.
Why you shouldn't bring? No, no,
He's
no.
very anxious.
Mister,
Don't
Mister,
resort to
don't
those
resort,
tactics.
because see, first of all, these are borderline areas of POCSO.
Don't.
And where
resort
the
to
law
those
mandates that
tactics.
the identity of shall not be disclosed. Okay. So they should have brought. In fact, we didn't in fact want to
There is no
mention
order
the names.
directing. There is
We
no
are
order
content-
requiring his presence.
In fact, we are contemplating that then their names shall be
Right,
deleted
is
from the
always
record.
there.
Okay, leave
We
it
also
for. The
wanted
names
basis.
of the
If your lordship had some
names of
query,
the
you could have-
students mentioned of shall be deleted from the record and they will be represented by so and so XXYY ZZ. We don't want to see.
But only thing is they should be allowed to resume.
Yes, yes, they will be allowed. Huh?
That
Allowed,
also
yes.
reflect in the.
Yes, yes. The students shall be allowed to resume their the suspension stands revoked.
Suspension.
Huh?
Yes, but TC required.
The TC stands revoked, TC is revoked and they shall be allowed to resume classes.
Obliged. Diploma.
Item 88 and 1,
Yes,
production list 1.
Yes, ma'am.
Yes, yes, next.
Same, my lord.
Oh, that same,
Yes,
same order,
Yes.
same order. Well, three appeals now. Yes.
Item number 24,
GR engineering, what is this engineering?
My lord, in this case, the bid of the private dispensary was rejected on the ground that, on the day of the financial bid. His financial bid could not be opened because he put a password,
He
put a password therein
put a password in the,
on the financial bid.
okay. That was only he knew, he was not.
Only he knew. Lord.
Okay, then,
Now, there was a condition in the tender document itself that it should not be, no password should be there.
okay.
In spite of that, he put the password. 26th December, the bid was opened. His bid could not be opened. And thereafter, subsequently, he on 27th, he provided the password. And thereafter, on 2nd, it was opened. And the non-single judge, without issuing notice on the motion stage itself, has directed that his bid, whatever was opened, may be considered. I was the person in whose right, the legal right accrued because of the rejection of finance bid. Now, assuming for the argument's sake, if anybody puts a password 26, he knew the bid, whatever was there. 27th, he provides the password. Anything can be done. Anything can be done. That's why he said that no password should be there. And non-single judge, how non-single judge can pass an order allowing the petition, directing the Numalika refinery that by price bid, whatever was subsequently opened, that should be considered. 26.
Don't ask that question to us, how to learn a single, that we can't say. That you can simply say that perhaps it was not. You can't ask why the learned single
No, why?
did that.
Say at the motion stage, when the petitions are filed, can without issuing notice.
You can ask that question, but just can it be done like that? But you can't say what the learned single just say. Yes. Because yes.
My lord, I'm appealing for the refinery, my lord. We have filed a review against that order, my lord, which is listed today before the learned single judge.
Review for what?
Reviewing of the order, my lord. What has happened actually?
Review
My-
for what? For what purpose?
Because the direction was to the private respondent herein, my lord, to submit a representation.
So you file a review
for
and
recalling-
he files an
Writ
appeal. So what do you do?
My query is that, since the order has been passed without hearing me and the direction is issued, matter should be demanded back to the single judge. to hear the matter on merits first.
And on what is the review you are seeking?
That is the prayer.
The same thing.
That is the prayer.
So we are,
My lord, we file a writ petition.
you are that
Writ
password, huh?
Yes, we file a writ petition before this honorable court. Our whole case, there was two bid system, one is techno-commercial bid and one was the price bid. Once you qualify techno-commercial bid, my lord, it is mandatory on the part that the NRL has to open the price bid. Now, in respect of,
But in any event, very good. You have a very fantastic case.
no, but
Can the writ be allowed?
no, where is the question of allowing a writ? How
You
he
see
not
the order?
In a motion, let
My
us see the
lord,
order.
I'm-
No, we'll hear, but can a writ petition be allowed on the motion
No,
on
my
merit without hearing
Why?
any
I'm
party?
telling Lordship,
Let us see the judgment.
Page
Lordship, why?
We'll hear Mr. Das, we'll hear.
Page 34, your lordship.
Page 30,
34
page 35.
and 36, your lordship, similar.
Upon such a rejection is procedure opening, the court considers that it would be in the direction to approach authorities, consider the bid as a bid could be opened prior to issuance of email.
Under such circumstances, as the rejection order proceeded with the opening of the price bid of the petitioner, the court is of considered opinion that it would meet the ends of justice to direct the petitioner to approach the respondent for consideration of their bids, as the price bids could not be opened prior to the issuance of the email reference. On such representation being made, the respondent authorities shall take note of their instruction that the price bid could not be opened prior to the rejection of the price bid of the petitioner, and the authorities shall take a decision in accordance with law. If such application is made, the respondent authorities should consider the same independent of the rejection of the email dated so and so. So rejection will go.
It amounts to some
lord.
on merit,
My lord,
quasi merit,
No,
quasi merit,
kindly see para 3.
not full merit,
No, no,
quasi merit.
Kindly see para 3, my lord. Para 3 at page 36. Why? Without entering into merit of the writ petition and the submission and counter submission made by the learned senior counsel for the petition learned counsel respond number 2, it would suffice to record herein that on a pointed query of the court, upon instruction, learned counsel for respond number 2 has submitted, he has received instruction to the effect that a price bid of the petitioner could be opened after receipt of the password from the petitioner. So what I say.
Correct. Therefore, according to the appellant, how could this respondent number 2 do so? That is contrary to the terms.
No, not there is
So-
there is no contrary to the term.
No, that is correct. Had this order been passed in his presence, there was no
No,
problem.
there is. There is.
You
we are
make
not
him
asking-
a party,
we
then
are
it's a court, respondent number 2 who doesn't represent the interest of respondent number 4 says, we have no objection if you can produce, fine, no problem.
No,
Had it been confined to you and respondent number 2, there's no-
How can he, my lord, how his right is affected?
My idea.
he's a bidder.
I'm.
He's a bidder,
he's a
fine.
bidder.
You even said 1-1-4,
There is not a LOI.
equality clause.
My lord, LOI has not been issued. to
Doesn't matter,
anybody.
doesn't matter.
Price bid doesn't.
Doesn't
mean the
matter.
final.
It starts from the very
I-
stage of consideration.
But
The
he-
consideration must be
but-
equal footing.
No, not my lord. It is the has to be done, assessment has to be done by NRL. Which is why they have also filed a review. That's why I'm saying. They that filed a review, my which lord, means. What I'm submitting, my submission review petition has to be heard. If review petition is allowed, then the. review
No, my
petition
right
will
will
be-
be
will be
same.
recalled. Recall, we made a party. We have made a party. My lord, let the appeal. My submission.
Or what we
If
can
he
say,
wants,
Mr.
let him
Das,
go
what,
before the
okay,
learned
fine.
judge.
Mr. Saraf, go to the review.
Yes.
We say that nothing
Yes.
will be decided without hearing you.
Let it.
We'll say that nothing
Yes.
will be heard, therefore this order will remain stale, will not be acted upon. Then what else is there, Mr.?
Well, I might say, right?
That is what will maintain. Otherwise, they will go ahead, my lord.
Please, they will, first to get your order,
Yes,
just type
yes.
up on the motion stage unheard of, and now you are saying that
Don't say unheard of.
unheard of. I
Don't
never
say
seen that
unheard.
type of order.
Yes.
This is unheard of.
Yes.
Please address us, then you can talk in the court, bar room, no, among yourself, you have all the time to talk to each other. Please, yes,
Tea and everything.
yes.
Well, the respondent, he has made me a party in the petition, the wrong name, wrong address. Now, assuming the Malika defined as filed a review petition, whether my right will be taken care of in the review petition? My right so far as that was finalized, that how that can be there, my lord? How once the rejection order was passed, if it is to interfere with, without issuing notice, without hearing me, can the learned single pass the order?
Let them file an IA, my lord.
Review is also the different thing.
Move it, IA.
When I am the review.
They can file an IA. In
Lordship
the
always
review
said
Okay, fine, whatever you do, as far as the review is not before us, whatever we cannot be decided by the review jurisdiction, because review jurisdiction is of the learned single judge. And we are dealing in the division bench, an appellate authority. Do whatever you want.
May I submit, my lord?
Yes,
My lord, any delay, the project suffers, my lord.
doesn't matter what to do.
So, my lord, my
Doesn't
respectful
matter.
submission is, lordship allows the appeal, remands the matter because in
Learned
that.
single judge, we have to remand to learned single
My lord,
judge.
my review becomes infructuous then.
Whatever that is,
My
we
lord.
don't know. Don't mention about your review petition. We are not
Lordship,
concerned.
allows
We
the
are not
review
dealing with the review petition. We are not in the review jurisdiction.
Let the writ petition
We are only
not be
the
read, my lord.
appellate jurisdiction.
The review at yourself, Krishna,
My lord,
asking for a moon. And you are,
don't use this all these words.
Had Mr. Learned Senior Counsel for the appellant, also Learned Counsel for the state as well as
When you are hearing about a stay application. That's my lord, your lordship.
what state
It
application?
is Status quo as on today's.
We are disposing of.
Disposing it, okay, fine,
We are disposing of. We are disposing of. We were remanding Learned single judge.
fine, fine,
That-
fine.
And Mr. Learned Single also sabka naam likho, so. The present appeal has been preferred against the order dated 6/1 to pass the Learned single judge in WPC number so, by which the Learned single judge, after making certain observation on the basis of the submission made by the Learned Counsel for the respondent number 2 therein. Respondent number 2 therein is the respondent number here?
Three here, my lord.
Here 3. Respondent number 3 within bracket, respondent number 2 in the repetition, to the fact that that it would suffice to record herein that a point that upon suffice that that he has received instruction to the effect the price bid of the could be opened after receipt of password from petitioner, has disposed of the petition in the with the following order and type the entire order. We have the view that though any matter could be disposed of at the motion stage also, but yet if it touches upon the merit of the case, even slightly, we have the view that in such circumstances, the other parties also ought to be heard. In the present case, the present appellant was implemented respond number in the repetition. 4 was a bidder and had every right to be heard before any observation is made, which would have the potential of impacting the merit of the case. We find that that the submission advanced by respondent number 2 therein has the potential of affecting the merit of the case. Under circumstances, we are satisfied that the appellant has right has been can be said to be prejudiced to the extent, and accordingly we set aside the impugn order so and so, and we remand the matter to the Learned single judge for fresh reconsider after hearing all the parties.
But status quo as on today will maintain. Otherwise, they will go ahead.
What we have set aside.
No, set aside means the entire thing is gone.
We have set aside this. No, we have set aside this order. We are not setting aside the proceeding of your tender.
No,
Tender is not being challenged.
No. Not tender.
We are setting aside this order.
No, set aside order means that they will revive the impugn order is revived.
Single judge for passing any order.
We don't know what that.
No,
that
my lord will kindly see. My lord kindly hear.
Yes. No, what?
One moment kindly, my
Well,
lord.
yes.
My lord will be prejudiced.
What in what way?
My lord will kindly see page 45. Kindly see the order.
Yes, page 45. Yes.
Order to go. Impugn order kindly see, my lord.
Page.
Yes. 34 is the impugn order.
Page 34.
Yes.
Yes.
69.
My lord, 34.
Yes.
First, your lordship, if it's not troubling your lordship, page 69, my lord.
Yes.
69.
Yes.
My at page 69
Yes.
is the price bid.
Yes.
My lord will kindly see. Email kindly see on 27.
Yes.
27. Down below, we checked again, your lordship got it. We regret to inform you, that your price bid cannot be considered
Yes.
for further.
So we say,
Regulation.
Mr. Yes, correct.
As the
We'll protect your interest by saying that this is your grievance. You shall be. You can certainly raise this grievance also to the Learned single judge for appropriate
Yes,
order.
but they will not go ahead with the contract.
When we are
Because they-
remanding,
Because the matter was
not
decided
we cannot decide on merit.
No, what is there?
We are remanding.
No, what is there?
We
Suppose
will not pass any order which is to be passed by the Learned single judge.
My lord, this will.
We are putting you in the back to
No,
square one. you agitate,
No,
you
no.
raise all the
That-
orders, you seek all the protection from the learned single judge. You are putting back in the same position where you
My
filed.
lord,
Let us assume that you have filed learned single judge.
no, my lord.
You,
No, what is there, my lord?
the learned
Why?
single judge is at liberty to pass any order he may deem fit, but not this
My
order.
lord, let this matter be listed on Monday before learned single judge.
He will be listed,
Yes.
fine, no problem.
No,
Okay.
no, my lord, what will happen?
Consider, we can say yes,
No, no.
considering the urgency of the matter.
No, what
so
I am
we
saying,
can,
if your lordship set aside this order,
yes,
set aside this order,
yes.
then what will the effect? Effect is reviving the earlier order, rejection order. That will stand.
Oh,
Then they
I
will go
don't know,
ahead.
Mr.
No, your
Das, how
lordship
can
will-
you, how
There's
can
no
you?
question of-
No, we are not satisfied with this, we satisfied.
No.
What consequences we have, it is you to find a way out to protect your own interest.
No.
As far we are concerned, we are not, we don't think that this can be sustained.
No, that is, my lord, what I am saying.
So
that
if you
there
want
is-
to protect your interest, immediately go to a learned single judge, say that, and therefore we can even fix it, place it before the learned single on Monday. You
But they
can
will-
raise it.
But they will, if this order, they have come for review of the order. No, my lordship will kindly just bear it for a moment, my lord. The order, that order was.
Review
passed-
will not be heard unless you are also heard.
No.
In review, maximum what they will do, we'll say we are remanding, what
No,
effect will
remanding-
have, we are remanding for
remanding.
fresh reconsideration.
Remanding, let this order remain. They will not be affected.
Sorry,
They
we
will not.
will not do that.
They
Sorry.
will-
We have heard you, heard
My-
Mr. We
Kindly
have heard
hear
you,
it.
Mr. Sorry.
My
We
lord,
cannot
your
go
lordship
beyond
will
this.
just hear me, my lord.
No, we have heard you, we have heard you.
No, I have to submit, my lord, because.
Submit.
passing Order,
Submit.
setting aside that order, my lord.
Yes, submit.
That will be, will prejudice by this
Yes,
order,
I'll
my
submit,
lord. What I am saying,
Yes,
submitting, my lord.
you submit, no problem.
Then, my lord, they can reject this bid only on the three conditions, my lord.
You are asking us to
Lordship
look
will
into
not-
the, no, you are asking to examine the merit.
No.
We are not at all going to examine the merit.
Just has not said that without going into merit of the case. My lord, just see the facts, what has happened, my lord. My lord, what I am.
You may have,
I am
Mr.
asking-
Das, you may
I'm
have the
asking-
best of the case. Even the best of the case, without hearing that aside,
No,
we will
I-
set aside. That's all.
No,
We are doing that, nothing else. We are not touching on a merit. Yes, you have a very good case.
no, I'm.
But
I'm
the
saying-
manner in which the
Right,
learner
right.
single
Your
has
lordship-
decided, that is not
No,
correct.
what
That is
I'm
what we
saying.
say.
I'm saying, my lord. Your lordship is right. Your
Yes.
lordship will may set aside this order.
Yes.
Only my apprehension is that they should not go further, because I'll reverse back to the original order whereby rejection.
It was there when you, before you filed a writ petition, what was your position?
My position was that I came up for stay of that
Very
particular.
good,
rejection
you
order.
seek for the stay in
No, that's
learner
why-
before the learner
No,
single judge.
that's why the learned single judge has passed this order, my lord.
But then since it is
Right.
defective, we can't.
Well, I am asking myself. So how the right is affected? Because the price be, finally it is not been decided. Further abolition is there, my lord. I'll show
Okay,
it. before
Okay,
this
we'll
court.
record your
No,
submission.
I'll show before this court. my
Learner
lord.
Singh, Mr. Das, Learner
Lord,
Singh,
your
counsel
lordship
for the
can
rest. No,
My
no,
lord,
we'll record your submission,
Can you
but we
see-
are not going to pass any order. You agitated before the learner single judge.
But if your lordship set aside this order.
Yes,
then what
obviously.
means Then what in my case, review also is allowed, meaning there were review is allowed. When they
What,
file a
we
review.
never said a review allowed, we
No, it
don't
will
know.
automatically
They're all
allowed.
contingent, I don't know, somebody making submission, the reviews file, we know, we are not before us.
No, your lordship has to look into it.
restored back
Yeah, respond.
No, review application will be.
petition.
Writ petition will be restored, it will be listed for motion, and you seek any of
Review,
prayer.
your lordship is indirectly allowing the review application here.
No, I don't know, we are direct, indirect, we don't know. It's not before us.
No, lordship will see.
We are not concerned with the review petition, we don't know it is not before us.
Making a statement, my lord, senior counsel, my lord, a review, a 6/1/2023, there is an order passed by this court, passed by the learned single judge.
We'll see that, we'll say the learner single judge will
My
consider
lord, They
the.
have come for a review against that order. They have come a review against that order.
Mr. Das
Suppose-
will remand to on Monday, you may plead whatever protection required, learner single judge will consider your case, whatever
But
protection
whatever,
required.
they may go ahead, that's the only protection may be given, my lord. Kindly pay.
We'll on Friday, We'll Friday, you
My
go,
lord, Page 69 kindly be see, my lord.
Friday.
Page 69 kindly be see, my lord. Place 69 status quo as on today, my lord. Let it be set aside, but at page 69.
See,
kindly
on
be.
this day, on this, when 6/1/2023,
Yes.
the learner single judge also did not pass any status quo order. That till you consider, same issue will be,
No,
no,
it's right.
no, then
No.
why should we improve upon the learner
No,
single judge also? You are not, the learned single judge did not give any status quo order also.
I
The
didn't
till
require- I
consideration.
didn't require a set
That
order.
you ask for it
What
on Friday.
asked for
We'll remanding it to Friday. Yes, likho.
My lord,
Learned
then
Mr.
it is
Digonta
set
Das.
aside. Your lordship is allowing the review application here.
We don't know
itself.
about, we don't know about
No,
the
your
review.
lordship it's a fact. Your lordship is allowing the review application.
No,
Yes.
I don't know.
No, your lordship.
We are remanding to learn a single judge, that's
What
all.
is the order passed on 6/1/2023 is the order passed by learned single judge.
Yes,
NRL has the review of that order. Your lordship is setting aside that order.
that
Second-
review, whatever that review, has it been numbered? Have you
Yes,
filed?
it is-
It will be listed. It will be
It
listed.
is listed.
It is listed, fine. Where it is listed?
Today itself.
Very
Item
good, very good.
59.
Let it be, has a notice has been issued? Then,
Today it has been, they have filed an.
no, where it was filed?
It was filed day before yesterday, my lord.
And it is listed
It is
today.
listed today.
And what is the order passed?
No, my lord, it has not yet
It is
reached, my
not
lord.
yet
No,
reached.
we'll
So they may
request,
record
we'll
this
request
order,
that,
my
we
lord.
will request that learned single judge to consider this together. That's
Yes,
all.
They may recall this order.
Yes.
My lord, the
Report
moment
it.
lordship sets aside that order, my lord, my review is become infructuous.
What remains with you, my lords?
You are sending back, you
I am
manage.
very happy, my lord. Lordship, I am saying, my lord, but what I am saying, so I am agreeing to it, my lord. Mine is that without hearing, right, correct, my lord.
Yes.
It should go.
How are you prejudiced by
No,
this
no.
order? I mean, by setting aside this
No,
order?
This order is set aside. My lord, what I am saying, that it will amount to rejection and they will take an action. What I am
Rejection
saying,
of what?
They will give a, from a prize bid will not be considered and an award will be given. This is what I want, my lord.
Mr. Das, you want us to consider on merit. How can we do that in this, after we have decided not to hear at all? Then it will be as good as deciding on merit also and remanding. How
No,
can
no,
it
your
be?
lordship will kindly.
No, you have faith in the learned single judge. He will pass appropriate
No,
order
no,
for your
what I'm saying-
protection.
No, what I'm saying.
Nothing will
No,
happen.
no, what I'm saying, 6/1/2023 is under challenge. 6/1/2003, they have filed a
Mr.
review.
We
If
don't,
your lordship is setting aside that order, is amounting allowing the review application.
I don't know. Your
No, your
interpretation,
lordship
we
is
don't
not-
agree with that. We don't agree with that. We
That's
don't.
the statement I'm making, my lord. I call for the review application.
This part, it decided whatever findings are there.
No, my lord, if your lordship. Review application will be allowed.
Mr. Das, Learned Senior Counsel appearing for the private respondent number
One, man.
1 submits that if this order dated 6/1/2023 is set aside, his interest will be greatly prejudiced in as much as he was already disqualified by, what is that page 1?
My rejection,
Page
69.
69.
page 69.
Email dated,
69,
27 of
bid was already disqualified,
my lord, my
disqualified.
rejection is on
His bid was rejected
on 2nd of January.
on 2nd of
January.
which was the situation also obtaining before this order was passed. Be it as it may, he would be at liberty to approach the learned single judge for making appropriate for necessary prayer to protect his interest. Full stop. Accordingly, we remand the matter to the learned single judge, Lingada, considering the urgency and the nature of the case and the urgency involved in the case. The matter be placed before the learned single judge on Monday. Writ petition is restored to the file to the learned single judge.
I'm obliged.
Appeal is allowed with the above
It will
observation.
come as a motion item.
Higher disposed of in
It will
terms
come
of.
as a motion item.
Sorry.
It will come-
Motion. The motion still, yes,
Supplementary cause list for admission, item 89.
89. Yes, what is this 89?
Wait, please, Malad. Malad, on the last occasion, I had supplied copies, Malad, of the judgment. Two similar,
I have to take inspection from the department also, my lord. Kindly give one day, my lord. Only one day, my lord.
Okay.
2-3 matters disposed of.
Yes,
Which
my
one,
lord.
which
that's
one?
fine.
Matters, my
Only
lord.
one day.
Post office.
the appointment of GDS VPN, my lord, Gramin Dak Sevak, my lord.
Maybe next month.
There were 3 petitioners, my lord. 2 petitions have already been disposed of and they've been directed to be reinstated with back wages. For similar circumstances, my lord,
Yes, what is that?
even the chain of events are similar, my lord.
Yes, yes. Yeah.
And the other 2 judgments are already appended to the writ petition, my lord.
Six on that matter may be disposed of, my lord, on the on
On the last occasion, I had supplied extra copies also of the judgment
27 of
for her perusal, my lord.
But why? How will it make any difference?
I have given to the authority, my lord, is also, my lord.
What authority?
Do you have
a copy of the pleadings?
Yes,
You
ma'am.
go
Yes.
through and read the order and tell us whether it is
Yes.
covered.
Only one day maybe accommodate, my lord.
Oh, you could not go through because the, okay. If
Only-
list on so and so on the prayer is there. Yes, next.
31-1.
My lord, fixing a date, my lord.
Yes, next.
Item number 90.
My lord, this is against the disciplinary proceeding wherein I was set aside. My lord, then, my lord, the order was interfered with. They have filed an appeal. Yesterday evening, my lord, I got the copy of the appeal. Only prayer, my lord, we'll have it on Monday, my lord. I have taken a consent from
Monday.
Monday. Much obliged.
Next.
Item number. For orders, item number 25.
What is this? Assistant Director.
FSSI will not read appeal, will not be service report awaits will not.
Okay.
I'm appealing for the respondent.
All respondents?
No, only one, your lordship, respondent.
Mr. Sunjay appears for respondent number,
Respondent number
One.
one, your lordship.
Await service to be in respect of,
You are appearing for respondent 1.
One. Middle.
then service complete only one. No, another.
Another pro forma is the Union of India.
Okay.
One is private
The
respondent.
who is to be served? Await service to be in respect of respondent number?
One. My appeal equals to one.
Then will not, the service is complete.
Okay, service complete. Then,
Because 2 is union.
yes, tell us then what to do, tell us.
Will not, may fix for admission here.
Okay. What admission hearing? You know hard. Assistant Director, we have challenged what?
Will not, single judge order will not, he was, will not, his service was discontinued, because of his,
And then what did Lana Single just say?
said will not, to continue his service.
Okay, very well, we'll hear you. Have Mr. Lana counsel for the appearance on the net, the matter be listed for hearing. Yes, next.
Will not.
Since the
26.
parties are- yes, next. 26, yes. Dipankar, yes.
37, my lord.
In respect of respondent number
7.
7, who is respondent number 7? Who is respondent number 7? Take step,
Smriti Alpana Barua.
huh?
Alpana Barua.
Who takes step by Dusty? Have you taken by Dusty? No. Huh?
Yes,
Then what happened? Earlier, there was a direction for taking Dusty. Did you take?
the postal service. and-
Oh, Dusty, not postal service. Did you take step by Dusty?
No, my lord.
You take by Dusty and keep on since 2018. Next one, number 7.
Appellant directed to take steps by Dusty to be registered.
Next.
Item 27.
Mizoram. Yes, madam.
They have
Not
come
well,
up to
counsel
kind of
not
a-
well, okay. Mizoram, all lawyers are not well. Sister, what to do?
Lordships,
Okay.
certain respondents remain unserved. Your lordships, 3 weeks time may be given to take fresh steps.
3 weeks time granted to the applicant to take fresh steps. Yes.
Item 28.
Dilip. What is this? Yes.
Senior counsel, Mr.
What is the case about? Tell us.
This regarding the appointment, my lord.
Appointment, what?
To compassionate appointment.
So,
A post was vacant.
Huh?
When a post was vacant.
And then?
But the petitioner was serving in the was far long than the.
Considered afresh. So what is the problem? It would be in interest if the claim response is considered afresh with 11 terms. Why you are coming? Who are you?
I'm the appeal, the case
Who is
was-
Dilip Kumar Ghosh? You are Dilip Kumar Ghosh.
My lord.
Then what is wrong?
My lord, no, my lord,
You mean to say there was vacancy?
there was vacancy, my lord, but the vacancy was supposed to be filled up by the person through compensation appointment. We had challenged that. Well, 2 weeks time, I will grant them, Mr. Council. will take this, my lord. For
Okay.
further hearing, my lord.
Okay. On the problem. Yes, next.
Item 29.
Vishnu.
In this case, my lord, notice could not be served on respondent number 6 because he has retired and address change. We have the address, my lord, which furnished to the address
Fresh step to be taken for sufficient notice upon the
6. Will furnish. to the
respondent number
6, my lord.
6 in the new address. Yes, next.
Item 30.
Yes, Vishwajit Das. Yes, anybody? Yes.
Lordship, in this case, I am appearing for the opposite party wife. On the time and again, directions were made to the appellant for depositing 1 lakh rupees. Lordship, kindly peruse the order passed by this.
Who is for the appellant?
No.
Appellant was directed to deposit.
Yes, Your Honor, they have not deposited even when the matter was dismissed for the.
Why is the appellant? Why he is not depositing?
I am appearing, but my lord, 2 weeks time may be allowed.
What 2 weeks time?
In the meantime, my lord, some talk of compromise has been made.
You first deposit and you compromise.
Yes, my lord, 2 weeks time may be.
No, why are you? Your appellant, who is the resident? No, why is the where is he staying? Appellant.
Guwahati, Your Honor.
You appear Monday. Ask your client to appear on Wednesday. Let the appellant appear in person before this court on Wednesday. Yes, next.
Published.
Item
Next.
31.
May I please, Your Lordship?
Yes.
2 weeks time may be granted to take fresh steps, Lordship.
2 weeks granted to. Yes, next.
Item number 33.
Gitanjali, yes. What is this matter?
My lord, already respondent has appeared, my lord. And now there is a sorry, I am, my lord, for stay, my lord, stay of the order, my lord.
Stay of the order. What is the order passed?
On, my lord, it was passed on 31/5.
What was the order? What is
Order
the-
was that the appellant filed a divorce.
It was allowed?
So no.
No, it was.
It was not
It was
allowed.
not
She
allowed.
Asked to restore conjugal right with the
We have
respondent.
filed one counterclaim, Your Honor.
But she also
Restitution of conjugal right will
on
stay
that
now.
ground, my lord.
So you don't want to go to him?
Yes.
Okay. Status quo as on today.
Ali, Your Lordship.
List is switched.
Item 34.
Asif Ali,
Please, steps taken.
steps taken. Notice receipt? Sir, no. You should check, mister. You have taken the step, you should check. Learned Council of Appeal shall serve a fresh new address of the appellant. Have you furnished a new address of the appellant?
Not at
Hmm?
this moment, not get the receipt, but I will collect.
Okay, collected.
I think someone appears. I think your Wahalat number is right. As per the occasion. It's not 6-1.
Wakalanama file, same place record. Hemlota Rahang, who is it? Wakalanama, Wakala is in file. That's one number 2.
Yes, sir.
Name is shown.
Okay.
This is by showing the name of the council for the respondent number 2. Yes, next.
Item 35.
Appu. What is this? Yes.
My lord, matrimonial suit of the appellant was dismissed, my lord, expiring, my lord. Before the family court also, my lord, the respondent did not appear, did not participate, and ultimately, my lord, suit was considered expired. Here also, my lord, I took a step from the respondent, but perhaps, my lord.
Neither unserved AD card received. What to do?
But the
Ex parte.
address is correct at this point.
You want to take Dusty?
Dusty, take
Dusty.
Take Dusty.
Perhaps it will be very difficult to actually enter the village, my lord, where my wife's reside, because I have some security threat, my lord.
Then what to do? Then let Kameshwar borrow. Will remain like this.
My lord, through police station, through my lord, local police station, that can be done.
we can.
Otherwise, my lord, so far, I have the instruction of my appellant, my lord. The respondent wife, my lord, she is very much aware of the proceeding, my lord, pending before this court, because during pendency of the appeal, my lord, she also filed one FIR, my lord, before the local police station. So ultimately, she is not appearing before the court, my lord. Even before in the family group also, she didn't appear to proceed expertly, and here also, my lord.
You get a, see, post office,
My lord.
you get a report whether it has been served or not. Huh?
Lord.
Appellant may furnish report from the official website of the postal authorities as to whether the register post has been served or not. Huh? You see that they also find out, no?
Otherwise, my lord,
No.
I can
Okay, you see that if it is shown served, then we'll see.
Lordship.
Yes, next.
Item 36.
Yes, yes.
Lordship, the correspondent had filed an affidavit on yesterday. May I please, this matter will be taken up after 2 weeks, lordship.
I have filed a affidavit.
2 weeks granted for filing rejoinder affidavit. Yes, next. To the appellant. Yes, next.
Item 37.
Yes, yes.
Lordship, earlier LCR was called for, Lordship.
Yes.
LCR has been received, Lordship.
Yes, receive,
It
yes.
may be fixed for hearing, Lordship.
Lordship, I am for the wife, not a single penny has been paid.
Why you're not paying? How much is been directed? You pay, otherwise you appear.
17 lakhs, Lordship.
7 lakh.
7 lakhs you
Permanent
keep.
element,
Huh?
Lordship.
Doesn't
Permanent-
matter, you give something.
Something, lordship.
How much will pay?
50%.
Lordship, I have to
50%.
Take instruction, Lordship.
Take incentive, no, ask her to appear. Ask him to appear before this court. We'll not take all these things. You can't just keep on filing cases and cases, marry and divorce and all those things. No, sorry. Ask him to appear before we'll hear him in person.
Lordship.
Let the appellant appear in person before this court on so and so. Tariq Didu beta.
What is that?
Where is he?
Lordship, the stage and seal, sir.
Silja, ask him to come. At Tariq Didu bo.
6th February.
Yes.
Lordship.
Oblige, your lord.
Item number 38.
Wait, please, your lordship.
Yes, item number
38.
Item number 38.
My
Okay, yes.
I had filed an application for divorce. Along with that, I filed an application
Yes.
paying for maintenance, the interim and the final. Under sections 24 and 25 of the Act. It was rejected on the count that both cannot be filed under the same application. The order at page 15, you know.
What is the other respondent doing?
He has a share in the family business, a jewelry business. No,
You have been, that divorce have been granted or what?
no, no. We have filed an application. Along with that, we filed an application for maintenance, permanent and interim. Under 24 and 25, the learned family court proceeded on the premise that cannot be given in the same application. There are judgments to show otherwise, my lord. Interim is initial, final is upon the grant of the decree.
Okay, we are disposing of.
My lord, lordship.
We are disposing the learned,
Absolutely.
family court will decide.
No,
Family court will decide on the basis of record.
absolutely, on the basis of, on the quantum of
Whatever,
maintenance.
whatever. Record, the records are not before us.
So far as this application is concerned, it was rejected on the count that
Therefore,
both
we are
cannot-
allowing,
Absolutely.
so you re-agitate before the
Lordship.
land. No?
My lord, one small submission. My lord, for the family court to invoke the jurisdiction under section 25, my lord, there has to be a decree, my lord.
See,
I don't
we have
know.
filed a application for divorce.
My lord,
The application is pending.
pending
And in the meantime, we want some maintenance.
maintenance.
That will be considered by the court, whatever merit.
Absolutely.
Maybe say, no, you are under, whatever, that we are not going to say enter into
But
that.
24, 25 can be filed under the same application.
Whatever, that
That's
we are
all.
not making any observation.
If you are relying on any judgment, you can permission.
You have any judgment?
Yes, yes.
Give it.
I've already given over.
Okay.
The relevant paragraphs would be. I'll indicate, you know.
Just indicate in
Para number.
The Allahabad High Court is paragraph 11. And the Bombay High Court is paragraph 22. It makes it clear.
Yes.
That's all. Obliged.
Okay.
Next.
Item 39.
What is this?
Lordship, I'm appearing on behalf of D Decca, your lordship. They are
What is this PL?
They are supposed.
What is this PL?
This is.
Your lordship seeking direction to alter, modify, change, remove the mandates of the mentioning and endorsing original place of birth in cases of domestically adopted children's while applying passports or birth certificate.
Have you filed some file?
No, lordship, I'm awaiting my instructions.
Okay, how long will it take?
Lordship will give me 3 weeks time.
Okay, further 3 weeks granted to the union respondent to file their affidavit. Yes, next.
Item number 40.
Review, what is this? Anybody for review? No, no, appears for the review petitioners. List up there again. You're there? Yes. Yes, tell us.
Appearing on behalf of Mr. P. Mahanta, is the amicus curiae, Your Lordship.
The review is filed by you.
No, Your Lordship. Mr. P. Mahanta is just the amicus curiae, Your Lordship.
Amicus curiae.
Where is he? He
Yes,
was
sir.
here a while ago. Where is he? Where is he?
Lordship, the matter will be adjourned.
Application or petition review of the one show called dishonesty. Okay, this up to 2 weeks.
Much obliged.
Yes, Nick,
Item 41.
you know the video, what is this?
My lord, this is an appeal by the railways, whereby the writ petition was allowed, directing railways to hand over possession to the respondent of their land. My lord, it is out and out a civil dispute, question of right title in interest was decided. My lord, all the respondents are served.
Case may be fixed for admission any date.
All the respondents are served. During pendency, my lord, respondent number 2 and 4
Is
died.
there any stay order?
My lord, on
No, my lord.
10/6/2022, your lordship passed an order to maintain status quo.
Oh,
10/6. Lordship may clarify.
Status quo is there, what clarification?
But,
Status quo,
Lord,
which status quo?
My lord, the learned single judge is directed for payment of compensation, my lord, some.
There also status quo, we don't know. If there is a status quo order, is status quo, whatever we don't
My
know.
lord,
Okay, list our Mr. Lane Council for the union also, Lane Council, the respondents have been, all are reprinted, the matter will be listed for hearing.
No, my lord.
Admission.
Admission,
Next week.
Next week, my lord.
2 weeks.
my lord. Item 42.
Lord, the interim.
Harley interim order will continue, yes. Item number?
42.
Wazuddin, yes, what is this?
My lord, this matter will come up for admission, my lord.
Why, what is this about?
My
Tell
lord,
us.
this is regarding my lord, principal in charge, my lord.
Principal?
Principal in charge of this.
Principal, sir.
No, Lordship, kindly see page number
This
16.
appeal has been filed against what? Which order?
Kindly see order
This is,
dated
against the
17th.
single judge order, my lord.
Huh? What did the Lana Single say?
Lordship, I have filed a writ petition, Lordship, challenging the discharge order of the petitioner, Lordship. Lordship, the honorable court holds that neither the petitioner nor the respondent is eligible for the post of headmaster. So accordingly, that impugned order is set aside and direction is given to the authority to determine the seniority, number one. Secondly, after determination of seniority, they put the senior most person to pursue the.
We will hear after, yes. At the matter.
Lordship, kindly say for, page
Yes,
16.
what we will hear after some time. What is the urgency?
Because of the pendency of the writ petition.
They will- huh?
I am deprived, Lordship, because the.
No, there is no stay order.
No, it's clear order, Lordship. Status
Still-
order is directed to maintain, Lordship.
Who is the principal right now?
Let the
My lord, I am
authority-
holding the post, my
Huh?
lord. I am holding.
He is not eligible, otherwise he is not eligible.
He is holding the post.
Yes, Lordship, that is why direction is
We'll
given,
see that,
Lordship,
we'll see that.
to determine the seniority, Lordship.
Okay, we'll see that.
Then Lordship is
If
given.
somebody is a principal, no, a school should not be without principal. He is there, we'll see.
Lordship, since 2000.
This dispute will go on, Mr. Doesn't.
Without a principal, Lordship.
So he's there, he's in
But
charge.
he is not having qualification, Lordship.
Doesn't
The
matter.
Rule 24/7.
We'll see that
No,
status
Lordship, there are
quo.
number of decisions, Lordship, which Lordship category held that.
Discuss.
Lordship,
You don't have the
for
qualification.
insertive, Lordship, they should require the.
Correct,
qualification.
correct. But there is a status quo order passed by this division bench of this court.
True,
We'll
Lord.
continue, we'll hear.
No, Lordship, because of this interim order, Lordship, I am the senior most, let the authority.
When you are going to retire?
Lordship, let the authority. give
When
the
you are going
direct-
to retire?
No, Lordship, I am,
How, what is your age?
I am 56, Lordship,
Huh? And what is the retirement age?
60, Lordship.
60 or 4 years. We'll decide before 4 years.
Lordship, will give a further direction to the authority, Lordship, to depute the senior person to undergo the peer training.
Oh, if that is so, then what's the purpose of filing the appeal? We don't know. We have to see here.
No, otherwise, Lordship, he is not, Lordship, agreed by this order, Lordship, because nobody is agreed, because I am neither. I am
Who says,
eligible,
why he has
nor
filed
is
his
eligible,
appeal?
Lordship.
Why he has filed the appeal?
That is, Lordship, kindly see.
My lord,
Why you have filed the appeal?
my lord,
Lordship,
ad
kindly-
hoc cannot be, my lord, replaced by the ad
Oh,
hoc.
forget about why you are filing the appeal.
My lord, because, my lord, this is an ad hoc arrangement, my lord.
Huh.
Now the authority is going to arrangement for replacement of.
Oh,
the
ad hoc by
ad hoc.
another ad hoc. That is why.
Yes.
Even if you are not eligible.
Yes.
Are you eligible or not?
No, my lord, I have no BEd, my lord.
That
You are
is,
not eligible.
the inspector of school is directed to hold.
If you are
his
not
card.
eligible, then how can you, if there is another eligible ad hoc? eligible
No, my
person?
lord, no.
Huh?
He's also not.
Let
my
him
lord.
ascertain
Yeah,
it.
that is what this honorable court directed.
Mr. Lane counsel for the appearance submit that he is not eligible yet.
So kindly see page number 61.
Stop.
Yes,
You also not eligible?
Yes, my lord.
That is possible. I am also not there. That is why Lordship directed.
Okay, yes, list after 3 weeks, yes.
That is why inspector was.
List after 3 weeks, next case.
My lord.
Next case.
My lord, stay.
I'll interim order will continue, yes, next.
43.
For a moment, kindly see. Lordship.
Sorry, please don't detain us.
So now
We have passed the order.
School is holding the
Sorry,
charge.
We have passed the order, yes, next.
My lord, on the last occasion when this matter had come,
Item number?
item number 43, my lord.
Yes.
In the, in pleading application, there was an application, interlocutory application 3480. There was an order passed on 25/11/22, including respondents number 14 to 22 as private respondents.
Hmm.
Now, my lord, in that case, notices were not issued. So my
So,
lord wanted the counsel who was supposed to appear, Mr. R.A. Chaudhary, to appear, his name to be reflected, and the matter was to be directed to be listed today. If he accepts notice on behalf of 14 to 22, because he appeared for them in the, before
I don't know, we can't force them. Are you going to appear?
See, I am appearing for respondent number 14 only, and for so far as the rest of the respondent, I have no instruction. I have filed.
Then my lord will issue a notice of that effect.
Okay. Mr.
R.A. Chaudhary.
Appear on behalf of respondent number newly implemented respondent 14.
14.
As regards the remaining respondent 7 to
15 to 22.
15 to 22,
We will take.
the applicant will take steps.
My lord,
Applicant
even
will take steps.
Dusty, my lord.
To Dusty, okay.
My lord,
This after 3 weeks,
2 weeks, my lord.
2 weeks, okay. Next,
Item 44 to 46.
yes, what is this? Anybody? Yes, John Sadharan, yes, Mr. Das.
Two appeals.
Yes,
The order passed by learned single judge. Where two appeals, my lord, partly what is allowed and one writ petition was dismissed. We came up before an appeal. And in the appeal,
The parties are all
now
present?
they have filed another appeal
Yes,
against the order of learned single judge, which we
Okay.
have received the copy.
okay.
So we will go through it accordingly, matter.
Okay, then just-
come up for admission, your worship.
What about list after 2 weeks?
2 weeks, your worship.
List on joint prayer list after 2 weeks. Yes, next.
May I pray for a date, your worship?
Director DDO, yes, next.
14 to.
Yes, next.
Item 47.
Ibrahim,
Yeah, it is lordship. Lordship, this is this IA lordship is for state the import order lordship judgment of the passed by the family court lordship.
Stay.
This appeal is not maintainable, man.
have you filed objection?
No.
What is the application for?
Application, my lordship.
What is that you have challenged?
Lordship, I have challenged lordship, the lordship, the family court lordship, my wife lordship, the lordship, she lordship left me in the 2003 lordship, the matter was settled before the court lordship, at that time lordship. Even lordship, at that time she gave assurance lordship, she will not fight any maintenance case, she will not proceed any case, or whatever lordship have decided the matter lordship. Again, lordship, after about 16, 17 years, lordship, she filed lordship another case lordship, in between she married two other place lordship. Later lordship, she suppressed everything lordship and filed a case lordship. Even the lordship,
Then what is order passed by Learned family court?
now court lordship, even lordship allowed lordship maintenance lordship and directed me to give 4,000 maintenance to her lordship.
How much, what are you doing?
I am lordship daily level lordship. I am depending to others lordship. I have filed a maintenance case against my son lordship.
Okay, have you
To
filed
maintenance
objection to this? Have you filed?
No, I know.
Have you filed?
I have to depend to my others lordship.
Okay.
How can I maintain lordship?
Appeal is
My
not
dear wife,
maintainable.
she
Huh?
left me.
Appeal is not itself maintainable, my
Oh,
lord.
whatever you
Under-
file your objection,
Under section
whatever it
92.
is, you file your objection.
Under 125 proceeding, man.
Huh?
125 proceeding.
125 proceeding,
Lordship.
125
Family
CRPC.
court orders lordship, it was
92 is clearly barred, my lord.
So far, I know lordship, it is a maintainable lordship. Against lordship, family court order lordship.
Okay, list again on after 2 weeks. Yes, next.
Item 48.
These are 2 weeks, 2 weeks, the 2 weeks, the maintenance of the application will be considered. Yes, next.
Item 48.
Rajiv Das, yes.
This is the challenge the service rule, my lord.
So will, have been notice have been issued?
Not issued, but it will come for admission hearing, my lord.
Others, why are not appearing? Who is appearing?
Higher education department.
Higher? They have challenged the rules. You don't want to file any affidavit?
My lord, Mr. Gugoi appears, my lord, he's on the,
Huh,
he's on
sir?
legs, my lord.
No,
Sometimes.
somebody has to file affidavit. Have you filed?
We'll have to file our.
You have to file. 3 weeks.
And date pe
To the state, to the filing, yes. next. Let them file their affidavit. Next, yes,
Item 49 to 52.
yes.
Item number 52, there has been a subsequent development, my lord. I may be allowed to bring on record the subsequent development in item
Okay.
52. And in respect of item 49 to 51, my lord, there is an interim order in item 49 and 51, my lord. I pray, my lord, this matter will be taken up next week, my lord, for hearing, my lord.
What hearing? What about, what is this matter about?
As regards settlement of fishery, my lord.
Settlement of fishery. Okay, we'll hear after 2 weeks.
No, Lordship.
Why?
Because Lordship revenue will be lost.
What revenue loss? Whose revenue?
Our revenue.
Who?
Because we are not being able.
We'll see that, There is
May
always,
be given, Lordship.
somebody will always gain, somebody will always, this is how life has been like this. Universe is functions like that. Somebody will always win, somebody will win. We'll see that.
Interim
But-
order may be extended. to
Okay,
item
at least
49
after
and
2 weeks
51.
on the prayer line council for the parties, all in the model will continue. Yes, next. Yes,
Item 53.
53.
There is delay, my lord, in preparing.
How many days delay?
65,
Huh?
265.
2 seasons, how much you are willing to pay? 5,000?
My lord, is due to my lord,
But what is your, who are you?
I am the, my lord, ex-tech superintendent,
Huh?
my lord, ex-tech superintendent, my lord. My service has been discharged, my lord.
Discharge, you
Yes.
pay something, 2,000, take superintendent.
lord, let us file objection in this way.
You want to file objection? What is the merit of the case? What is the issue is?
All other appeals are pending before this honorable board, my lord.
Huh?
Other appeals, my lord.
510 days, my lord.
Doesn't matter, Mr. Government, you file after 3 years, 4 years, and you raise objection. If you reject this, he will use this against the government. Government comes up with 3 years, 4 years. Taxman,
My lord.
superintendent,
My lord.
you are retired.
No, my lord, the APSC case, my lord.
Huh?
APSC case, my lord, that 49% my lord services, my lord, reject, discharge, my lord.
Okay.
Other appeals are pending before this.
Okay. You are one of them.
Yes.
Then what is there? What is there? Others?
Orders should reflect, my lord, I have objected it.
Yes. How Mr. Lane counsel for the applicant, how Mr. Lane counsel for the state, the present application filed for convenience delay of
265.
265 days
Yes.
in filing this appeal.
510 days.
510, which have been objected on the ground that the reasons assigned is not, are not reasonable, first off. However, considering the fact that similar appeals are pending,
Well.
we are inclined to allow this application for convenience delay subject to payment rupee 2,000 to be deposited to the account of the lawyer's fund.
Well.
Application is allowed. The appeal be listed after registration. Yes, next.
My lord, one prayer, my lord. In the respondents, my lord, the home department may insert in, my lord, instead of my lord, finance, department, that may be allowed to be filed.
In the appeal.
In IAN as well as the appeal.
Okay. The applicant is allowed to make necessary correction in the course title.
Yes.
Yes.
Item 54.
54, yes. What is this? 54, anybody present? Chief engineer. Chief engineer, shall we dismiss? If you are not appearing, we'll dismiss. He will, yeah. IFO 5 days staying for condonation of delay, how many days? This is for the respondent also. Nobody is for the respondent also. Notice has not been issued. No one appears, you file a case and go away. What do? We dismiss. If you file a case, don't appear, we dismiss. What do we do? What do we do with these papers? None appears for the applicant, dismissed on default. Yes.
Item 55.
For condonation of 3 days delay, my lord.
What should we make?
Sorry?
3 days delay.
3 days, how much you will pay? 50 rupees or 100 rupees, or how much? Okay, yes, which for the other side?
Standing counsel, UCO Bank, my lord.
Where is the bank? Notice has been served or no?
No, this is the first.
Notice is the first time you serve.
His name shown, my lord, in the cause list.
But then,
UCO Bank. 3
but
days.
then notice, under notice goes, he says, I don't know why my name is shown. He's not a government advocate.
We have served the copy on him, my lord. His name has been shown. 3 days delay, my lord.
Correct, but still.
You
get him
here before
You catch him, catch hold of him. 3 days delay, give him a cup of tea, bring him here, we allow, we will not impose any cost. Because it's 3 days only. Catch all of me. Bring him. Okay, next week. Next.
Supplementary list, item 91, order.
Please, your lordship, I appear for the petitions.
I appear for 4 and
I have
5.
receipt of the affidavit filed
Yes.
by them.
I think we can dispose it off today. What do you say?
Yes, sir.
And we have already heard extensive, and nothing additional. So we'll close this. Huh?
May I make a submission?
Yes, please.
May I only say this? Manoj, pursuant to the Tripura High Court order,
Yes,
the high powered committee, may I just submit the report to assist your lordship?
yes, yes.
This is Kwa Manoj Arunachal Pradesh and Manoj the state of Tripura. If your lordship kindly sees, yes,
Can I have a copy?
I'll just read and give. I don't have an extra copy. If your lordship sees, this is the minutes of the second meeting
Yes.
held at Jamnagar. And kindly, my lord, see, it was headed by Justice Deepak Verma.
Yes.
If your lordship turns to page 2, the state of Tripura and Arunachal Pradesh were represented. Arunachal Pradesh was represented by Mr. Tam. And my
Yes.
lords, this is the high-powered committee which has completed its inspection into the facilities over there at the rehab center. And my lords, they have found that this is world class in its own manner. 170 elephants, if your lordship kindly sees, para 15.
Yes. Yes.
Personally visit, all actual conditions of the elephants were seen. At the inspection day, para 16, it was found that there were more than 15 veterinary doctors, 25 paravets, 386 mahouts
Yes.
at the camp for the care of elephants so as to ensure that elephants do not suffer from ailments of any type, with which generally they are inflicted on account of their age and other conditions looking to the weight size of the animal. Detailed list along with their CV of every veterinary doctor and paramedical staff working in the trust has been submitted to the chairperson of the trust. In addition to this, the documents in relation to registration of trust, various NOCs and permissions have been submitted to the chairperson. Para 17, regular treatment is also undertaken at the camp for which these 170 elephants as needed to prevent all other elephants from suffering any other ailment at later date. In addition to these schedules for elephants with regard to vaccination, diet supplementation, cleaning, disinfection, and deworming were also shared with the committee. 18, a file of each elephant is maintained separately at the hospital, which the members of the HPC had checked randomly. A list of the doctors and report prepared by them from time to time was shown to us, which will form part of the final report. And therefore, my lord, this visit was concluded. Now, my lords, this is the kind of detailed survey pursuant to the High Court's directions, which has been conducted by the committee, which I have placed on record to assist your honor. My friend on the other side files a PIL as an advocate relying on newspaper reports. Now, my lords, therefore, these kind of PIL should be discouraged. Now, my lords, as far as the other types of animals are concerned, Supreme Court judgment in Kanhaiya Kumar, which has been annexed to the PIL at page 66 may kindly be seen.
Yes.
So,
yes.
as far as elephants are concerned, it's covered here. As far as the other animals are concerned, the lordships of the Supreme Court have only one paragraph I'll read. Paragraph page 66. The para at the bottom.
Yes.
The respondent number 2, that is me,
Yes.
has filed a detailed counter affidavit opposing the writ petition while asserting that the same is entirely misconceived based on incorrect and incomplete news reports.
Yes, we have been gone through. Yes.
Yes. And Manoj, on the next page, if your lordship sees, just 2 minutes more. Wildlife Act, section 38, all permissions are in place. Judicial notice has been taken by the highest court of the country. And thereafter, the Leopard Rescue Center, Crocodile Rescue Center, maintaining that VATs, curators, biologists, zoologists, and other experts are engaged to carry out the activities. Malors, these permissions have been granted after due verification, evaluation under the appropriate statute. Malors, therefore, in view of these facts,
these kind of PILs which have been filed, Malos completely not noting, no due diligence being taken, no personal Malos verification being conducted based on hearsay news reports is completely misconceived. Malos, please don't encourage such PILs. They should be dismissed with cost. And one more thing, Malos, I have taken instructions from my clients. Even the state of Assam, a representative, what my learned friend advises, can form part of this HPC. I want to be transparent. My statement may be recorded, if necessary. If necessary.
May I submit?
I have some objection to that, my lord, because HPC was also entrusted by the Tripura High Court to monitor future transfer, my lord. That power, my lord, may not grant to them, my lord. There are authorities under the statute. Let them take a call, either Chief Wildlife Warden or the Central, because my lord, that was, though it was a PIL, my lord, resisting transfer, my lord, transfer was permissible by this act order, my lord.
Okay.
But it is only to assist the court.
Just a minute, let me call. I will take 1 minute, my lord. Para 31 of the Tripura judgment says, my lord, in case where the chairman of the HPC recommends that an elephant or elephants be transferred to the camp of the restaurant number 3, my lord, that will be a license, my lord. That will be a license, my lord, to take out elephants from here, my lord.
Okay.
So that HPC may not be a part, my lord. Whatever we do, my lord, we will do in terms with Wildlife Protection Act with the permission of the Chief Wildlife Warden and the Central Zoo Authority, my lord. These are the two authorities.
That you relied on section?
Section 38, my lord.
Or 38 of the Wildlife.
And one more section, my lord. Section 38 is for zoo to zoo, my lord. And other transfer, my lord, is to be done by Chief Wildlife Warden. Section 48A, my lord. Section 48A.
May I submit something?
Yes, yes.
My lordships.
Well, before my learned friend starts, only one thing.
With my learned friend.
No, 1 minute, just 1 minute. Page 93, Tripura High Court order, only one observation to assist this court. Page 93 on the top. The committee was formed, the high-powered committee was formed by their lordships. Yes. By designation.
Yes.
And there at paragraph C, if your lordship sees on top, page 93, the chairman of the HPC shall co-opt an expert having experience of elephants. As a member of such HPC, the chairman may also consider taking assistance of the chairman, Animal Welfare Board of India for purposes of HPC. Therefore, my lord, I only suggested that if state of Assam wants to appoint, then I have no problem.
Okay.
My submission is similar and I
Yes.
to an extent because there are two aspects to my prayers. Now, when I say it, my lordship may see my prayer A and B. I'm talking about exotic animals. Now, as far as elephants are concerned, it is covered by the HPC. And your lordships, even if may see the report, my learned friend has read out,
Yes.
that there are subcommittees consist of state of Tripura and Arunachal Pradesh, who are therefore more in tune to understanding the problems here.
Yes.
Your lordships, I would be willing to address to the HPC regarding the real problems that are happening and how I can. And as far as the other animals are concerned, your lordships, I'll take my chance with the apex court. But it would be in your lordships, however, I mean, may not quote me directly on it, but it seems like a very workable order. And I don't know why the government wants to, when there are technical members here, I don't know why the government wants to oppose it. When it is confirmed by the Supreme Court that the HPC be in place, I don't know why my learned friend wants to oppose it, but it seems like a fair suggestion.
Both the parties are making the same suggestion. I'm objecting to it because my lord will kindly peruse page 90.
Yes.
Of the PIL, my lord.
Yes.
Under the law, my lord, transfer is permissible. But if we create a separate body to monitor transferring, my lord, it will be, my lord, will be facilitating transfer, my lord. Paragraph 31, my lord, will see. And one more thing, my lord, it was a judgment of Tripura High Court. My lord may not like to add something to this judgment. Paragraph 31 says, in case where the chairperson of the HPC recommends that an elephant or elephants be transferred to the camp of respondent number 3, the private respondent, the concerned chief wildlife warden shall ensure the transfer of the elephant is taken in the most appropriate manner. So wildlife warden, being a statutory authority, has been reduced to a, my lord,
So anyways, for the government to decide if they wish to be part of they're most welcome to be part of the HPC, but we can't force the government to be part of the HPC because that is in the context, though we don't see anything wrong. Otherwise, because the detailed submission made, but is all in in the interest of, but if the government is not, because there is also section 38 of the act, therefore this will be in addition to this section 38. That is up to the government. If the government wishes to be part of the HPC, they are most welcome, then they can do it. Otherwise, and if there is any grievance, obviously you can always address to the competent authority. Because see, this is a very general omnibus, as we see also, as far as the black panthers are concerned, it appears that they have obtained the necessary approval from the concerned competent authority. And as far the elephants is concerned, it appears that these are covered by HPC.
Yes,
Therefore, there is no point for us to make any further observation. Judicial order has been passed after due deliberation. But if there is any because merely because we have closed this PI will not preclude you from approaching the competent authority if there is a violation. But in any event, all the parties concerned are required to conform to the laws, the norms of the law of the land. If there is any violation, you can always approach the competent authority.
I'm obliged. Manoj, one more thing. What I understood my learned friend on the other side saying that even the PIL petitioner wants to be a part of the HPC or somehow or the other insert himself into this HPC. But that your lordship will not permit. HPC was formed as per the High Court order. This PIL cannot be a mode to gain indirect backward entry into the HPC. The HPC is self-contained.
Yes,
HPC is doing its job.
Correct. HPC earlier in the HPC constituted by in terms of the High Court does not make the petitioner there in the party also.
And the Supreme Court
They
judgment.
only the official. Correct. They are all officials.
Everything is covered by the Supreme Court judgment.
This
All
HPC
permissions are in place.
correct. So all these HPC also are officials. No non-officials are
Yes,
there.
exactly.
So
I'm
therefore,
obliged.
we are not going to make any changes in that.
No, that is what she was suggesting, and Malas, I am objecting to that.
Yes.
Only thing, para 31,
Yes, 31.
page 90, my lord.
Yes.
It says, my lord, in cases where the
Yeah, we
chair-
have gone through. Yes.
So, my lord, there is a statutory authority who can.
Fine, we have
monitor-
given. If you want to join the HPC, it's up to you. You
Yes,
can
my
do
lord,
it.
record my submission. my lord.
Yes, that we have noted. That's all. We'll close it.
My lord.
We'll
Extremely
pass,
obliged, madam.
yeah, we'll
Extremely
pass the detailed orders.
Oblige me.
We are closing this PIL with these observations.
Extremely obliged.
Grateful, Your Lordships.
I hope both of you will be in time for your flights.
Grateful.
Huh?
We will just make in time.
Okay, very
It's a
well.
personal privilege to address your lordship.
No, but I must say, and I was a little, we got an opportunity to attend your Lordship's court. And the way your Lordship handles the court, very impressed.
We are just making our endeavors to see what we can do.
Plus, we'll carry
Yeah.
back fond memories to Bombay.
Because we are really concerned with the huge pendency of these cases. Really problematic.
Lordships, we were having a personal conversation and he said your Lordships are already acting chief here. And there also we soon will have a new chief. So we
No,
hope
that is,
magic
we don't,
happens.
this is beyond my jurisdiction to make any comments.
We hope. I just made the effect that we would love to have you in Bombay. Your Lordships. Great.
Only now hearing matters left. All this. Now I can see, we don't know. We can't unfortunately read the mind of people. No, God has given everything, intelligence, wisdom, to love, to hate, to strike, but then God withheld one thing, the power to read the mind of another person. Because God also knows he's very smart, no? If he gives this power, there will be no end to this quarrel. Wife and husband are, smiling each other, spending their time together. But if they disclose, if they're allowed to see that, then, never know, you don't know. Similarly, all good friends, sitting together over a cup of tea, sharing their cup of tea. If they allow to see this, what is in their mind, see, all these restaurants will fail. restaurants, no? Because only there will be, see, so.
I was before Justice Kabir, as he then was in the Supreme Court, and Mr. Rohatgi asked for password post lunch. So Mr. Justice Kabir asked that why post lunch? He's saying that because I have heard that after lunch, the mood of the judge changes. So lawyers can perhaps read that part.
So hearing, of course, we do hearing all the time from 10:30 to 4:15. So, but this is a special hearing, category of hearing. What to do with this special category of hearing? Are the council also willing to offer their counseling? Yes, Mr. Mishra, we can see you, very prominent member of the bar, prominently, but you have understood what we want to say. Don't read our mind. Try to read also.
No, I can't.
But you can see something also.
Thank God, even God cannot read our mind. Otherwise, he will know what we are saying about you. If something is not fulfilled, we say we curse the God. So God will come to know even that. Anyway, that's a part. But I'm only saying, Your Lordship may not take up the hearing. It's not possible. I can understand that. But why don't Your Lordship consider? Lordship has already heard my bail application. He has completed, my Lord, 13 years, 7 months, and about 25 days. 14 years. In May, he will become eligible to
14
be
years is a
considered.
very good auspicious year. 14 years.
So therefore,
Everything
we
will
live
come.
before that.
14 years, if you complete 14 years, we'll apply the law of Ramayana. You see, 14 years, everything, then you celebrate Diwali also. After completion of 14 years.
Kindly consider that only. I have nothing more to say. Can we consider? There is a written submission also before Your Lordship.
Anyway, we'll see that. We are not saying anything today. We'll keep it some other day and we'll see what to do with that. Because that is also a very simple prayer pregnant with serious, implications. Very simple otherwise, apparently, but pregnant with serious consequences.
Your Lordship has
Correct,
told
correct,
everything
correct,
when I have
correct,
completed
correct.
the arguments in the appeal.
So anyway, we'll see, Mr. Mishra, what to do with this, because this is also troubling us, because we were in the midst of this. Actually, COVID came and disturbed us. Otherwise, we were sailing through.
My Lord, this argument commenced on 18/2/2021.
21. Then the
3
COVID
years.
came. COVID came.
Yes.
See, and
No,
COVID
what
came
I
and
think-
destroyed many
let-
business also, no?
My Lord, let the miscellaneous case come up on any day.
Yes, that is, let us see. We'll make
If your
on a hearing day. Today is not a hearing. Is it a hearing day today?
I'll leave it to Your Lordship.
Yeah,
Kindly
let it come on a
consider.
hearing day. We'll see what we'll certainly consider your case. We are not rejecting that prayer also.
Yes.
We are not saying no.
Because last time,
Correct.
Your Lordship took up this matter on 31st of March 2022. When I pressed for the bail, Your Lordship says, let's wait for something. If you cannot decide, we will dispose of your bail application. That's how Your Lordship kept
Correct.
the bail petition pending.
Okay, okay.
That's the reason. Now, therefore, I would say that if the Lordship can take it up next Tuesday, only bail matter, the Lordship will dispose it.
Okay.
My prayer is
We will see the next Tuesday. Huh?
31st.
Let us see. 31st. We'll see. We'll make
let
it,
miscellaneous case only come.
Okay. We will make an attempt.
Now, the other,
Yes.
other matters, my lord, I have also
And then let
71,
this be
76. My lord, we'll have it on any other day.
Some other hearing day.
Day.
All these hearing may come up on a hearing day because it come up because today.
But this miscellaneous matter on 31st.
Okay, 30.
Item number 8, the affidavit we file in item number 9, madam, and also 9 in we file in item number 8, madam. So rectification is required, madam. So 3 weeks time we granted, madam.
Okay.
We will inform the other side.
So you're on the prayer, Mr. Mary. Yes.
3 weeks.
Wait, please, Your Lordship. Lordship, I beg to mention item 4. I've been instructed to withdraw this matter.
Mr. Sancho submit the instruction to withdraw this petition in view of the present contempt is closed on withdrawal. Yes, next.
Daily list for motion, item number 1.
Viren.
May I please, Your Lordship? Here in this case, Lordship, this petitioner, this is a long history for the petitioner. He has been pursuing his matter for a number of occasions, the third round of litigation. And the petitioner retired on 31/1.
Who is the other side?
This
Who is the other side? Names of standing council.
Standing Council Education, Standing Council AG,
Yes.
and Standing Council SCRT.
Who is there, Lordship?
Mr. B. Kaushik, yes,
Yes.
anybody? Yes, Mr. Khotania, any, yes? Yes, tell us.
Lordship, what has happened on 31/1/2021, the person has retired. And till date, he has not received any pension and pensionary benefit.
Why? Why
The
not?
only point was that this relaxation, because prior to that, he had approached before this honorable court, because he was not given due promotion as additional director. So he had approached this honorable court, and this honorable court has passed an order directing for his promotion with retrospective effect from 2018. And that was not considered by the respondent authorities because the relaxation was not given as per FR 17(1), FR SR. Now the petition has been pursuing for a long period of time, and again we have approached this honorable court for which we have filed this contempt. After filing of this contempt, Lordship, now I have recently received one communication that is of 9th of January 2023. They have given this relaxation of FR 17(1) by invoking FR 5A. I have written the copy and I have given one copy for this honorable court.
So
Now it is done. Now
Now
the
it's done.
basic issue was with regard to the issuance of the payslip. The
yes.
payslip was not issued because the relaxation was not given. The petitioner is striving since 2021 for last 2-3 years, but he has not been given the pension. He has not been given the pensionary benefits only because of this relaxation was not given. Now, since the relaxation has been given on the last occasion, Lordship, this, if your Lordship kindly see page number 19 of the contempt petition,
Yes.
there was a specific direction of this honorable court. The last paragraph, the paragraph number 7,
In 19.
page 19.
Yes.
Having noticed that the petitioner has already superannuated from service on 31/1/2021 and has not received any benefit till date, the writ petition is therefore disposed of with a direction to the respondent number 1, Secretary to the Government of Assam, Education Elementary Department, to process the matter of relaxation as per.
So the AG will do.
Exactly. Now within 2 weeks, the AG has to do. Now it has been issued on 9/1/2023. 2 weeks gone, Lordship. Now nothing they have done. AG, the counsel for the AG is also there.
Yes,
So it
yes,
is
yes.
again another violation of the direction of this honorable court.
Yes.
And for nothing, the matter has been dragged, Lordship.
What do you do?
Lordship, in the instant case, Accountant General was not made party, Lordship.
Doesn't matter. Don't bother about all these technicalities. You know, you are the technicalities. What is that?
Lordship,
Not
my
party,
only-
not party.
Lordship.
He has to get the pension.
No, Lordship.
You are aware of this order?
My only one, I have received only one instruction, Lordship. He has received the unincluded earned leave amount. That is
Only is my
instruction.
thing, Lordship. They are on
But
the.
then whatever now you do, whatever is required.
I can give a
Why
copy to the council,
hardly?
Lordship. I can give a
Whether
copy to the council.
Account General Office has received the pension paper or not.
Of course, that you be satisfied.
That is, I have to
Ah.
obtain instruction.
Yeah, but you are already a party. In
Lordship,
this-
in the main writ petition, he was a party, but
But-
in the contempt, he was not a party because the initial direction was to the secretary. Now
Actually, you
now
should-
he can be implemented as a party. in this
Absolutely,
contempt
you should have
petition.
implemented.
Yes,
When you
Lordship.
received, you should have implemented.
Yes, now he can be implemented as a
You
party.
implement,
Yes, Lordship.
should have implemented.
Yes, Lordship, can it be done for the?
You implement.
For the
You-
advancement
you-
of justice.
you-
I will write it down.
You
Lordship.
do that.
Yes, I will write it down.
If you ask this judge also to
No,
implement,
no, I
then
will not do that, Lordship. I will write it down. Lordship.
do it.
Yes, Lordship.
Do it,
Only
implement.
I'm just praying for this indulgence. Lordship.
Okay. The accountant general will stand implemented
Yes.
in view of the decision taken by the state government that the relaxation under the relaxation of FR 17(1) by invoking FR 5A has been issued by the had been approved. Relaxation of FR 17 has been approved by government order dated
9/1/2023. Lordship.
in view and as such the once a relaxation is granted, account general is to issue a pay slip to the
Yes,
petitioner within 2 weeks as directed in para 7 of the order.
Yes.
Accordingly, the petitioner will implement and so since Mr.
RK Talukar, Lordship.
You take that.
Lordship.
Since Mr. Talra has already entered appearance, the notice may be served through the Mr.
Yes.
Talra,
Lordship.
who will file necessary
Will appraise this court, Lordship. with you.
who will inform this court
Yes,
as to the implementation of this court's order by the next date. How long will it take?
Lordship, 1st of February, Lordship is a very near place to go. He can get this information.
Second week of February, Lordship.
Give a date.
2nd of February.
Any date, Lordship, after 14th.
Director Didu. Director Didu.
15.
Lordship, can it be in the 1st week of February, Lordship, because this person is for last 2 years.
First week of February.
First week of February, Lordship.
On 6th.
6th.
You tell us, no
Lordship,
problem.
Lordship,
Yeah. Okay, list 7.
Lordship, 6th of February.
Next,
Obliged, Lordship.
Item number 2.
Rashtra Bhasha. Yes, madam, was Rashtra Bhasha.
Mr. Lordship, High Court order 11 space 28.
Okay, what was the direction? Notice we should matter pertains to provincialization. Rashtra Bhasha. Petitioner extra copies. You are appearing here?
Yes, madam. In fact, I have received some instruction, my lord.
Okay.
We need some time to comply with the order of the honorable court.
How long?
My lord, we have already taken up the matter with the deputy president because some allotment of land, my lord.
Yes.
So at least 4 weeks, my lord.
Bristol and Council appearing for the respondent place for 4 weeks for compliance with the court's order. This accordingly after 4 weeks. Yes, next.
Item number 3.
Orup Day, what is this? Orup Day
So order has been complied with.
complied.
Complied, I'll see it.
What is the direction of the court?
Direction of the court to examine the partial final page number 14.
14.
Whether the authority has taken.
In view of the
application.
opinion, this direct respondent to inform result of the candidate and yes, then what is?
His application has been rejected, he is overreached.
Okay. Though no one is present for the petitioner, harm Mr.
Yes, my lord.
Royal and counsel for the respondent who submits that the order of this court pass on 2/8/2019 in WPC number so and so has been implemented it has been found that the petitioner was overaged as on 1/1/2017 as per criteria number 1 of the advertisement dated 30/6/2017 and as per the provision of the government or some OM number so and so and as such his candidature has been rejected. In that with the petition is closed with liberty to the petitioner to challenge the said decision of the authorities before the appropriate forum. Copy of the compliance order dated 9/1/23 issued by the mission director Home Sarva Saksha Abhiyan is placed on record. Next,
Item 5.
Binita Roy, what is this?
May I please your lordship, matter
Yes.
is pertains to non-compliance of the order dated.
Non-compliance. No, will issue
What?
notice?
Yes,
Notice, rest of post with AD. 2 weeks. Next,
Item 6.
Bora. Yes, what is this?
My lord, MSCP benefit was not given, my lord.
Okay,
Yes,
notice 3 weeks.
my lord.
Rest of post with AD. Yes, next.
For admission, item 7.
Eastern Cargo Mobile. What is this?
Lordship,
What is it to be done today?
lordship,
What?
today for admission here.
Admission hearing. Will admit. Will hear. Okay.
Lordship,
Will admit. And
lordship,
Mr.
the
Lal,
matter is.
admitted, matter will listed for hearing.
The matter may be today also,
Today also.
lordship, it can be discussed.
How long will it take?
10 minutes, lordship, from my side, lordship. Only 10 minutes. It's simple matter, lordship. Lordship, they are arguing that the arbitration clause does not covers as because there is a retirement deed, lordship.
There is a?
In the retirement deed, the arbitration clause is not incorporated.
Oh, I see.
But in the partnership, the original partnership agreement, there was an arbitration clause.
Yeah, partnership between who?
Partnership between respondents and petitioners, lordship.
Okay, then what happened? The dispute arose.
This dispute arose
As per, according to as per the partnership, there is a provision for arbitration.
in partnership. Then they are arguing, their main contention is that they are arguing on this point. Now, my learned friend is arguing that as because there is no arbitration clause in the retirement deed, so the arbitration does not exist, lordship. Here, lordship, here the section this comes here because there is a reference section 7 of subsection 5. 7(5) comes, lordship. Section 7. Section 7, clause 5 comes, lordship. Is applicable in the this agreement, lordship.
Section
7, clause 5, lordship.
the reference in a contract, a document containing an arbitration clause constitutes an arbitration agreement if the contract is in writing and the reference in such as to make the arbitration clause part of the contract. Lordship, here.
Yes.
Here, Lordship, in the requirement deed, Lordship.
Yes.
Yes, Lordship. Page number 31, Lordship. This is the requirement deed, Lordship. It starts from page number 27, Lordship. Page number 31.
Page 27.
From 27, it starts, Lordship.
Date of retirement.
Deed of retirement. Lordship, here, page number 31. Where it was reflected, where
The brothers or what?
yes, son and father, Lordship.
Son and father. Why son and father quarrel? Why can't you
Because
resolve?
there is I have changed something, Lordship.
You have said something.
Changed religion.
Huh?
Change the religion.
Son is to pay money, my lord.
Huh?
There's a financial dispute, Lordship. But
You are the son or you are the father?
I'm the
I'm the father, my lord.
they are the
You are the
I'm the
father.
father.
father and
Why,
elder brother.
why don't you listen to your father?
Lordship.
Why don't you listen to your father? Why
Lordship, they have we are about 9 brothers, Lord.
9 brothers.
Lord, I'm the youngest.
Youngest.
They have as per this, I'm alone, Lordship. With my father and 8 brothers, they are standing together.
Very powerful.
Very powerful, Lordship. Lordship here.
You are the youngest also.
I'm the youngest.
Why do you want to torture your youngest son?
He is actually torturing us
Torturing.
because the terms of the retirement deed is very clear. He's supposed to pay the money, but he doesn't want to pay the money. That's why he has dragged us to all these things.
Lordship.
Actually, there is no dispute which can be referred to arbitration.
What is the retirement?
Lordship, retirement deed, Lordship, let me comment, Lordship, page number 31.
Is 31, yes.
Here, Lordship, I'm just trying to convince the court, Lordship, that where the parties here to have been carrying on business in partnership under the deed of partnership dated 5/2/2015. There was a reference of the original partnership deed, Lordship, entered into by the parties here to in the name of Method Eastern Cargo Movers, Lordship. Here, Lordship, here, if your Lordship goes to the original partnership deed, Lordship, here, dear Lordship, original partnership deed, page number 18, Lordship.
18.
18, Lordship.
Yes.
Here, Lordship, this is clause number 15, Lordship. Here it is written that all the disputes relating to the partnership business between the partners or the representatives cannot be settled mutually. The same shall be governed as per the provisions of Arbitration Act and Conciliation Act 1996, Lordship. Here, Lordship, here deed of retirement. Here, Lordship, what they did, Lordship, in the retirement deed, I am before this court. First, I'm trying to convince Lordship that there is the arbitration clause covers in the arbitration deed of retirement also. Then I will go to proceed to the next part, Lordship.
But is deed of retirement is traceable to the deed of partnership?
What he has suppressed, my lord, if your lordship will come to the arbitration clause in the deed of partnership, it says that all dispute relating to the partnership business between the partners, that is at page number 26.
18.
26.
18 or 26?
The arbitration clause, my lord. It is at
18.
page 26.
26?
Yes.
Huh? What is 26? 26 starts from where? 26.
No, it's 18, my lord.
18, Lordship.
But what is the deed of partnership? 1st day of August 2020.
Yes, Lord.
And you're reading this. There are two deeds of partnership.
Yes, Lord.
Huh? Why there are 2 deeds of partnership? One is on 25th day of February 2015 And
This
another
one-
is
This one is mine, lordship. We are.
1st of August 2020. What are these?
My lord,
This is amongst us, lordship.
The applicable one is at page number
This
18.
18,
my-
lordship. This is.
Page number 18.
18,
Okay.
my lord.
Okay, very well.
Arbitration clause. It says that all disputes relating to this partnership business between the partners or their representative, if cannot be settled mutually, the same shall be governed as by the provisions of the
All dispute relating to the partnership business.
business.
All matters. All matters. And then what does it mean?
If cannot be settled mutually.
Yeah.
The same shall be governed as per.
Has
the
it been mutually settled?
Yes,
Yes,
that is what he has suppressed. my lord. That we have filed.
Oh, I see. It has been mutually settled.
Exactly.
Then he goes, he makes a U-turn.
Yes.
I said, no, 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 I did not do that.
No, he doesn't say that. my lord.
Then?
There was a resolution. We had.
Page
No,
34 for
affidavit.
affidavit.
My
Kindly,
lord,
lordship.
Page number
Will hear
34.
you, will hear you.
Don't. Page number 34. of
Yes,
our
34.
34 for affidavit.
Affidavit, my lord, filed by.
Page 34
Yes.
of
The affidavit
reply.
filed by-
I know. Opposition.
affidavit in opposition. my lord.
affidavit in opposition.
Filed by respondent number 1, 2, and 3.
Page
34, annexure A. my lord.
yes.
He is signatory of this.
Yes, resolution taken by Eastern.
Page
Cargo-
34 of the affidavit in opposition.
My lord.
Filed by whom?
The respondent number 1, 2, and 3.
Respondent number
1, 2, and 3, my lord.
1, 2, and 3. Excellent. Page number
34,
34.
my lords. Annexure A.
Resolution taken.
Yes, my lord. So this was in pursuant to that clause number, my lord, 15.
Resolved to dispute, and taken a common resolution to resolve.
Yes.
Dispute has been occurred, so and so and so and so. So this is, what is his name? This, your youngest son name?
Natwar Lal Mishra.
Natwar Lal. Natwar Lal.
We
Natwar is a very familiar name. Huh?
Yes,
Natwar Lal is familiar. Those who have seen Hindi film,
Lordship, lordship.
and they are very.
His date is also mysterious.
Huh?
His date is also mysterious.
Natwar Lal. So Natwar Lal, you are a signatory.
Not what.
Okay, then so according to you, since there was already a settlement, there is no dispute.
Yes, this, now in pursuance to this, the deed of retirement was made.
Okay.
So everything settled, my lord. Now there cannot be any question of reverting back to arbitration, my lord. Because a different
Lordship,
contract
this
has been made now.
We are not registered partnership.
In pursuance to the, and my lord, this deed of retirement, he had challenged it before the civil court. And then he withdrew that suit, and no liberty was granted to him, my lord, to agitate again. So whatever here, the terms and clauses of the.
He
deed of-
challenged this deed of retirement
Yes, my lord,
Lordship,
before the civil court.
before civil court.
Yes. But
Where? In Delhi,
No, in Guwahati, my lord.
in Guwahati.
Yes, that order we have filed by way of an additional affidavit.
Where is it?
Which has dismissed his case, my lord. An additional affidavit, my lord, filed by us.
Additional affidavit filed by you.
Yes, my lord.
That was a separate issue, lordship.
No.
Actually,
We'll hear, no? We'll hear.
lordship, lordship.
We'll hear you.
Lordship,
We are just on the facts. We are not really, yes.
lordship.
Para number,
My lord.
page number,
Of the additional affidavit, page number 31, my lord.
page 31.
Yes.
No, page 31,
Of
31.
the additional affidavit.
Actually, there is no page 31, all 301 or something.
Of the additional affidavit, my lord.
But there is an additional affidavit, all, it has been all erasex. Erasex is there. Therefore, we are not able
Filed
to.
on 1611, my lord.
No, we have seen that, 1611. The internal page is there typed. Thereafter, the annexes are not marked.
Not my lord.
Annexure, which annexure?
Annexure 3, my lord.
Annexure 3.
Page 31, my lord.
No, this page has been erased, no. There is another page of the combined page, 305, 304 continues. Annexure?
3, my lord. Order dated 18/7/2000.
Just a minute. Annexure 1. Annexure 2. Annexure 3, what is it?
18/7/2022, passed in TS 285.
Yes.
Yes. Parties are duly represented. Produce the petition number so and so filed on behalf of the plaintiffs under order 23, rule 11 CPC, praying for allowing the plaintiffs to withdraw the instance.
Who is the plaintiff?
I'm the Their name is there, my lord, Natwar Lal Mishra.
Separate issue, lordship.
Where is the Natwar Lal?
On the
Present.
right hand side.
On a top.
Oh, okay. Handwritten. Okay. So, allowed to withdraw. It was allowed.
With no liberty was granted.
Equity people allowed, from fresh and dismissed and disposed of withdrawal.
The plaintiffs are precluded from bringing a fresh suit.
And what is the suit, what is
Yes.
the
The
relief
relief
claim in
that-
that?
Yes, the reliefs that was sought, my lord, I am taking your lordship to the plain. That appears at my lord. Page number 66, the claim starts of our affidavit in opposition.
66 of which one?
The affidavit in opposition, my lord.
Which we are reading just now?
Yes, my lord.
No, this, what we are reading is the additional affidavit, my lord. Now-
Just prior to that.
Now I have to take. your
Page
lordship-
66.
Yes, please.
Civil suit, Judge Kamrup, title suit, Natwar Lal,
Yes.
Eastern Cargo Movers.
So if your lordship directly comes to the prayer, your lordship will know what were the reliefs that were sought in
Hmm.
that suit.
Page number 75, lordship.
Yes.
Page number 75, lord.
Yes,
The relief sought.
yes, yes, yes.
Yes, for a decree of declaration against the defendant jointly and severally to pay 2 crore 10 lakhs as per clause number 6 and 7 of the retirement deed dated so and so. And rupees 32 lakhs taken as loan on 17/8/2020 along with pendency life and future interest at the rate of 24% per annum. And for a decree of declaration that the verbal agreement dated 17/8/2020 among all the partners of plaintiff number 2 with defendant number 1 to 4 are in force and the same are binding on the defendant jointly and severally. And for a decree of declaration that the clause number 14, 15, 16 along with payment schedule is null and void and not binding on the partners of plaintiff number 2. He had challenged clause number 14, 15 and 16 and payment schedule of the deed of retirement, my lord, in this suit. And for decree of cancellation of clause number 14, 15, 16,
Why he challenged?
my lord, because he didn't want to pay up the money. So he challenged it, my lord.
In their affidavit in opposition.
He's supposed to pay us.
We'll hear you, Mr.
On retirement, he was supposed to pay us. There was a payment schedule. There was a schedule of movables which contained the trucks in question, my lord. So he was supposed to give it to us. He did not give, my lord. And then he filed the suit. And he challenged the deed of retirement. But later on, he withdrew the suit and no liberty has been granted to him to agitate in future the same thing, my lord.
Yes.
And what is the dispute that he says? If your lordship would see,
Yes.
he says that we are unauthorizedly using the trucks and have not paid the loan and have been using the name of the partnership by violating clause number 17 of the deed of retirement. Deed of retirement. Your lordship would find it in para number 3 to 6 of his petition.
Yes.
If your lordship would come to page number 5.
Yes. Yes.
Now he admits that the petitioner begged to state that as per the said deed of retirement. Paragraph number 3, my lord.
Yes.
Yes. The petitioner begged to state that as per the said deed of retirement agreement dated 3/8/2020, all the respondents had received 6 numbers of vehicles by number so and so, so and so, so and so. These are the registration numbers.
Yes.
So on the basis of the contract,
Yes.
which is in the form of a deed of retirement, we had admittedly received these vehicles.
Yes.
Second paragraph, number 4, that the petitioner begged to state that after receiving the stated vehicles, respondents are supposed to complete the transfer process in the DTO
Kamrup Metro by clearing all dues of vehicles, including loan of 5 vehicles. But the respondents, by not paying any amount, are using these vehicles which are in the name of Eastern Cargo Movers, where respondents were partners as per partnership agreement dated 5/1/2015 before retiring in the year 2020, but the respondents are using the vehicles illegally. Next, my lord, he says, the petitioner begged to state that the respondents are using these vehicles which are in the name of Messrs. Eastern Cargo Movers with an impression to the clients of the firm of the petitioner that the respondents are still partners of Messrs. Eastern Cargo Movers and thus creating huge loss to the firm. And by this way, the respondents had violated clause number 17 of the deed of retirement agreement dated 3/8/2020, whereas clause number 70 says that retiring partners agree and undertake that they will not use the name of the firm. Number 6, that the petitioner begs to state that as the respondent had used the stated vehicles and also to the fact that loan amount of the entire 5 vehicles had been paid by the firm of the petitioner, that is Eastern Cargo Movers, after execution of the
This
retirement.
Eastern Cargo Movers is his brand name or what?
Now
No.
he's
Yes,
continuing.
my brand name.
Yeah, he's continuing.
Yes.
You are not supposed to.
I have
Oh,
retired.
retired.
And also to the fact that respondents are using in the name of Messrs. Eastern Cargo Movers at
So there he's alleging that you are using the name of this Eastern Cargo doing business.
Yes.
In spite
Now-
of the agreement arrived at between
Yes.
this
Now,
Lordship, that is
now
the-
if your lordship will come to the
Agreement, my lord.
deed of retirement.
new time. Yes, that is.
Yes. First, I will show your lordship because he admits that the vehicles were given on the basis of the deed of retirement. For that purpose, your lordship would kindly see page 43 and 44.
Forty-three, 44
Yes. Of the
agreement,
of the arbitration.
resolution.
This arbitration petition.
No, no, FDP.
Number 32.
Oh, no, no.
Of our affidavit in opposition. madam.
Huh?
Of
Of
our
the
affidavit in
petition 27, lordship. It is in the 27.
Huh?
Okay.
So this resolution taken by MS Argo Movers, that one,
My
that
lord,
agreement.
I beg to take your lordship to my affidavit in opposition, my lord,
Uh-huh.
at page number 39, at page number 43, my lord.
Yes,
Yes.
43.
Yes,
And his affidavit.
Movable asset received by retiring.
yes,
That one, huh?
yes, my lord.
Yes, lordship.
Yes,
Yes.
yes. So these are the 5 numbers of ultra truck, my lord.
Yes.
1 number of 10-wheeler truck, 1 number of I-20 car, 1 number of Maruti car, and 1 number of 407 truck. Here, the dispute is regarding those trucks, my lord. Here, we have received, my lord, these trucks. Then your lordship would come to page number 44. Detailed account statement.
Yes.
Here, a grand total was arrived. If your lordship would see 3,58,00,000.
But then if he's not paying, he's supposed to pay
Yes,
to you
yes.
according to you.
Yes,
Suppose if he's not paying, then what will happen?
he has already paid, my lord. In
Huh?
terms, he has already paid.
For a loan amount.
Loan amount is already paid.
No,
Ah.
why he's filing this arbitration?
My lord, because there is a.
No, what is there to be, what is the dispute which is
There
to be resolved?
dispute. That is what we are arguing, my lord. There is no dispute, my lord. Tracks we have got on the basis of the contract. In terms of this deed of agreement, he has already.
So page 43, these 5 trucks is in terms of the
Yes,
this resolution, na?
my lord.
Deed of,
Lordship, here, the crux of the case starts from here.
My lord,
lordship.
may I add one more thing, my lord?
yes, sir.
My lord, lordship, here, lordship, I'm supposed to get rupees.
My lord,
No,
just
don't worry, we'll help you.
step by step we go, my lord. Otherwise, it will create confusion, my lord. Page number 44, if your lordship would see.
If the court is asking questions to respondent,
Lordship,
that means for the time being, the court is satisfied with you. That's what we want to know.
lordship,
If I am not satisfied, again, I will ask you again.
lordship.
Hmm.
At page 44.
Hmm. Because if I am satisfied with respondent, why should I ask any question to?
Lordship.
Yes,
At page 44, my lord.
yes.
your lordship would see the detailed account. So on retirement, each of the partners were entitled to receive 70 lakhs each. So a calculation is made. The grand total is 3 crores 58 lakhs. 3 crores 58 lakhs. Now from this amount, the value of these trucks,
This 70 lakhs given by whom to whom?
we have to receive. The Eastern Cargo Movers, the continuing partner would pay to the retiring partner.
Okay, okay.
To us, to the.
This company, movers will give it to Sitaram, then Anil and Rajesh like that. Huh?
Yes, yes.
Then what is it for Boragaon then also?
Yes, that
78.
the accounts were made in that manner.
Okay, anyway.
Yes.
So grand total 3 crores 58 lakhs
My lord.
were paid.
Yes, from this amount,
Yes.
these values of the trucks in question. Here,
Were
value of
deducted.
movables and immovables. This amount was deducted.
Because you are using it.
Yes.
Because you are using it.
Yes, yes. So the ownership automatically goes to me, my lord. Because the amount is deducted from my retirement benefits. Now, ultimately, after all these deduction, 1 crore 74 lakhs. Below. Total amount due is 1 crore 74 lakhs. For this purpose, a schedule your lordship would find at page number 42.
Page 42.
Yes, of the same document, my lord. This is the payment schedule of 1 crore 74 lakhs. So the petitioners were supposed to make this payment, my lord.
To
us.
Sitaram Mishra,
Yes.
like for example, 1st September 2020,
Yes.
3 lakhs 33,000 to be paid by him to Sitaram.
Nothing has been paid. Yeah, this he has not paid, my lord.
If he has not paid, then what will you do?
My lord, we are coming to that. My lord. Instead of paying this amount, he made up a case that we are illegally using the vehicles by not paying the loan amount, and he filed it FIR. So the entire story starts from the FIR.
Are you sure he is your son?
Your lordship had already taken note of the fact that his name is Natwar Lal, my lord.
No.
But you are the father. Why did you give this name? If you had given a Rana, Sita Ram, then you would have,
Because the day he was born, I could see the trait, my lord. The day he was born, I could see the trait. So better name him, my lord.
No.
As an abundant person, I named him Natwar Lal, my lord. My lord, just to satisfy your lordship again, at page number 39, there are few clauses which your lordship will have to see regarding the allegation that he's saying that regarding the loan money I am supposed to pay. Clause number 3, my lord, at page number 39. It is declared that except herein after provided the retiring partner shall not have and they hereby release their entire share, right, title and interest in the business of the said partnership, its assets including goodwill, all licensing permits held by the said firm, its outstanding dues.
Clause number 9 you are reading?
Clause number 3.
Clause number?
3 and 4 will have to be read.
3 and 4 of which page you are reading?
Page number 39 of the arbitration petition.
Oh.
Of the affidavit and oppositions. I'm sorry, my lord.
Page number?
39.
39. Clause number 4.
Yes, 4.
Continuing partners agree to pay all the debts,
and
liabilities
of
to the said firm.
from today and to indemnify and keep indemnify the retiring partners against all such debts and liabilities, all losses, costs, charges, expenses that the retiring partner may incur or suffer on account thereof. To us. So in terms of this clause, he has already paid the loan amount. But when the time came to make the payment of 1 crore 74 lakhs in the manner as shown in page number 42, he made up this story that we are illegally using the vehicles by not paying the loan amount and filed an FIR against us. On the basis of that FIR, he made a complaint to the DTO and got the vehicles blacklisted. By that action, we came to the Honorable Guwahati High Court, and that writ petition was decided in our favor. That order I have annexed along with my additional affidavit. If your lordship could see that order of the Honorable High Court.
Yeah, Mr. One thing, sorry, your name? Mr.
Mukit, my lord.
Mr.
Mukit.
Mukit.
Yeah.
Okay, Mr. Mukit. You may be correct, But your story appears to be very longish.
Yeah.
Huh?
Because he has taken us for
Correct.
several rounds of
Correct.
litigation. my lord.
Then do you think that this court should hear the long story? Because normally, if in arbitration jurisdiction, if you have to make a very long
That your
history,
lordship- that your
then
lordship-
will it be appropriate for the arbitrator to decide itself whether it has jurisdiction or not? Something I'm just asking
Yes, yes,
myself
yes.
also.
I'll satisfy that, your lordship.
If you-
Section 11.6, my lord, that part has been repealed now.
Yes.
11.6. So this judgment, or the latest judgment of IOCL, my lord, 2022, my lord. There, my lord,
Yes, what does it say? Ratio?
yes, ratio is at page number 89,
What does it say?
para 89. SCC online. Online.
Para?
89.
89.
Yes.
Yes.
The important part is in the middle, but just to keep the continuity, I'll read from the beginning. Having heard learned counsel appearing for the respective parties and to facts and circumstances of the case, the issue aspect with regard to accord and satisfaction of claim is seriously disputed and debatable. Whether in view of the acceptance of rupees 4,21 by the respondent NSCL, which was released by IOC on the offer letter made by the respondent NSCL dated so and so, there is an instance of accord and satisfaction of the claim is a good and reasonable arguable case. It cannot be said to be an open and shut case. Therefore, even when it is observed and held that such an aspect with regard to accord and satisfaction of the claims made can be considered by the court at the stage of deciding section 11 application. It is always advisable and appropriate that in cases of debatable and disputable facts, good, reasonable, arguable cases, the same should be left to the arbitral tribunal. Similar view is expressed by this court in case of Vidya Dorilia Supra. Therefore, in the facts and circumstances of the case, though it is specifically observed and held that aspects with regard to accord and satisfaction of the claims can be considered by the court at the stage of deciding section 11.6 application. In the facts and circumstances of the case, the High Court has not committed any error in observing that aspect with regard to accord and satisfaction of the claims, or where there is a serious dispute will have to be left to the arbitral tribunal. However, at the same time, we do not agree with the conclusion arrived by the High Court that after the insertion of section 6A in section 11 of the Arbitration Act, scope of inquiry by the court in section 11 petition is confined only to ascertain as to whether or not a binding arbitration agreement exists for the parties before it, which is relatable to the dispute at hand. We are of the opinion that though the arbitral tribunal may have jurisdiction and authority to decide the dispute, including the question of jurisdiction and non-arbitrability, the same can also be considered by the court at the stage of deciding section 11 application. If the facts are very clear and glaring, and in view of specific clauses in the agreement binding between the parties, whether the dispute is non-arbitrable or it falls within the accepted clauses. Even at the stage of deciding section 11 application, the court may prima facie consider even the aspect with regard to accord and satisfaction of the claims. So now, my lord.
Of course, what this judgment says that normally it should be left to the arbitral tribunal and there's a long contentious issues there. But it does not preclude the court from doing it.
Yes.
Now, it again is a discretion again.
My lord.
Is a discretion.
I'm setting my argument on the limited point here, my lord, because here the terms and clauses of the deed of retirement is clear. He makes an admission that on the basis of the deed of retirement, I have got the vehicles.
Or is it the case that this deed of retirement and in the agreement which you say that have been arrived at,
my lord,
though you have arrived at the agreement,
my lord,
there was a problem in the execution of the agreement?
No, not in the execution.
Because see, though we may have agreed, okay, fine, oh, three of us come, we'll decide, we'll agree to do this. Then we agreed, I will give this, I give. Then again, when they go out of the room, they start fighting. Arey, you have not given this money as per the agreement. I said, no, I have given this. Now how, suppose agreement is entered. Here also among the 9 brothers and father, agreement is entered. This. Now when they come out, there's some person, rightly or wrongly, according to his natural, that's why he is making false claim. But then he says, okay, fine. He said, no, you have not given me this, suppose, say, given this, or you have not done this, you have not done this, a dispute arises. Assume that is them a genuine dispute. We are not talking of this, according to him, is a fraudulent dispute. Let us assume that can there be a genuine dispute also in the time of execution of the agreement? Is it possible?
Execution of the terms and conditions.
Yes, of the agreement.
My lord,
Agreement.
yes.
Can there be also, is it possible that there can be a dispute relating to the execution of the agreement? Is it possible?
If we just confine to ourselves, my lord, what he's alleging.
No. I'm just a certain
then
question.
things would be simple, my lord.
So suppose there is a genuine disagreement on the agreed, because you take a different interpretation of that agreement.
My lord.
He takes a different interpretation of the agreement, though it was all agreed.
My lord.
Then when they come out of the room, then he starts saying, he said, no, this agreement means this. And he said, no, this agreement means this. So there is a dispute, for example. In that case, how the dispute will be resolved? You want to say that?
He's not saying that, though he's alleging that I've illegally taken the vehicle, but he makes the admission in the petition itself that on the basis of that deed of retirement, the vehicles were given to me. And I have already taken your lordship to the schedule, my lord, that the vehicles are indeed given to me, and clause number 4 is clear. And that's what the Supreme Court is saying. And when the clauses are clear, it does not preclude the powers of the Honorable High Court in deciding the non-arbitrability or arbitrability of the dispute agitated before your lordships. That is my argument, my lord. That is, so if your lordship would, if we confine to what he is alleging, then things would become very simple, my lord. So I was taking your lordship to the fact that he had filed an FIR, my lord, alleging that we have illegally taken the vehicles. And that FIR, my lord, ended up in FR, in final report. He filed an objection to that final report, and that FIR was accepted by the learned magistrate. On the strength of that FIR, he had also got the vehicles blacklisted. And then we came to the Honorable Guwahati High Court by filing 2 writ petitions, my lord. And those writ petitions were decided in our favor, my lord. To that order, I was trying to take your lordship, that additional affidavit. Page number 13 of that additional affidavit.
See, the problem is that here I don't know why these numbers were deleted. Erased and the new numbers have been given. That's why I'm having problem. Additional
Maybe because your lordship, new rule has come that the seriatim has to be maintained from the petition itself.
But you are not maintaining. Only the court will maintain. You don't maintain.
My lord, that has happened because we couldn't do the follow-up, maybe. That is our fault. We accept it, my lord.
Because we have a registry to do that. You don't have a registry.
We also have
You have your personal registry.
Yes.
You may call it by some name.
This rule was applied only few days ago.
Few days ago.
That is the problem. When we filed this application, that rule was not there.
Because see, I don't know why they have also erased it. That's why I'm difficulty getting the. Therefore, it will be annexure.
Annexure 1, my lord.
Annexure 1. That is annexure 1.
My lord.
Annexure 1 is Sitaram Mishra.
Yes.
No, that was?
Yes, my lord.
6672.
6672. This was a common order passed in respect of 3 writ petitions, my lord.
Here is page 300. And then, yes, this is the order
of this Honorable Guwahati High Court. The order dated is 16/8/2022.
What was the final order passed?
Yeah, yes, that's part, the operative part.
Yes.
Number 60, paragraph number 16, my lord.
16.
Yes.
The basis for blacklisting,
Yes.
which is a subject matter of adjudication, is the complaint by the registered owner. Who is the registered owner?
My lord.
He's the one.
Yes.
He's a registered owner. He's supposed to give it to you,
Yes.
but he has not transferred the ownership.
Yes, my.
But you are using by virtue of this agreement.
Yes, my.
So he said you are fraudulently using.
Yes. But the
That is the crux of the case, Lordship. They are.
You are indeed not.
We are,
You,
no, Lordship.
your acts, is really,
No,
really.
Lordship, that, no,
Ah.
Lordship, that is,
Justice does justice to your name also.
no, Lordship, that is, no, Lordship, the fact is not like this,
Now
Lordship.
let us see anyway, the basis of blacklisting of 6 numbers of vehicle which is a subject matter education, the complaint by registered owner supported by lodging of FIR so and so, though the request for blacklisting was done, that the fact of culmination of the police case submission so and so was intentionally suppressed. This fact was only noticed by this court while adjudication, which was initiated by the present respondent against communication by DTO and attempt to reconcile. So on record orders by the final person except there is nothing on record that view the matter. But one thing, Mr. Mukil,
Yes.
why this arbitration act was enacted?
My lord.
So that the court is relieve all this burden of deciding these cases, so arbitrator will decide.
My lord. That is there. The intake.
See that you have quoted this judgment. Vidraj earlier always says that it's okay, but that does not preclude the court from examining.
My lord.
We can do, we don't, but the problem we don't have time. So if the arbitrator can also decide, why can't the arbitrator decide? Then you say everything.
My lord.
I'm just
Yes,
loud thinking. I'm not saying
Yes, yes. Your lordship,
See, we are not saying that you are what you saying is correct also. But then yes, this court also can.
Yes.
You can say that please, this court, please don't hesitate to do that. Please go ahead. I said, fine, I am not averse to doing that. But then see, we have to go all these things which can be done also by the arbitrator.
My lord.
See, there are 2 options, no? It gives the option to this court.
My lord.
Okay?
My lord.
For example, say dead wood, say hopelessly time barred.
My lord.
Then court says, no, don't refer to arbitrator. Why you're wasting your time? Why should you waste the time of the arbitrator by referring a matter which is non-maintainable at all? One can understand.
My lord.
But here, so let the arbitrator decide these are this. What do you say about it?
My lord, my submission would be if your lordship allows me to only submit this part, my lord. But what I'm trying to take your lordship. Thereafter, if your lordship finds that there is some difference or some dispute, then my lord, your lordship can. And one point I would like to place another judgment, my lord, of the Honorable Supreme Court, which covers this aspect. Here, if your lordship would see that clause number 15 of the deed of partnership, it says that first they will try to mutually resolve the issue, and thereafter, if that does not happen, then arbitration. So there was a mutual settlement. And in pursuance to the mutual settlement, the deed of retirement was made. And the deed of retirement was put to challenge in the title suit. That has also ended because he has withdrawn it, and no liberty is now given to him to agitate upon it. That thing has attained finality. So the deed of retirement is binding. So when there is a mutual settlement,
This deed of retirement was executed after the agreement was signed, no?
yes,
Isn't it?
after the resolution. After
So
the resolution
just
was
I will get back again, no?
Yes,
So just again from your partnership deed executed on
partnership
5th of March, something like that.
5th of March, 5th of February 2015.
5th of February
15.
2015. Now this deed was that contains clause 15 contains arbitration clause.
Yes.
Okay. Clause 15 arbitration clause. Then as per this partnership deed, it was dissolved. It was dissolved, no?
There was a resolution taken.
Resolution, huh?
Yes.
Resolution.
26/7/2020.
Resolution taken on
26/7/2020.
26/7
July
2016.
2020. Man.
2020.
My lord.
That is found to be at page number the resolution at page 34.
My lords.
Page 34.
My lord.
That is resolution on 26/7. In terms of this resolution, the deed of retirement was executed. Huh?
Yes, ma'am.
deed of retirement executed on
3/8/2020, 3rd of
3/8/20
2020.
2020. Page number. There is page number.
He has also annexed it and
There
we
is
have
page number, let us,
36.
huh?
Page number 36 to 46.
36 to 46.
Annexure B, my lord, of our affidavit.
Page 36 to 46. Now, after the deed of say retirement was executed on 3/8/2020, suppose if there is a, according to there is no dispute
Yes,
after deed of retirement was executed,
my lord.
what are the terms of deed of retirement? That so and so will give all those amount? No.
Yes, yes.
Huh? He'll
Clause
pay.
number 4, my lord.
Huh?
Clause number,
Here, Lordship, one thing is missing, Lordship.
clause number 4,
Clause number 4,
page number 39, my lord.
number 39. Yes.
And there is no retirement, there is no agreement.
This. So the alleged dispute is only related to clause number 4 or what? No.
No, my lord.
17.
Clause number 7 also, Lordship, can.
17.
17, my lord.
The continuing partners agree to pay all debts and liabilities of said firm from today and to indemnify, keep the indemnified the retiring partner against all debts and liabilities and all loss for so and so, so and so. In fact, you are the aggrieved person.
Yes,
You are the aggrieved person.
yes, my lord.
You are the aggrieved person.
Because he's making false allegations.
Ah.
No, Lordship, here.
No. Paragraph 4, because you said, no, he has not paid anything. See,
No,
continuing partner is he.
my lord,
Yes, Lordship.
this.
He is Natwarlal and the company, he is the continuing partner, isn't it?
Lordship.
Isn't it?
My lord,
So he is the continuing partner.
my lord.
So he has to pay all the debts and liabilities of the said firm
Lordship.
from today and to indemnify and keep indemnify the retiring partners
My lord,
against all such debts and liabilities and all loss so and so, so and so.
my lord.
Then after that, after doing full essential evidence comes out and amount will be divided equally.
Lordship, kindly go to page.
Yeah, no,
Seven
no,
also.
just a minute.
7 also, up to.
After that, after equally distribution of the capital, everyone gets an amount of so and so, but the partners agree to receive round figure of 70 lakhs
Here we are,
each.
for this, we have, where we are, after taking over the farm, they were the managing partner till 2020. We have not got this
That
70
is
lakhs.
not the
Lordship. For
question
this,
here, my lord.
we are the agreed person, Lordship. Yes, for that we have filed that.
Okay, we will hear. Yes, yes.
Yes, my lord. Why, your lordship, why had taken your lordship to clause number 4? Because his allegation is that we are not paying the loan amount and we are using the vehicles unauthorized. So this clause is clear that who is supposed to pay the loan
Lordship, that,
on retirement?
Lordship, that,
He, my lord, the continuing partners. And regarding the vehicles, he's saying unauthorizedly.
He has not cleared that
Loan he
vehicle.
has paid. Loan he has paid. I can show, my lord.
The loan he has paid.
Paid.
So there is no
Later.
outstanding.
No, my lord.
at present, Lordship.
So
Regarding those vehicles.
legally those vehicles.
That is the dispute here in the arbitration. The vehicles, nothing else.
So the dispute is about the
These vehicles only,
about these vehicles.
my lord.
Why cannot arbitrator decide it? Ki, no, you have paid and finish it off. I don't know why you are asking this court to decide this.
Because the,
That dispute is there. Therefore, there is a dispute.
my lord,
So ultimately, you are also saying that there is a dispute about this non-payment. He did not pay or he did not.
no, my submission is, my lord, if your lordship would see his allegation and the clause, it is clear, my lord. That is why I'm saying that there is no dispute which can be referred to arbitration, my lord. And moreover, that arbitration clause cannot get attracted here. Reason being, in pursuance to clause number 15, which says that first they will mutually settle the dispute.
Second question this court would like to ask. Is there anything you have to pay or he has to pay right now?
We are not supposed to pay. We are to receive.
We are receiving.
You have to receive. Then don't receive it then.
So we are.
We'll close this arbitration. We'll not say, then don't give anything, then you have to file a suit.
My lord, we'll take action that is.
No, we cannot file suit, Lordship. We are
We will.
against that
No, no,
part.
he-
He will.
I need not.
But
give
he
permission
need the-
from
okay.
my lord to file a
Okay.
suit. My cause survives, I'll file, my lord. If my cause survives, I'll file, my lord. That is by devolution of law, my lord. I need not take permission from him, my lord. So there is no dispute that which can be referred to arbitration, and this arbitration clause cannot come in view of the fact that there was a mutual settlement, and in pursuant to that mutual settlement, a different contract was made. And Zenith Drugs case is clear on this point, if your lordship would.
That is what I was going to ask. See, if there is a dispute arising out of execution of an agreement, can you still cling on to the earlier arbitration? So that is what we are asking this.
No.
You have to argue, if I'm not saying that, I may be also wrong. We are all students of law. Just because we are sitting here doesn't become, we have become masters. You may be master, in fact. We are, no, that's how law is, So we are also in the process of learning every day.
Young, my lord.
Yes. So what we are checking is, yes, there was an arbitration clause 15 as per the partnership deed.
My lord.
So that partnership deed once dissolved,
My lord.
that terms also go. But then,
It was not dissolved.
no, just asking, I am not talking about this case. Suppose let us assume that there is a partnership deed and it contains certain arbitration clause. Now it is dissolved, for example, or a dispute arises and dissolved, and the dissolution deed is executed. But in that dissolution deed, there is no arbitration clause, for example. Then, if a dispute arises out of that dissolution deed, can you say that no, since arbitration, this dissolution is traceable to the arbitration, deed of arbitration, because this dissolution deed is a byproduct or a consequence of that, is a continuation of the arbitration in whatever negative form maybe or whatever. Therefore, that arbitration clause will survive. So one can invoke that. That is what actually you are saying.
Yes.
You are saying that, number one, though there was an arbitration partnership form, so it was mutually agreed that it should be closed, resolved, closed. In fact, the partnership doesn't exist as far as you are concerned. You want to get out of it. So there was a mutual agreement. On the basis of the mutual agreement, a deed of retirement was executed. Now, right or wrong, suddenly a dispute arises. He says, he being Natorlal, he says, no, there is a dispute about this retirement deed. Though retirement deed does not contain any arbitration clause, because this retirement deed is traceable to the deed of arbitration, which contains a arbitration clause, so therefore it is arbitrable. Otherwise, there is no arbitration clause in the deed of.
No. There's no.
Isn't it?
Yes.
You are trying to cling to that first origin.
Lordship.
Yes,
Lordship.
Because everything started with the deed of partnership.
Yes, there is a reference also in the deed of retirement.
The reference, therefore, you are stretching back.
Yes, Lordship. As per that is his case.
So that is, if I have understood, if that is so, how do you disconnect? You have to show that though the initial deed of partnership contained arbitration agreement, the moment that arbitration does not exist anymore, partnership does not exist anymore, a new agreement has come into place, either dissolution or retirement, whatever you may nomenclate. Then now it does not contain any arbitration clause. Therefore, if there is a dispute or no dispute, it's not arbitrable. Your case is there is no dispute. He says dispute. You say there is no dispute. He says dispute. So there is a dispute about this also. Then in that case, in that case, can I say that there is also dispute as to whether there is a dispute or not dispute? That itself is a dispute.
That your lordship can decide in section 11.
Lordship, may I say? Lordship, may I say? Lordship, once.
Your lordship.
Yes.
Yes. I would like to place this judgment of Zenith Drug, my lord.
The relevant paragraph.
Regarding
We'll hear you, Mr. Don't worry, I am not going to.
Paragraph 15 and
We'll
16.
hear you.
Paragraph 15 and 16. As your lordship was raising this question, my lord.
What is the item number we are going through? Item number?
7.
Item number, how many cases are listed?
This will take time, my lord.
Same. That's what I was thinking, because everybody is sitting
Lordship,
behind and eagerly thinking when this Natwarlal's case will be over, so that they will have an opportunity to. No, it's very interesting case otherwise also.
Your lordship,
It's always interesting where Natwarlal is there, it will be always interesting. There will be a box office, no?
Lordship.
No, but this para number, Janit,
para 15 and 16.
they are 15 and 16.
Observing that filing application under section 8 of the act should relate to the arbitration agreement or to be applicable to the dispute. In Yogi Agarwal versus Inspiration Clothes and You, it was held as under. When a defendant invokes section 8 of the act by alleging existence of an arbitration agreement, it should establish that such arbitration agreement relate to or is applicable to the suit transaction oblique contract. The parties may enter into different contracts at different points of time or may enter into a series of unrelated transactions. It is possible that in regard to some, they may provide for arbitration, in regards to others may not provide for arbitration. Obviously, the existence of an arbitration agreement with reference to some other transaction contract to which the plaintiff was or is a party unconnected with the transaction or contracts to which a suit relates cannot be considered as existence of an arbitration
So you
agreement.
cannot link up. There must be, according to this,
Yes.
that,
cannot
that any dispute must be specifically referable to the arbitration clause.
Exactly.
If there is arbitration clause is there, fine, not there, then doesn't matter.
Because parties are free to enter into different sorts.
I have given another.
May I just add one more point?
No, we'll hear you, we'll hear you. So you are saying something that today you said some more time. That's what we are also thinking. I thought
Lordship, here, Lordship, I may just say one.
you said 10 minutes. See, your 10 minutes, we know now.
His 10 minutes was the fire.
Fire.
Strike. Rest, my lord, is-
So whatever you submit, it has to be, considered with a pinch of salt, not about you as a lawyer, but your.
Just 4 minutes,
Yeah,
Lordship, now.
yeah.
Now, Lordship, here, Lordship,
Yeah.
regarding the vehicles, I want to just.
No, we'll hear, we'll hear.
Lordship,
That's what,
regarding vehicles, Lordship,
it's already 3 o'clock, that's why I'm wondering. We'll hear.
Malad, may fix up a date on a hearing date, Malad.
On a hearing day, yes. Hearing will continue on which day?
Any date convenient for Malad.
But here, Lordship, I just one thing.
Hearing will continue at a hearing day.
Part heard.
Next week.
Next week, I don't know, whatever.
Any date, Malad,
convenient.
convenient to Malad.
Any date, whenever the.
At your
date comes,
disposal.
Lordship.
Whenever the date comes.
Hearing day.
14 February? Okay.
No, it's
14 February.
Lordship,
Yes, now tell us.
tell you regarding vehicles, Lordship, 2 minutes, only 2 minutes, Lordship. Here, Lordship, the vehicle is in my name, Eastern Cargo Movers.
Yes,
Here, yes, we are admitting that we have given the vehicles to them,
yes.
but we have not allowed them to use it. By using the vehicles, they have illegally using it because by transporting the vehicles in my name in the road, it's a very illegal thing they are doing because they cannot use it in the road.
So what you have to say, Learned Counsel, is that, see, yes, they have been given this vehicle to them.
Look, yes, Lordship.
They have been given.
Lordship.
They are now the owner.
No, oh yeah, I being the owner.
No. You are no more the owner. If you give, how can you be owner?
How is the owner, Malad?
What your case is that these vehicles,
Are
which are
given.
in the name of this firm,
Lordship.
have been given to them.
But not.
Therefore, they cannot use this farm name anymore in their vehicle.
Lordship.
In the Tata, although in the back side also many things are written.
Lordship.
All this bye, all this, all kind of things.
No.
No horn and whatever, then so many things are also written. But on the side,
Lordship.
you cannot write these movers.
Lordship.
According to you, they are still using movers. And when these drivers carry goods, they always issue bill and all those in movers' name,
Lordship.
which they cannot do. That is okay.
Yes, Lord.
Therefore, there is a dispute.
Lordship, another thing, Lordship, at the time when this was delivered, the vehicles could not have been transferred because it was under hypothecation, Lordship.
Correct. So
But they-
according to you, there is a dispute.
Yes, they are
Now,
supposed
this dispute is traceable to which agreement, which contract?
a 2015 contract.
Now they are saying no.
No,
They are saying that your contract is the deed of
Retirement.
retirement. That is the contract.
That
That has gone.
That's
That
gone.
has been gone.
Yeah.
That deed of according to them.
according to them.
Huh.
But here,
According to
Lordship,
them, according to them,
I have cited
that
another.
deed of partnership is gone. That buried.
Lordship, I have cited-
Rest RIP.
Lordship,
Now the new one is deed of retirement.
Lordship,
That is what they are trying to.
they are trying to say.
Yes.
Here, Lordship, I am
And
relying.
you said, no, let him not rest in peace. He still has resurrected.
I'm relying on the section 7 of clause 5. 7 clause 5 of arbitration clause, and that is
My lord, we are deeply obliged, my lord.
Yes, we'll hear again. 7 clause.
clause 7.
Okay,
Section 7
fine.
clause 5.
Reference in a contract to a document containing an arbitration clause constitute an arbitration agreement if the
I
contract
have
is
cited
writing
another agreement.
and the
Judgment
reference is as such to make that arbitration clause. Anyway, we'll see that 7.5.
Lordship,
Will 75?
Yes, my lord.
It is 75 or so 70. He's trying to put this color. What is your interpretation of 7.5? We would like to know from you also.
Lordship, I have given a covered judgment also.
Covered judgment.
Yes, Lordship, just now, in the first instance, Lordship.
Which one is that?
Whether it is covered or not, that we'll see on the next day. But he has given a.
Covered.
So that is the point number. Clause
Kerala
10.
High Court. Kerala High Court.
Yes, Lordship. Clause 10, Lordship.
You have found out from. This one is from.
This constitutes an arbitration.
Google.
Lordship.
You see, you can Kerala High Court. You give some respect to Kerala High Court also.
No, Lordship.
Get some SCC online, something like Kerala. You are from Google is for everybody. Huh?
These are not authorities in fact, my lord.
Some Google.
Lordship, today actually hurriedly lost. I lost some earlier days. I prepared with the judgment, Lordship, from the SCC online also. This was reply. This was reported in SCC online also.
Please cite a little better because see, Google is a big mess. You don't know Google. Everybody can post anything.
No,
Google.
Lordship, then also that is reliable, Lordship. No, okay, I will place clause number 10, Lordship.
Okay. Clause number 10 now?
That judgment, Lordship, I put it.
Acha, clause number 10.
To constitute an arbitration agreement, the requirement is an agreement by the parties to submit to arbitration all or certain disputes which have arisen or which may arise between them in respect of a defined legal relationship, whether contractual or not. The arbitration agreement could be incorporated as an arbitration clause in contract. It could even be in the form of a separate agreement. Subsection 3 of section 7 stipulates that an arbitration agreement shall be in writing. It does not insist that it should be in any particular form. Subsection 4 of section 7 provides that an arbitration agreement is in writing if it is contained any documents mentioned in clause A to C therein. Subsection 5, section 7 provides that for situation where there is a reference in a contract to a document containing an arbitration clause. Here, Lordship, here the retirement deed, there is a reference to
the deed of partnership.
Specific reference, Lordship.
Anyway.
My case is that regarding facts, Lordship, I am the agree because there is supposed to be 2 crore rupees, 2 crore 75 rupees in the accounts. That was not there. They are managing the firm till 2020. And I am only the partner. That fund was supposed to be there in the company, Lordship. That was not there. For that, I filed that.
Okay.
I'm also agree in some way, Lordship.
Among in the Indian households, the youngest is the most spoiled also, no? No, huh? Because he's the most pampered. Most pampered. Youngest is the
About
most pampered.
10. One girl, 9.
The good part is, my lord,
9 sons.
father labeled him on the day he was born. Never
Obliged, my lord. Deeply obliged, my lord.
For orders, item 10.
Highly obliged, Lordship.
Obliged.
Item number 10.
Service is not complete, my lord.
Not complete. Okay. Release chapter so and so. You have to take step or what? No.
Let's wait, my lord, next time if you.
Okay. Await service report in respect of respondent number. Respondent number?
My lord, respondent number. Seven, my lord.
Okay. Item number next 11. Review. What is this? Anis Alam Khan. What review?
Because this pertains to a provincialization of a science teacher in a high school. Milords, but today I'm seeking an adjournment on behalf of my senior, Mr. Sharma.
Okay. Under prayer of Lani Council. Yes, yes, next.
After 2 weeks.
Obligement.
Item 12.
Contempt.
May I please, Honorable Court, my lord, in this matter, my friend will be appearing. My friend has been brought from Delhi by my
Oh.
petitioner.
Okay, very well.
So I lead, my friend will act.
What is the order passed by the court?
That is.
What is the direction? Direction is
That is at the relevant portion is at page 157, Your Lordship.
157?
Yeah.
What
Of
you are
the
talking?
Contempt petition.
157?
Second.
Pagination, I'll assist my lord.
Yes, my lord, it is the orders.
157.
157.
Go to 150.
Okay, what is this? Just a minute. Noors Ali, what is this?
It is starts from
Well,
page 155, Your Lordship.
13. Okay, sorry, just a minute.
Something else is before my lord.
Page 154.
It is starts from page 154.
15. And what is the direction?
The relevant portion is as page 157.
Yes, I am inclined to stay the operation.
The second, the bottom at page 157. In the second para, it is starts that the petitioner shall go ahead with the fresh tender process without applying the risk and cost liability on the respondent contractor till the disposal of the connected appeal. Appeal is still pending. That is FAO 27 of 2020.
FAO, first appeal.
Yes, which is still pending, and that only this interim order has been passed by this honorable court. And the same shall be considered at the time of disposal of the appeal. The second portion, the bottom of this one is the necessary formalities before handing over the site to the prospective fresh contractor/contractor shall be maintained by the petitioners as per the terms and conditions of contract entered into by the petitioner and the respondent contractor. I came before your lordship, the respondent has not complied with that portion of the interim order of 30th of September 2020. They, along with their counter, they have only filed, kindly see page 31.
Yes.
Page 31, this is basically work progress report. Even the date is not mentioned there.
So anyway, you say they have not complied.
Yes.
Why we have not complied? What is the problem?
My lord, before going into, he has said about the second part of the order. Before going into, I'd have to give a brief description.
No, whether you have complied.
In the order, my lord, first, but I have to give the.
We have not complied, but we have not violated. Is it your case?
There is no.
Have you complied with this or not?
There is no case of compliance.
Why?
There is no violation.
No, we'll forget that violation or non-violation. We'll see later on. Court had given a direction. You do this, do A, do B.
There is no direction. First of all.
What is this?
Yes,
Just a minute. I am inclined to stay the operation of the impugn order dated pass in so and so, so and so, so and so. And the petitioner shall go ahead with fresh tender. Who is the petitioner?
I am the petitioner.
Have you gone ahead with the fresh tender?
Yes, my lord. Yes.
You have gone ahead. Very well. Number one. Without applying the risk and cost ability,
Yes, I have not
you have not applied.
Yes.
On the respondent till the disposal of the connected. And the same shall be considered at a time of disposal. When you go ahead means what? What is the meaning of go ahead?
Which one, my lord?
No, that shall go ahead the fresh.
Fresh tender process.
So you have go, when
I
did
have
you,
issued tender.
when did you issue the tender?
Long back that, but my lord, I have submitted the tenders also.
No, just the idea, just not the exact date. Which year? This order was passed when?
My lord.
In September.
September
2020.
This order was passed on 30 September 2020. Now go ahead. You said you have gone ahead.
Yes, my lord.
But just going or you will not go, reach anywhere or just keep on going over. When you go ahead, you have to reach a destination. When you go ahead a tender, you float a tender, then you invite tenders, bidders, then you hold a, consider that, then you decide.
Yes.
Now it will be given.
Yes, my lord.
What is the stage now of that tender
Tender
process?
has been given
To whom?
to it.
Some other.
Yes, to third parties.
Third party. Okay,
Into
very well.
3 packages, my
Okay.
lord. And out of 9 BOPs, border outposts, 6 has been handed over to
border security force, and
Okay.
rest 3 of the BOPs, border outposts, are, we are in the process of handing over.
Okay, very well. Now that then necessary formalities before handing over the site
Yes,
to prospective fresh contractors shall be maintained by the petitioner as per terms and conditions. That you also have maintained.
that before that, my lord has to see order dated 17.
Now, who are you? Who is he?
I am
Who are you?
Earlier contractor, your lord.
You are a contractor.
Yes.
earlier
So,
contractor.
earlier contractor.
Yes.
Now,
My material was there at the site. My plant was there. My machinery was there. They have not done, they have not given me the entire list. They have not done the joint measurement even before giving the taking over to the other contractors.
but where is the order? But there is no such order that
Yes,
no.
kindly see, there are 2 portions of this order, your lordship.
Yes,
The
yes.
first,
If you
only
go
they
ahead
have
and- Yes,
the genesis of this order is with the title suit filed before the district court in Kamrup district court. They have stayed the tendering process to any third party. They came before this honorable court in FAO 27 of 2020, challenging that order, interim order of stay of the subsequent bidding process, in which by disposing of that application, this order has been passed. There are 2 portions of this order. The first
is
they
to
have
go ahead the
stay-
tender.
They have, go ahead with the tender, but with the condition. The condition is mentioned in the last portion of this order.
What is that?
The necessary formalities before handing over the site to the prospective fresh contractor shall be maintained by the petitioner.
What is the necessary formalities?
They have to prepare the joint measurement sheet. They have to give me the entire list of plant and machinery which is at site at that time. They have suddenly terminated me during the currency of the contract. They have not done all these things. They have misappropriated my plant and machinery and the materials before present at the site.
And they handed over the site to the
Yes, the other
new-
contractors, they
Oh.
are giving now submission. They have already completed their work by using my materials, my plant and machinery. That is a non-compliant.
Yes, Mr. What is this? The heavy,
Yes,
what
my
is the
lord,
necessary
my-
formalities which you have
My lord, that
accomplished?
my lord, before that, the order dated 17/2/2022 passed
Yeah.
by Justice Suman Shyam.
Oh, don't name judge's name here. Bring
My
down.
lord, just, yes, I am not naming.
Because I don't know any judge's name.
My
If you
apologies.
mention the name, I won't recognize. Yes, page number.
My lord,
Page
that is
number.
there in the order sheet. Order
Page
sheet.
number. There are so many orders, 100 pages. There are 100 pages, not 100 pages, about 1,000 pages. You have to give me the page number. I can't find out by showing the name of the judge. I have to go to website. What is this order? From why you're putting, you're from your pocket, you are,
It is of this.
is
petition
it part of this pleading? I don't know.
My lord, it is not part of pleading.
Then
it is-
you are behaving
not
like
aware
PC
yet.
Sarkar. PC Sarkar
My
does,
lord-
he just takes out a bird from his pocket. Sometimes he
it
brings out a hat.
My lord, it is the order of contempt case only, this present contempt case.
You say that, when present contempt case, when it was order passed, which date?
Into,
You say that,
yes, my lord.
17/2/2022. In this contempt, 17/2/20, yes.
Yes.
Now, what do you want? Yes, you take it back because
Yes.
it is the original with it. You are
Yes.
giving a duplicate copy.
Yes,
The original is with us.
yes, my lord.
Yes, what do you want to say?
Okay.
So and so, so and so, so and so. In order to consider submission advanced by the petitioner's counsel, I have perused the order dated passed by the court in IA number. Just let us see what is that.
That is the order, lordship,
Just give a time. Okay, you got
at page 157.
157. This is IA 1346. Okay. I have perused the order dated so and so, find that there is no direction from the court in the manner in which the petitioner counsel is canvassing the case. According to Mr. Kaushal, the respondent have handed over the site to the new contractor without carrying out a measurement of the work done by his client and has been asked to deposit a sum of rupees crore to LD. What is LD?
Liquidated damages.
Liquidated damages.
Okay,
Your
okay.
Mm.
To you.
Yes.
Who has to? Who has to?
Lordship. They have served us notice.
You have to give 5 crore.
Yes.
While Mr. Swanswamy is just arguing that recourse taken by department is illegal and contrary to the spirit of the Swan, yet I find there is no specific restraint order from the court on such count, and therefore it is doubtful as to whether a contempt petition on the ground is stated in a would at all maintain be designated as a unconstitutional matter stand adjourned after 4 weeks.
Yes, my lord.
So is it the final order?
It is not a final order, but
Your
he
Lordship.
has given an observation that there is no specific order that you do this, you do that.
No, correct.
Yes. my
No,
lord.
but then,
So where is the contempt, my lord?
Mr. When you say you go properly to the school,
Yes.
that means what? Number one, you will wear the uniform.
Yes.
Number one, you will, number two, you will wear the school, shoes, not a canvas shoes. If the school uniform rule says that you should wear a leather, you can't wear a chappal. Huh?
My lord.
Formality is what? You go formally to the school.
Yes, sir.
It doesn't mean that now you have to take a bath. Yes, you may not take a bath.
Yes.
No problem. But you must put on, even if you don't put on the hair oil also, you must comb the hair. Huh? Then you must wear the uniform. That's the formalities you have to do when you go to a school. You can go in your night suit. So the formalities has to be completed. There must be certain process you must undertake. That is what is the meaning of formality then?
My lord, I have called the petitioner. There is an admission from the petitioner side in page 14 of the petition itself, in paragraph 29. Page 14. Paragraph 29.
There 29. Page 14 of the contempt petition.
Yes, my lord. Paragraph 29.
There 29. There 29. Yes. Yes.
Yes, my lord.
Yes.
That by letter dated 23/2017, contract was terminated, though time for execution of contract was fixed on 35/2017.
Yes.
In such situation, the applicant plaintiff was not in a position to agree with the same. For this reason, though the applicant plaintiff was called upon for joint measurement, but the applicant plaintiff did not participate to the same as it would be detrimental.
So according to
their
you,
case.
he himself did not participate.
Yes, second time I have, my lord, thereafter, I go on with it.
However, no measurement carried out by the contract party is the only, therefore he doesn't come, so you'll do whatever you want.
Second time I have done.
Suppose a respondent does not appear ex parte, the court will pass any order, the
Just
rule.
5 minutes of indulgence to me.
Yes,
My
what is
lord,
that?
after that also I have invited them for joint measurement, and joint measurement has been done, my lord.
Done, okay.
Yes,
But is it on record?
they know very well.
Oh, mister, they may know, but I don't know this court. Again, we are saying, when you do a case, the record with the plea, because we are hearing, no.
They have filed a reply affidavit. Reply affidavit.
And what is this annexer, all these thick papers?
These
What
are
these
these are
thick-
the contract, basically.
Subsequent contract.
Huh?
Subsequent contracts to new contractors.
Why it is required in the
Because
contempt
there is-
petition?
There was an order by the learned court, by the honorable
Lords
court.
called for it.
Oh.
My lords
For
called
the-
for it.
There I have given those contracts, and I have given one affidavit also. There I have said that I have not imposed risk and cost on the petitioner.
So, they were only particular measure required to record was not furnished. However, no measurements carried out by the contracting authority, they were. Then now what then what was?
Second,
Yes.
Lord, thereafter I have issued another letter after this order and joint measurement, and joint measurement has been done. And the second order.
Where is it? Where is it?
It is in their reply affidavit.
Reply affidavit.
Yes.
Page number?
Annexer PR1, page number they have not put in my
PR1.
last page, reply affidavit.
PR1.
Yes.
Utpal Patwari. Engineering project. Yes. What is
This
this?
is the reply given by the petitioner.
Hmm.
Last page, my lord.
Yes. Yes, please read.
Yes, that joint measurement letter, my lord.
Joint measurement executive work along Indo-Bangladesh border,
Yes.
so and so.
Yes.
Yes, sir. Letter. What do you want to show? Please tell us.
I have invited them for joint measurement and the joint measurement has been done. Joint measurement has been submitted. There are other 3 writ petitions pending before this honorable court.
This is filed by who? This
This is filed by the petitioner of this content case.
by the petitioner.
Yes.
So, and why they have annexed this or this letter for 4/2/2021?
I have
Why have you annexed this?
Your lordship, after filing of this contempt petition only, they have issued this letter to come for joint measurement. Joint measurement was a farce exercise done by the respondent. That is why they are not filing the entire record before this honorable court. They have not done the joint measurement as per the contractual provision, but they have just put out some lines and they forced us to sign on the same.
Forced you?
Yes.
Forced you?
You
are a juvenile or what?
Yes, under protest. Under protest, we have signed on the joint measurement.
How
side
can they
because-
force you?
Because the materials present, they were not included in that joint measurement, as well as we have also done earth excavation work there. That was not.
No, you are
in the
using a
joint
very
measurement
dangerous
sheet.
word. You have been forced. On what?
Use the word of few items, not.
Kindly see, they have terminated my contract in 2017. Thereafter, they are in the possession of all those sites. And in 2021, only after 4 years, they have called me to sign this one. And
Did you go after this, on the basis of this? Did you go?
yes, I have approached them.
And then
for
what
this.
happened? Then what happened?
Because they have not prepared the joint measurement sheet as per the terms and conditions of the contract. That is why we have signed under protest.
Where is it?
on
Where
that
is it?
letter.
Where is
They
it?
have not produced it before. That was done on 21st of February 2021.
You don't have a copy
Subsequent
of
to
that.
this.
You don't have
I
a
have
copy.
only one seat, your lordship, but that not attached the, I have only one seat of this
But
letter,
it is not in this.
but that
before
is
this.
not
Correct.
enclosed with the
Sir,
measurement sheet,
now
your lordship.
what I am now feeling
Yes.
is that you are relying on documents which is not part of the record
Yes,
before us. Why don't you place it and give a gist and a brief note?
okay. I
That
will
will be
file.
better.
I will file your.
And file those documents which you are relying.
Okay.
I request you to also.
Yes,
So
my lord.
all
Yes,
those,
my lord.
documents for that. And you said this is my case. 1, 2, 3, 4.
Yes, my
Page
lord.
number.
Yes, yes.
Because see, I am little bit frightened with this big volume.
Yes, my lord.
No,
I
your lordship.
get easily
The
frightened.
issue is very
I am a
limited.
very scary person. I am not very bold. When I get see these voluminous, then I get, my heart start pumping.
Yes, my lord.
So you
Beg to
please.
differ with my lordship. Lordship is one of the most bold lawyers, judges.
So kindly prepare a small brief note and this page number, this is what you are relying. You see,
And
My
the
lord, I have
relevant
filed- I
records may
filed the
also
joint
be
measurement
filed.
sheet also.
what? Yes, please do that.
Yes.
Please, you have to do what, because you are the contempt. You are
Yes.
being, proceeded against.
Yes.
Therefore, you have to show that no, I have done. And this is what I did.
My lord,
Therefore, nothing remains.
this order has been passed in such a prudent way by this honorable court only. I am not naming the judges. My lord, it is stated that I am satisfied that completion of the construction of border outpost is of vital importance to the security of
No
the
problem, there
country.
is no issue on that.
So, my lord,
Yeah.
it would not attract contempt under section 13(2).
What is 13(2)?
13(2) states,
Yes, yes.
notwithstanding anything contained in any law for the time being in force, I'm going to.
Yes, yes, yes.
The court may permit in any proceeding for contempt of court justification by truth as a valid defense if it is satisfied that it is a public interest.
Yes.
So protecting the boundaries of the country.
No, that is no problem, but
Yes.
it doesn't mean that you will take his property.
No,
That you do that.
he can agitate it in a civil court.
No, but correct. But then if there is said modalities,
Hmm.
perform the modality, as I say, you go to school after observing the modalities, then you have to go to school in a uniform. That is what I understand,
Yes.
subject to correction.
Yes.
So what is the modalities required to be undertaken, fulfilled? That you should fulfill. Merely because the court has says modalities, therefore I will not do this, I will not, these are all subject of, see, there is an issue to be considered. Anyway, parties are directed to prepare, parties are, or should I don't think we need to write all these orders.
Yes, my lord.
No, I
At least 4 weeks time.
4 weeks time, in a man. Because if I direct, that means the lawyers don't know what to do.
Yeah.
That's not good. Because as per High Court rules also, at the time of hearing, you are supposed to prepare a brief note, isn't it? No?
Yes.
So we don't want to say that. Please do it. Huh? Okay.
I will do it.
Please accept so that party will prepare the necessary, file the necessary documents. Document that's
Yes,
good enough.
yes, yes.
Necessary documents
Mm.
to be relied on at a time of hearing.
Yes.
Yes, please.
Item 13.
My lord, for my friend's convenience, a fixed date maybe.
Yes, kindly take any date, whatever. Any date, whatever you want.
In March.
2nd of March.
Okay.
2nd of March, my lord.
Obliged.
Deeply obliged, my lord.
Item 13.
Noor Sahir Ali, what is this?
The salary and the other dues of the petitioners was asked to be paid by this honorable court. Now, my lord, on the last occasion.
Gogoi submits that present petitioner has transferred, doesn't matter, transfer will keep going, but poor fellow will, so he'll run after all these officers, transfer after
But even
transfer.
then we have filed a new petition including the present.
What is
income.
this? Then what we have done while we are in service, you tell us, then we'll exempt you from further, we'll release you. When you were the secretary or whatever, what did you do? If you have done this, then yes, of course, then we'll discharge you. Then you will take over. But what did you do? You are appearing for whom?
I am appearing for the contemner, my lord.
Who condemn is? Give me the name of the contemner. Mr. Whom? There are so 2-3 people. I can see the name. You are appearing for whom? There is one Narayan Kaur. There is one D.K. Mili. There is one Manivaran. Whom you are appearing for?
I have telephonic instruction to appear on behalf of the newly implemented, my lord.
Who is the newly implemented?
This, my lord, Commissioner Secretary, my lord, and
who is the name? Tell me the name.
Narayan Kaur, Narayan
Kaur, my lord.
Huh?
Narayan Kaur, my lord.
So what does he say? Narayan Kaur
My
you say?
lord, I need some time, my lord, because actually this matter has been dealt by Mr. K. Gogoi, and he left the court, my lord, today due to some personal inconvenience, my lord.
And what is the direction of the court?
To pay the salary starting from November and all other.
Is he still serving?
Yes, madam. Salaries and other due. What happens if madam this?
We do not find even before provincialized. What is the direction?
Yes, ma'am.
Page number.
The order is from page 11 to 26.
Then the relevant.
Para 23.
Needless to say that a consumer relief entitled what will be given. Another. And you have not been receiving any salary till
Not
now.
a single penny.
What is this?
They have gone on appeal also against this order. There is no stay in the.
If you don't pay, what will happen to him?
He has retired.
He is retired also.
Retired. Now, this litigation started in 2011. By this time, he has completed LLB, retired, now joined the bar as a lawyer.
Bar.
Did not get a single penny. In 2001 it started, sorry, not 11, 2001.
Then we'll ask him to represent that council. Then he will ask him to charge 1 lakh rupees per appearance. Then
the litigation started in 2001.
What is this? What is this?
The first order of this honorable court was from 2001.
And you find out when you will comply.
Yes, that your lordship will kindly indicate.
Yes. How long will take? Will indicate that on least second on so and so on which date the respondent will indicate as to when the order of the court will be complied with.
Yes.
Time
limit was also given in the early order.
Yes, next.
14 to
Valentine's Day. Very nice.
item 14.
Yes. Item 14.
Please, Lord.
In this case, I am appearing for respondent number 1.
What is the direction of the court?
Lordship, it was directed to verify the claim of the petitioner, and if it is found okay, Lordship, then to proceed for payment of.
And then what is the problem?
Lordship, in the meantime, we have verified, Lordship.
And it is correct.
Lordship, out of the 3 contempt cases, 1 we have already done verification.
And
there
then
it has been found okay, Lordship. So
Then?
19. Now we are proceeding. This letter was-
contempt 19, we are considering contempt 19.
Yes, Lordship. And this
30,
letter was,
33 lakhs.
33 lakh 77,006.
So you
This
give.
this has been informed to me on 21st of January this month.
Very good.
So we are going to file an affidavit so far as the item 19 is concerned, Lordship. Lordship,
Other items also.
other two items are there, Lordship.
No, anyway, item 19, you have verified, then you correct amount.
Yes.
Then when you pay, when will you pay?
Lordship, may kindly see page 18, Lordship. Page 18.
In respect, you will go under, and if such exam verification is found entitled, then BC should process the claim of the in accordance with law and light. Yes, what does the law say?
It says, Lordship, the petitioner will be placed in a chronological order, Lordship, and whenever.
In Tamsher Ali.
Yes, Lordship.
Where is the Tamsher Ali case?
Tamsher Ali is not here, Lordship. That is the order, Lordship. in
Are you,
Lordship.
yes?
Yes, Lordship.
So he will be placed in that series, he will be put in some,
That is the order, Lordship.
It is the order,
Then?
Lordship. What can I do?
huh?
But let them file an affidavit and place on. the
Okay, let you file.
Lordship.
Fine, okay. Hard miss?
Yes, Lordship.
He does. Are also Mr. Naik, who filed this affidavit within?
3 weeks, Lordship.
Why you
Lordship,
think?
Lordship, I'm praying one because Lordship, even on that date on which the notice was issued, Lordship, I was not there. I have already been transferred out of that post, Lordship. Now somebody else is working in that post. He's the principal secretary, BTC, Lordship. So that is the typical for me.
Okay, 3 weeks, yes.
Lordship, in the meantime, Lordship, petitioner will implement the new.
Kindly pick the date, Lordship.
Date it, bata raha tha.
Lordship, in the meantime, petitioner will file an IA, Lordship, to implement the new incumbent. It will be easier for her, Lordship.
Okay, Lord.
In the meantime, the petitioner will implement a new incumbent to the post of?
This principal secretary,
Commissioner Secretary.
principal secretary, BTC.
Okay.
20th February. 22
March.
Yes,
March,
yes.
1st of March.
Next.
14, 15, 16, same.
Same. Oh, nice.
For hearing item 17.
Public Lordship.
Hearing, we have been waiting.
Yes,
What to be heard? Who will hear whom? Who is going to do the hearing? This court is going to hear. What do you want to say? Tell us.
Actually, I was thinking for Passover, for taking a Passover.
You want to pass over?
Yes.
Why?
Actually, the senior, he is not here.
Sina is not here. What is the matter about? Arbitration.
This is section 11 application. Lord.
So what is the problem?
I am saying that there is no arbitration agreement surviving as on date, Lord.
Why?
The facts of the case was that in 2010, an agreement was entered
Yes.
between the petitioner and Dr. Lal Pathlabs to
Yes.
open a sample collection center in Dibrugarh.
Yes.
Thereafter, on the very next day, a partnership agreement was entered between the petitioner and the sole respondent, saying that they will together operate the sample collection center.
Yes.
Then the sample collection center was, the agreement for operating the sample collection center was valid for 5 years.
Yes.
And the partnership agreement was contingent upon that. So after 5 years, the agreement of the sample collection center expired.
Yes.
And the sample collection center was closed down.
Yes.
So
The
resultantly,
dispute arises out of what?
I'm coming to the facts mode.
Yes.
So after the sample collection, that agreement was terminated.
Yes.
The partnership again naturally got terminated.
Yes.
So after 1.5 years thereafter, I opened another sample collection center in my individual capacity as a sole proprietorship, entering an agreement with Dr. Lal Pathlabs. So,
Another person.
no, for the respondent.
The same person.
I, the respondent, earlier was the partnership agreement. The new one is a sole proprietorship of mine, my individual capacity.
He knows nothing to do.
He's nothing to do. When he sees that my business is going well, so he now comes and says that he wants profit sharing with my sole proprietorship. He says that there is, since we had entered into a partnership, so there is a dispute, he wants profit sharing. But I say that partnership had expired in 2015 itself. Now he is coming in 2022 and saying that he wants profit sharing.
But that name of the partnership firm here same.
No, not same.
Different partnership. Okay. On the pair of Miss
MAOSS.
are also Mr.
S. Bishop.
Matter be listed again on front. Type it, please.
So what?